ಮೀಟಿಂಗ್ ಮಾಡ್ತಾರಲ್ಲ ಆ ಡೇಟಿಗೆ ಮತ್ತೊಂದು ಮೆಮೊ ಮುಂದುವರ್ತಾರೆ. ಒಂದು ಮೆಮೊ ಕೊಟ್ಮೇಲೆ 2 ದಿವಸ ಇಲ್ಲ 3 ದಿವಸ ವೆಯ್ಟ್ ಮಾಡಲ್ಲ. ಇನ್ನೇನೋ ಹಂಗೆ ಆಯ್ತು, ಯಾರೋ ಹೇಳ್ತಾರೆ ಸೂಚನೆ ಮಾಡೋದು 3 ದಿವಸ ಆದ್ಮೇಲೆ ಮತ್ತೊಂದು ಮೆಮೊ ಕೊಟ್ಟರು. 21 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ವೆಯ್ಟ್ ಮಾಡಿ ನಾನು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಆ ಡೇಟ್ ಬಿಡ್ತಾರೆ, ಮತ್ತೊಂದು ಡೇಟಿಗೆ ನೋಡ್ತಾರೆ.
ಸರ್ ಅವೆಲ್ಲ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್.
ಅಲ್ಲಿ ಮೆಮೊನೇ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್.
My lords, may I request, my lords? The courtal mic is muted, my lords.
ಯಾವ್ದು ನೀವು
ಹಲೋ
ನಿಮ್ ಸೇಮ್ ಮ್ಯಾಟ್ರಾ ಅಲ್ಲ? ಎಸ್.
List number 1, serial number 1, pronouncement of orders.
Preparing for the
Anuparna, board holding.
Consequently, the civil miscellaneous petition is accordingly dismissed.
Preliminary, serial number 2, Shilpa
My
Rani.
lords, I am appearing for the petitioner. Kindly pass over the matter, my lords. Serial number, please, my lords. I am proxy counsel, my lords. The advocate on record is her legs, my lords. Kindly pass over the matter, my lords.
Pass over.
Please, my lords.
Serial number 3, Chaitanya SG.
The petition in this matter. Lord, an agreement of sale, at least. An agreement of sale was entered between myself and respondent number 2 to 6, my lord, on 5/3/2022. Subsequently, my lords, with the intention to defraud me, the respondent number 2 to 6, along with other family members, as well as respondent number 1, have filed a partition suit, my lord. It is a collusive suit, my lord. They are trying for a compromise agreement. And having no other alternative, I have filed an application under Order 1, Rule 10, seeking to implead myself as a proposed defendant in this suit, my lord. Said application came to be dismissed, my lord, saying that I am just a mere agreement holder and I am not a purchaser.
Correct.
Purchaser, my lord. But it's a registered sale agreement, my lord. And the outcome of that partition suit will directly affect, my lord, and I have paid about 11,50,000 rupees, 50% of the amount I have paid, my lord.
To all the parties.
Yes, 2 to 6, my lord. 2 to 6 are the family members. Now, respondent number 1 is also claiming to be the family member, and she has filed a suit against all the other family members.
Yes.
And therefore, I have filed an application under Order 1, Rule 10, seeking for impleadment of parties.
Nothing wrong in the order.
My lord, but the outcome of,
You are not a necessary party to those proceedings and a partition suit.
yes, but my lord, this is a, there are,
Therefore, you will have to work out your remedies elsewhere, sir, not in this suit.
I have also filed a specific
notice to the
suit for specific performance.
You will have to work out there, not here.
My lord, stay may be granted.
Issue notice to the respondents. Yes.
My lord, an interim stay may be.
No.
Or Shashikumar. Or Shashikumar.
Challenging
Yes.
the compromise decree obtained by the respondents. Playing a fraud and misrepresentation. The petitioners have engaged entrusted some cases to the respondent number 2 and 3.
You are not a party to the suit.
We are the party to the suit.
Ah,
The respondent number 2 and 3 are the
that
advocates.
was compromised in
Yes.
Lokadala.
Yes, my lord.
Ah,
The respondents number 2 and 3 are the advocates, my lord.
Huh?
In the year 2020, the petitioners have entrusted 2 matters to the said advocates, my lord. In that matters, they have obtained some signatures on the papers and created the agreement to sell in favor of themselves in respect of the very same property which is in the dispute, my lord. One is a partition suit, another one is a revenue interest challenged by the adjacent landowner, my lord. After that, my lord, based on the said created agreement to sell, which is at annexure B, page number 31, my lord. Within a few days, they have issued a notice and filed a specific performance suit, my lord. In the suit also, my lord, they only
For
engaged the
agreed of what, sir?
Let-
For agreed of what? For
compromise
agreed of
decree, my lord.
annexure A?
Annexure A, my lord.
Huh?
Annexure A, my
You
lord.
are a party to the proceedings?
Yes, my lord.
Huh?
Subsequently, my lord, criminal case has been registered against the respondents, my lord.
Huh?
Uh, on 4th June 2024, my lord, dishonorable coordinate bench of dishonorable court quashed the said proceedings with liberty to establish the fraud before the competent court, my lord.
Hmm.
After the compromise decree obtained by the respondents, my lord, they have challenged the said compromise petition before the civil court in OS 434/21, my lord. That is came to be dismissed, my lord.
Huh?
On the that the suit came to be rejected under 7 Rule 11, my lord, on the ground that the suit is not maintainable since the decree is passed before the Lok Adalat, my lord.
Hmm.
Only writ petition is maintainable. That's why this petition is filed, my lord. Based on the compromise petition, my lord, fraudulent compromise petition, they filed an execution petition, my lord.
Hmm.
In the said execution petition, they have deposited some amount and the court commissioner has been appointed for execution of the sale deed. Whatever the amount stated in the compromise petition as well as the agreement, they have not paid even single rupee to the respondents.
Then why did you sign the document?
My lord, they have taken a petitioners to stating that, my lord, the suit number OS 497/2014 filed by the sister of the first petitioner, my lord, that has been settled. We have to come to court and we have to sign the compromise petition. Like that, they have taken the petitioners and obtained the signatures on the compromise petition, my lord.
Issue notice to the respondents. Yes.
My lord, they have
Number five.
my lord, sale deed execute ಮಾಡ್ಕೊಟ್ರೆ nothing will concern by. Sir, sale deed execute ಮಾಡಿದ್ರೆ ಏನು ಉಳಿಯಲ್ಲ ಸುಮ್ಮನೆ.
Yes.
Number five.
Petitioner is a plaintiff in the suit. He has challenged the order passed by the Learned Trial Court, imposing duty and penalty on agreement to sell, my lords. May kindly find, my lords, Annexure J is the agreement to sell between the parties.
Hmm.
The parties entered into an agreement. But in terms of this agreement, my lords, the contract was that the plaintiffs would be entitled to 33.3% of the developed area in the property. My lords, when your lordship sees exhibit Annexure J, the lordship does not find the sale consideration mentioned anywhere in the document. Possession is not delivered to the plaintiffs. Therefore, my lords, they file a suit, my lords, for a declaration that they are entitled to 33% of this land area, which is suit scheduled property. My lords, the trial court, my lords, looking into this document, allows an application filed by defendant number 1, stating that it is a conveyance falling under section Article 20 of the Stamp Act, and has directed me to pay stamp duty, my lords.
ಏನ್ರಿ RSL ಆಗಿದೆಯಲ್ರಿ?
My lords, what happened, my lords? This application was allowed, filed by defendant number 1. And my suit also.
At the stage of trial.
No, my lords, at
Huh?
the very inception of the suit, after my suit was instituted,
Huh.
they filed an application under Order 7 Rule 11.
Yes.
As also 33 under section 33 and 34.
Huh.
33 and 34 application was allowed,
Huh.
directing me to pay stamp duty.
Yes.
On the very same day, my lords, Order 7 Rule 11 was also allowed. My lords, I challenged it before the first appellate court, my lords, in an RA. RA was also dismissed. Then, my lords, I filed second appeal. Second appeal came to be allowed, and my suit has been restored now, my lords. Well, it's first I had actually challenged this very same order Annexure A by filing a writ petition.
Restored with what direction?
Well, it's in toto, my lords, de novo inquiry, my lords.
Huh?
Kindly see, my lords, page 99.
Yes.
Well, judgment and decree, 98, my lords, is the. Accordingly, the appeal is allowed. Judgment and decree dated so and so, passed by in OS 477 of 17 by the trial court, and the judgment and order dated so and so, passed in RA 251 of 19 by the first appellate court, are set aside. Plaintiff is restored, my lords. Now, my lords, I had, my lords.
Matter is remitted to trial court. Trial court shall proceed from the stage where it was before passing the impugned order and dispose of the matter on merits. What about that section 33, 34 application?
33, 34, my lords, I had challenged it earlier. I filed a writ petition challenging it. My writ petition, my lords, came to be dismissed on the ground, my lords, that it has become infructuous because the suit itself was dismissed. Therefore, my lords, I filed a writ petition now because the suit has been restored. A cause of action, my lords, for challenging that order has arisen now again for me. Therefore, my lords, I filed this writ.
Issue notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondent before the trial court.
I request a stay of the recovery of this. It's
Serial number
important, my lords,
6.
may kindly see this order, my lord. One, my lordship. may
No,
kindly-
not now, sir.
My lords,
not
the
now.
trial court, my lords, holds that it is a stamp duty has to be paid under Article 20.
ಆಯ್ತು, ಇನ್ನು ಸ್ಟಾರ್ಟಿಂಗ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದಾರೆ, nothing will happen, let them come, we'll see.
Allah,
Yes.
the document is already sent to the DR, my lords.
See, you did not challenge it.
I challenged it, my lords. I filed a writ petition.
Where is that order?
My lords, kindly see, my lords, that order is available. My lords, page 74, my lords. 75, my lords. My lords, at 77, in the present case, the suit itself is dismissed on 16/10/2019. Therefore, the question of exercising divisional jurisdiction and Article 227 would not arise. It is stated across the bar that the now is list in respect of the subject matter in the suit is pending in RSA number so and so. If these significant details are taken into consideration, the writ petition does not survive a consideration, and accordingly, the writ petition is dismissed, having become infructuous. Because, my lord, the suit itself.
See, please read paragraph number 3.
3, my lords. It is a trait law that an interlocutory orders passed in the pending suit can either be challenged under Article 227 of the Constitution of India, or if the suit goes against the party has the remedy to question the order on an interlocutory application in an appeal under Section 96 of the CPC. Now, my lords, in fact, my lords, the suit has been restored now. Therefore, my lords.
Along with that, you should have pressed this petition also, or this prayer also, regarding the orders passed on in respect of the application filed under Section 33-34.
Yes.
You have not done that.
My lords, it was in the second appeal, my lords. Therefore, my lords, under section 100, my lords, this appeal, this was not available to me. When the order was passed in the writ petition, my lords, second appeal was already pending under Section 100. My lords.
Then you could have asked this writ petition to be clubbed along with that one.
My lords, but the court said, my lords, that it is infructuous. My lords, anyway, my lords, since the suit has been restored, all orders, my lords, in fact, they come back to.
Release this matter on 3rd of September.
Serial number 6.
Lords, a suit for bare injunction has been filed by the petition, respondent. My lords, I have filed a suit for declaration of my title in respect of survey number 150 measuring to an extent of 6 guntas.
You
My
filed a
suit for declaration, my lords. My lords, that declaration suit is at pay annexure B.
respect of the same property.
My lords, I am claiming 6 guntas of land. Now respondents are claiming a site based on a Hakkupatra. My lords, and
Card out of that survey number.
called out of that survey number. My lords, my sale deed is of the year 1958. My lords, they claim that they have been granted Hakkupatra in the year 1972. My lords, I am in possession of this property. Suppressing this fact, my lords.
Granted by?
My lords, the Tahsildar. My lords, now suppressing this fact, my sale deed is of the year 1958. My lords, he files a suit for bare injunction.
Yes.
But subsequently, I file a suit for declaration to declare that I am the absolute owner of the entire property of 6 guntas of land. My lords, the suits are pending consideration. My lords, I make an application in OA, the suit for bare injunction, to club this along with my declaratory suit. My lords, trial court dismisses on the sole ground that the properties claimed by both the parties are different. My lords, in order to have a proper adjudication, my lords,
You notice to the respondent. The petitioner is also permitted to serve copy of the petition along with annexures on the learned counsel representing the respondent before the trial court. We'll stop. Next para. Learned counsel for the petitioner submits that the respondent herein has filed a suit seeking permanent injunction
in OS 115 of 2021.
in OS number
115 of 2021.
115 of 2021.
Yes, ma'am.
And the schedule to the suit is in respect of a residential site
Yes, my lord.
said to be carved out of survey number 150. ಅದ್ಯಾವ್ದು ಇನ್ನೊಂದು 396/3 ಸರ್ವೆ ನಂಬರ್ 396/3 ಯಾವುದು?
My lords, that is the property purchased by me.
Then what is 150?
My lords, it is a ಖಾತಾ number.
ಸರ್ವೆ ನಂಬರ್ ಅಂತಿದೆ.
ಅಲ್ಲ, ಅವ್ರು ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಹೇಳ್ತಾರೆ. But ಖಾತಾ ನಂಬರ್, my lords, kindly refer to page 23, my lords.
ನಿಮ್ದು ಸರ್ವೆ ನಂಬರ್ 396/3 ನಾ?
Yes, my lords.
ಏನ್ ಹೇಳಿದೆ? $150. Full stop. Subsequent to the suit filed by the respondent, the petitioner has also filed another suit in OS number
273 of 21.
273 of 2021, seeking declaration in respect of 6 kuntas of land in survey number 396/3. Arraying the respondent herein as the defendant.
Defendant.
Full stop. It is the contention of the petitioner that the site, the suit schedule property in OS number 115 of 2021 is claimed to be a part of survey number 396/3 belonging to the petitioner who
Purchase this.
had purchased 6 kuntas of land
On
in survey number 396/3 under
20
registered sale deed dated
27/10/1958.
full stop. Thereafter, the petitioner filed an application, filed a petition, filed an application seeking to club the two matters to be heard together.
Along with, my lords, so in OS 115 of 21, I have filed this application.
Full stop. However, the impugned order has been passed, rejecting the application only on the ground that the description of the scheduled properties in the two suits are different and therefore the same cannot be clubbed. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 27/5/2024 and all further proceedings
In OS 115 of 21.
ಎರಡು ಮಾಡಬೇಕಾಗುತ್ತೆ.
My lords, I will leave it.
In OS number 115 of 2021 and
273 of 21.
till the next date of hearing.
Much of this.
Seven, Kumar.
I represent petitioner, my lord. Petitioners have challenged the annexure A impugned order passed to the trial court, senior civil judge Magdi, my lord.
Hmm.
My lord, have filed application under 16 rule 6 and 7
Hmm.
CPC
To
seeking
produce
to produce registration extract. My lord, in the impugned order, the observation made that no pleadings as such as far as alleged partition is concerned. Kindly turn, my lord, in my plain, I have clearly stated in paragraph 10 that I may be permitted to read paragraph 10, few lines, my lord.
no, please read paragraph number 2 of the impugned order.
Please. In the affidavit filed in support of the application, the plaintiff averred that he had filed, yes, my lord, filed an application under section 45 Evidence Act, and while passing the order on this application, the court has opined that unless the original sale deed is produced, the opinion of the expert cannot be obtained. He states that the defendant number 3 has not produced original sale deed for comparison of admitted and disputed signatures. My lord, prior to this, I have filed application under section 45. The trial court rightly rejected, stating that original is not available. So second application I have filed seeking direction to the defendant number 3, who is contesting, to produce the sale deed. Then he comes and claims that it is lost. For the first time, he narrated before the court that he lost it. So that when that original is not available, other go is that I have to approach with another application seeking direction to the sub-registrar to produce a registration extract, wherein the signatures of Timmanna available. I have clearly pleaded in my plaint that the partition deed or Panchayat Palupatti, which is unregistered, is created to defraud the share of the plaintiff. That was very much there in para 10 of the plaint, my lord. In spite of it, on the sole ground that no pleadings as such, observing that the impugned order has been passed, so that the petitioners are before the honorable court. In the paragraph number 10, I have clearly stated Panchayat Palupatti is an unregistered one. It is created. Then for the first time that came to be produced at his evidence.
Issue notice to the respondents.
And tomorrow is the case before the
The
trial court.
petitioner is also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondent before the trial court. We'll stop. Next paragraph. Learned counsel for the petitioner submits that IA number 23 filed by the petitioner plaintiff under order 16 rule 6 and 7 of CPC seeking directions to the sub-registrar, Magdi Taluk, to produce the registration extract for the period 1998-99, more particularly in respect of sale deed dated 13/8/1998, Exhibit P4, has been rejected on the ground that there is no pleading about any forgery or fraud in the plaint as required under Order 6 Rule 4 of CPC. Full stop. Learned counsel submits that in the plaint, the petitioner has clearly stated that the Palupatti,
Yes.
as claimed by the defendants,
Defendant number 3, my lord,
defendant number 3,
particular.
is a bogus document created only to defraud the plaintiff. And
Sure.
therefore, the trial court has erred in rejecting the application. Full stop. Learned counsel submits that earlier, when an application was filed by the petitioner under section 45 of the Evidence Act, with what prior?
To refer the document to expert. When original not available.
To refer the sale deed dated 13/8/1998
Please, along with the D4.
for expert's opinion
Please.
regarding the signatures
Please.
of
Timmanna.
Shri Timmanna, the same was rejected on the ground that the defendants have clearly stated that the original sale deed is lost. Full stop. That being the position, the petitioner had no other alternative than to file an application under Order 16, Rule 6 and 7, seeking production of the registration extract, which would contain the signatures of the parties to the sale deed.
Sale deed and Panchayat Palupatti.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order. Ilri, interim order illa.
Prayed, please.
Huh?
Prayed. Interim order is there.
Illi.
Grounds for interim prayer.
Prayer?
8th.
Prayer?
9th.
prayer ilide
Prayer
re.
is wherefore the petitioner most respectfully pray that Honorable please to stay the further proceedings.
Interim prayer ilre.
The grounds for interim prayer is there.
Starting at the oral request of the learned counsel for petitioner, the petitioner is permitted to add interim prayer, having regard to the grounds raised for interim prayer. If you please do it.
Please,
You are seeking stay
please,
of further proceedings.
please.
The impugned order dated 25/6/2024 and all further proceedings in OS number 389 of 2015 on the file of the senior civil judge Magdi till the next date of hearing. What do you have?
Number 8, Siddhappa, BM.
I am appearing for the petition.
Yes,
This is a defendant's writ petition challenging the dismissal of the IA 17 and 18, which are filed for one recalling and for witness and to production of some documents before the court.
under section 151.
Please,
In
ma'am.
order 18 rule 17 to recall
Please,
PW1
ma'am.
for further cross examination.
Please.
Ah,
Some documents, my lord, which I required to confront the PW1, where they has stated, my lord, are wrong things in the evidence. I have obtained the certified copy wherein, my lord, execution proceedings are different. And this, what is the mentioned in the sale is also different. And he did not produce the original sale deed also. In order to confront it, my lord, I filed the application. It is only for that purpose only, my lord. Already it is came to at the stage of urge of conclusion.
yav document.
Then what has happened? He has produced the document as claiming to be the sale deed purchased by one Vedamurti Swami. Vedamurti Swami has no document to produce before the court. Where he mentioned there is an execution proceedings. I obtained the execution proceedings copies wherein the entire name and everything is different. The property is also different.
It says
Suit
you
is
are
for
not stated
declaration
anything.
and permanent injunction. I am the dependent, Malad.
For production of additional documents and even separate application hakilvalla.
ಅಲ್ಲ ಅದನ್ನ ಕನ್ಫ್ರಂಟ್ ಮಾಡ್ಸಕ್ಕೆ ನನ್ನ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ರೀಕಾಲ್ ಮಾಡಿ ಕನ್ಫ್ರಂಟ್ ಮಾಡ್ಸಕ್ಕೆ ಅವರಿಗೆ
The document is already on record.
ವಾಟ್ he has stated in the in the document produced by me and in the chief examination entirely different.
Sorry, sir.
It is his document only I want to confront.
Is the document already on record?
His document
Or
is,
are you seeking to produce any other document?
in other document, my production is will not dispense with the proof. Confrontation is necessary. I want to
Confrontation
confront
of
the
what, sir?
document.
See, you have said it in the order it is said.
I agree, Malada, some reasons in the affidavit they are not properly assigned. That is, I agree, Malada. They are not
There is no
properly
application
worded.
to seeking leave to produce additional documents. How can this application be allowed?
Reduction of additional document is different, is on my behalf. Here, in one document, what is mentioned in his document?
ಆಯ್ತು ಗೊತ್ತಾಯ್ತು sir. The impugned order has been passed, noticing that you have not filed any application for production of additional documents.
I filed an
But you are seeking
application
production
for
of
the
certain
recalling and
documents.
reopening of the case, Malada.
ಎರಡೇ ಕೇಳಿರೋದು ನೀವು. To recall the order.
Recall adre, I can produce the document through him only.
Huh?
By confronting, if admits a document, it will be the marked document.
How can
Yeah,
you?
for which-
No. How can you tender the document for confrontation without seeking leave?
That was, I have two applications have been filed.
ಹಾಕಿಲ್ವಲ್ಲ ನೀವು you were only
Recalling
asking
and
for recall of
reopening.
the order.
Recalling and reopening.
You should have filed one more application.
Document production, ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ I would have filed another application. But here only a witness confront ಮಾಡಕ್ಕೆ.
Confront ಮಾಡಕ್ಕೆ document if it is already on record, you can ask it from the court and confront it.
No,
If it is
document.
not on record, then you will have to produce the document. You
My
have not filed
submission
any
to-
application
Yeah.
to produce additional document.
I am, madam, if he is, madam, I did not admit it, I make an application, that is different aspect.
Ah.
Unless he recalled, my lord, I can't do it, madam. Because there is vital evidence.
But your intention itself is to confront a certain document to the witness.
To the witness who is already closed his case. ಅದಕ್ಕೆ recall
Recalling
ಮಾಡ್ಬೇಕು.
is all right.
Ah.
But if you want to produce any additional document for confrontation, another application should have been filed.
ಇಲ್ಲ, additional document for confrontation of the witness, my lord, it is not necessary, madam. Because only confrontation, if he admits, if he did not admit, then I make an application for production through me, my lord.
Issue notice to the respondent. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondents before the trial court. Next para. Learned counsel submits that the impugned order has been passed rejecting the applications filed by the petitioner under order 18/17 of CPC to recall PW1 for further cross-examination on the ground that the petitioner has nowhere stated in the affidavits regarding the documents to be produced, and there are no documents filed along with the application. Full stop. Learned counsel submits that once the plaintiff witness is recalled for cross-examination, the defendant is entitled to confront any document to the witness, and if the witness admits of such document, then it can be marked, or else a separate application will have to be then filed to produce additional document. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 26/6/2024 in OS number 459 of 2014, and all further proceedings thereto on the file of the first additional civil judge and JMFC Chitradurga till the next date of hearing.
Number 9.
My lordship,
One
kindly
can
pass
check
out, my lordship. They've given some judgments, my lordship. I'll go through and will submit by 1:30.
1:30 na?
Tomorrow, my lordship. And have it by tomorrow.
At the request of the learned AGA, release this matter tomorrow.
Serial number 10. Manju, yes.
My lord, in this case, I am a association. This apartments association comprises of 39 flats. And unless the respondents and other members pay the maintenance, association is not in a position to bear the, to give them the basic amenities. Now, this petition before the trial court came to be filed for seeking maintenance, as respondent failed to pay the maintenance continuously for 1 year during COVID. And during that time, the secretary came on record. He was hale and healthy. He was the secretary at that time, and he filed the case. And subsequent to leading evidence, and it was posted for cross-examination, he was suffering with some illness, and as a result, he couldn't represent before the Honorable Trial Court. In the order sheet at ink page 23, the Honorable Trial Court has observed that due to ill health and clot in the brain, the the witness is unable to represent before the court. So as a result, the party himself represented and pleaded that he may be relieved from the case and allow the present secretary, because in the association every year elections are held, the present secretary is willing to come on record and he has produced all the relevant documents to show that he is the secretary who is appointed at present and he is willing to contest the matter on merits and also to take the case ahead, wherein the trial court is reluctant to bring on record the present secretary because the
What do
case
you
was,
mean bring on record?
in the sense, my lord, at the time of filing of the recovery suit,
The plaint is filed by Devmukh Apartment
owners
Owners
association.
Welfare Association,
Yes, my lord.
represented by its secretary.
Secretary, yes.
Whoever is the secretary will take care of the matter.
Please, my lord.
Where is the need for bringing another person?
So.
There was no need for you to make such an application at all.
Yes, my lord, but
Huh.
in
Why
spite
did you
of
make that application?
that application was not required, the court directed me to take next initiative. Take
For
this.
what?
To the, because the,
First of all, there was no need for the previous secretary
yes, my
to
lord.
have filed such a request before the court.
Yes, my lord.
See, whenever elections take place, another person is appointed to that post.
Please, my lord.
He will continue the suit.
Yes, my,
Where was the need for you to make such an application?
but because,
Suit is filed not by the secretary.
yes,
It is
my lord.
filed by the association.
Yes, my lord.
Then
So my trial court was not.
there was no need for you to make
Yes,
such
my lord.
application at all, madam.
But I couldn't proceed with the case because they were not allowing the
You
present
are aggrieved by
secretary.
which order now?
My order dated 29
Allow him to come on
29/4,
record.
2024.
As he is the present secretary
Hmm.
of the plaintiff association and permit him to lead the evidence.
Yes, my lord.
Huh.
But this is not appreciated in its true spirit, my lord.
The only point now requires consideration is that whether court can grant the same relief which is already rejected by the same court.
Means an application when the previous secretary informed the court that I am unable to represent and I filed an application. At that time, because supporting documents were not produced, my application was rejected.
Ah.
And subsequently, I was compelled to file another application with all the supporting documents to show the election was held in accordance with the bylaw of the
Where
association.
that previous order, you did not challenge it.
No, my lord. Due to paucity of time, I couldn't do it. As my mother was not keeping well and due to my personal reasons, I was held up in my hometown. As I didn't challenge the previous IA number 2, my IA number 3 is refused.
When was that previous order passed?
Previous order was passed on to 12/10/2023. At ink page 21, my lord. Sorry, ink page 26. At ink page 27, the court says, since the applicant has not produced any document to show that he is the present secretary. At the last portion of the order. That was the only ground on which my application was rejected.
Purple. Issue notice to the respondent. The petitioner is also permitted to serve a copy of the writ petition along with annexures from the learned counsel representing the respondent before the trial court. We'll stop. Next paragraph. The petitioner, Apartment Owners Welfare Association, had filed a suit before the small causes court for recovery of rupees 1,12,000 from the respondent defendant, who is also the owner of an apartment and a member of the association.
Yes, ma'am.
Full stop. An application was earlier filed by the previous secretary who was examined as PW1, that due to his medical condition, he is unable to prosecute the matter, and therefore the person who subsequently was appointed as secretary to the association would continue the proceedings, and he should be permitted to lead evidence and be cross-examined by the other side. Full stop. That application filed under section 151 of CPC was dismissed by order dated 12/10/2023 on the ground that no supporting documents were produced by the applicant to show that he subsequently was appointed as the secretary of the association. Full stop. Thereafter, the present application was once again filed under section 151 along with the requisite documents. Full stop. However, the application has been rejected on the ground that earlier similar application was already rejected and similar application cannot be entertained once again by the court. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 27/5/2024 and all further proceedings in SC number 456 of 2022 on the file of the 11th additional small causes judge and ACMM, Bengaluru till the next date of hearing.
Much obliged, my lord.
11. Fayaz Saab, BG.
Here for plaintiff in this case, Lord. Lord, in this case, the plaintiff has filed the plaintiff petitioner before this court is the plaintiff in OS number, commercial OS number 3 of 2022 on the file of first additional district and session at Tumkur, Lord. Lord, the petitioner here has filed a suit for recovery of a sum of rupees 20 lakhs, which has been paid by this plaintiff to the defendant as a security deposit. That amount has been paid separately. There is no reference in the agreement. This has been, Lord, kindly see the Annexure B, page 41, Lord. Annexure B, page 41. The page 42, Lord, kindly have a page 42. This is the agreement.
Sale agreement.
12/8/2020.
Sale of what?
This is the sale with regard to that vehicles, Lord, movable properties. So, Lord, page 42, Lord, page 42, condition number 2 in the bottom, Lord, second condition number 2. While signing the agreement, the buyer will transfer the fund as a 20 lakhs as a security deposit. So, pursuant to that, Lord, he has there is no reference with regard to that payment, but he has paid separately that amount of 20 lakhs, 5 lakh rupees through the RTGS and another 15 lakh rupees through the check. That amount has been paid to this defendant Lord. Then they have not this thing, they have filed a suit for recovery of that amount. The agreement which has been referred here, Lord, has not taken any shelter under these things. This transaction of this, it is only as a security deposit. He made the payment separately. That is also not made in a reference. But Lord, in support of that, as a supportive document.
You are aggrieved of which order, sir?
Lord, aggrieved of that, Lord, page 27, Lord. The trial court has impounded the document and also for 20 lakhs, 15 lakhs rupees court fee katti, stamp duty and registration charges anta heli, they pass that order, page 27, Lord. Page 27. Shall I read, Lord? Page 27 nalli. Heard the arguments of plaintiffs, bottom nalli this. Plaintiffs and the defendant counsel, plaintiff is directed to pay the duty and penalty on original agreement, a sale agreement, and also pay remaining court fee of rupees 15 lakhs. This is the order on 6/11/2023. The trial court has passed that order. Lord, my submission before this court, Lord, he filed a suit for Annexure E, page 53 is the plaintiff, Lord. I have not claimed anything in support of that agreement. So whatever the amount, page 56 is the relief sought, prayer sought in the suit, Lord.
he is seeking for that amount which has been paid by him in two different times. That is 5 lakh rupees under RTGS, page 56. No?
Directing defendant to pay amount of rupees 5 lakhs.
5 lakh received by the defendant from the plaintiff in IMF so and so, reference number so and so, and another amount of 15 lakhs by amount paid by the defendant through the check bearing number so and so. For that, he has paid the court
As
fee.
per agreement entered into between,
Agreement entered, my lord, because for in the agreement, he has not made any this reference.
no,
Because for my
you
lord,
have to pay, sir.
Lord, this is the amount of 20 lakhs. I am not acting on that agreement. Acting on that agreement, Lord. That as recorded under section 21 of the Karnataka Code Fee and
No.
Suit Valuation Act, Lord, I paid the amount of that 20 lakhs, that 33 lakhs, 375, Lord.
Without that agreement, there is nothing at all.
Well, agreement is like the separate transaction because for this amount has been
No.
made separately, not in support of that agreement, Lord.
No, sir, there is nothing wrong in the order. Yes.
Otherwise, Lord, because for I am having a sufficient document, so permit me to take back that agreement because agreement, I am not relying on that agreement.
If you don't rely, if it is impounded, let it be impounded. Yeah, what is that? You are not going to get found any-
Impounded ಅಂದ್ರೆ ಏನಿದೆ
Leave it
ಅಂದ್ರಲ್ಲಿ
there.
one
Yes.
submission, Lord. Based on that, now the court is demanding me to pay that amount of 15 lakhs.
Don't pay, the document will not be considered, it will be impounded.
ಅಲ್ಲ ಈಗ
That's it.
ಅಲ್ಲ suit
Anyway, you are not placing reliance on the document. Leave it at
Suit
that.
itself is that the court is inclined to dismiss the suit, Lord.
Huh?
The court is inclined to dismiss because of non-payment of that court fee. That's my submission because I am having the independent evidence.
Have you not paid court fee
Yes, Lord.
in respect of 20 lakhs?
Yes, I have paid that. I have paid that.
How it can be
But
dismissed?
the court is because for this document is impounded. If I have not paid this amount of 15 lakhs, the court is wanted to dismiss the suit.
No, sir, you can argue.
So,
I have paid
already
court-
argument
I
has
have
been placed.
paid court fee for recovery of 20 lakhs.
Yes, Lord.
Therefore, the suit cannot be rejected.
Alla,
For
with
non-payment
with
of
those
court fee.
observations, this suit may also be disposed
From the order
of.
passed order, let us see. It's not
Alla,
now.
because for if the
Why
court
please
has been
drop off?
dismissed my suit, Lord, again it leads
That is
to
not the order
multiplicity of
passed now.
proceedings.
That is not the order passed.
That is not the order. because
Hangena
of
order passed,
non-payment
let
of
us
this,
see.
and also as required under section 31, the trial court has to refer this document to the deputy commissioner for adjudication. That is also not done. Directly the court has
So if you are saying, I am prepared to pay the,
No, I am not prepared to pay the procedure lapse I am submitting before this court. The procedure lapse which has been committed by the trial court, I am submitting as per section 31 of that.
court also has got the power, sir.
Let's, court has got power.
Court also has got
Because
the
for I
power.
am not relying on that
Pay the
document,
stamp duty.
that whatever the amount I claimed for that, I paid the court fee. As required under section 21 of the.
Therefore, if you are saying
Yes, no.
whether that document is considered or not, whether it is impounded or, I am not worried.
Yes, no, because for that I am having a sufficient document,
it at
independent
that.
evidence to prove that
If you
that
don't
amount
want
which
to
has
pay
been
the,
paid.
if you don't want to pay the stamp duty and penalty, leave it at that.
But ಅವರು ಈಗ ಅದನ್ನ ಇಂಪೌಂಡ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಮಾಡ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ.
Suit
That
dismiss
is
ಮಾಡ್ತೀವಿ ಅಂತ
the-
ಹೇಳಿಲ್ಲ ಸರ್. ಮಾಡಿದ್ರೆ, if such an order is passed, you will get a cause of action. We will see at that time.
Seal number
ಅಲ್ಲ,
12.
ಅದನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ because
Not now.
otherwise it leads to multiple, again I have to file one more petition or I file an
No, sir.
application for amendment and all those things.
Yes.
Seal number 12.
Next
YP
matter.
Gurappa.
Please, madam. Please, madam. I am appealing for the petitioner, madam. Madam, this is a plaintiff's writ petition
Yes.
seeking the direction of this honorable court to seeking direction against the second additional civil judge Arkalgodu to dispose the suit number 3 of 2013, madam. Petitioner is a senior citizen, already she is 71 years old. He has filed the said suit for seeking the partition of the scheduled properties. The suit is pending for last 11 years, madam. And dependent respondent are dragging the matter for one or other reason. The matter was posted for defense evidence in the year 2019 itself. For last 5 years, my lord, the matter was dragged for defense evidence. Therefore, only request before this honorable court is to direct the honorable trial court to dispose of the matter in a stipulated time. My lord.
Document was sent for collection of stamp duty and penalty.
Yes, my lord. Earlier
district registrar.
evidence of
Banta ಅದು?
sent and that was returned. That was returned. And again, the matter was posted something clarification. Order sheet at page number 100 and 101 could be seen, my lord.
Banta
From
clarification.
2000, that matter again, it is posted for clarification, and it is mentioned in 3/1/2024 at page number.
The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondent before the trial court. Release this matter on 3rd of September.
Please.
Serial number 13, PC Sunita.
I appear for the petitioner. Petitioner is the plaintiff before the trial court, my lord. Petitioner is the plaintiff before the trial court. my
Suit
lord.
for
Suit for declaration and cancellation of the sale deed, my
Ah.
lord, which is pending for, from 2014, we have filed, my lord. This, my lord, the plaintiff father has granted a land by the land grant, he is cultivating an unauthorized cultivation of the land, my lord. Land committee has granted the land in favor of the petitioner father in the year 1978, my lord. Thereafter, the kata was made in favor of the petitioner father, and up-to-date tax was paid, kandayam was paid by the petitioner father, my lord. Thereafter, my lord, in 2000, my lord, without notice to the petitioner's father, my lord, the kata was, grant was cancelled.
2010. Suit was filed in the year 2010.
2010, my lord. 2000, my lord, kata was changed in favor of the respondent hearing, my lord. Thereafter, my lord, they filed an appeal before the assistant commissioner for changing the kata. Thereafter, my lord, they filed a.
You said you have filed an application seeking regularization of unauthorized
Please, my
occupation.
lord, granted, my lord. And
It is
I was-
granted.
Granted, my lord.
When?
I was, it's 1978, my lord. Thereafter, my lord, I was put in possession till date, my lord, I have paid kata, my lord. Without my knowledge, my lord, grant was cancelled and made it in favor of the fourth respondent hearing, my lord. Fourth respondent immediately, my lord.
When was it cancelled?
At 99/2000, my lord. 99/2000. Immediately, I filed an appeal before the assistant commissioner for the cancellation of, my lord, when it was pending. my lord,
Challenging the order of
and
cancellation.
grant, my lord.
Yes,
Cancellation of grant.
yes.
Thereafter, my lord, I filed a suit, my lord. Here, my lord.
Why suit?
A suit, my lord, for declaration in favor of me, my lord.
How can you seek declaration when you are yourself saying the grant has been cancelled and you are challenging the order of cancellation?
Cancellation, my lord. It was pending, my lord. Assistant commissioner, before the assistant commissioner, it was pending, my lord. Since, my lord, kata and tax was paid by the petitioner, my
Yes.
lord. I sought for declaration of the survey numbers, my lord.
When you yourself are saying the grant is cancelled, how can you seek a declaration?
Bit of land was granted to the defendants, my lord, not entire, my lord, bit of.
That is not the issue, madam. You are saying your grant was cancelled
Please.
year 1999-2000.
99/2000, my lord.
So you approach the assistant commissioner challenging the order of cancellation.
Cancellation. my lord. Because the assistant commissioner, my lord, only the revenue courts, my lord, they cannot, exercise their jurisdiction, my lord, title deed. my lord.
What happened?
My lord, I sought for summon.
What happened to the proceedings before the assistant
It was still
commissioner?
pending, my lord.
Is still pending.
Pending. my
Then
lord.
how can you seek a declaration in this background?
Because since, my lord, they, in pursuance.
You
of the-
yourself are saying the grant is cancelled.
Please, my lord.
What kind of a declaration are you seeking for?
My lord, only bit of land was granted in favor of the defendants. my lord. The
Adallamma,
entire
that is
grant
not
was-
the issue.
Entire grant was
If
not.
your grant has been cancelled,
Entire grant was not cancelled, my lord. Only some land was.
what is the, you are aggrieved of what now?
I sought for an summoning of the Tashildar, my lord, to say, my lord, whether they followed the procedure while cancelling the grant or not, my lord.
Those
Because
proceedings cannot be called in question before a civil court. There is a bar.
Because since, my lord, it's a land grant, unauthorized cultivation of the land, my lord. Because since, my lord, Tahsildar
notice
has,
to the respondents.
my lord, for a moment,
Learned AGA takes notice for respondents number 1 to 3.
1 to 3, my lord.
Issue notice to response number 4 to 9. Learned counsel for petitioners is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA. Release this matter on 3rd of September.
My lord, I saw it first.
There is a
because
bar,
since
madam.
Because since my lord, Tahsildar has filed a
You
written
cannot
statement.
call an order passed by the revenue authorities under the provisions of the Karnataka Land Revenue Act or the Land Reforms Act before a civil court.
ಇದು Land Reforms Act ಕೆಳಗಡೆ
Yes,
ಮಾಡಿದ್ದು.
yes.
ಇದು land.
Number 14.
My lord, for a moment, my lord, since. my
Let us see,
lord,
I have given a date.
Tahsildar, my lord.
Yes.
Has filed an written statement.
The next matter, please.
Number 14.
Petitioner,
Yes.
my lord, in a suit for ejectment and for payment of arrears of revenue, my lord, arrears of rent, my lord, an order came to be passed by the trial court on 15th of July 2023. Your lordship may kindly turn to page 103. May I trouble your lordship to kindly see, my lord, the order portion which your lordship will find at page number 114. IA2,
Application filed by plaintiffs.
my lord, yeah, this is an application filed by the plaintiff. I appear for the plaintiff.
Direction to the defendant to
Yes.
deposit arrears of rental.
Correct, yes, my lord.
Uh-huh.
Now, my lord, against this order, an appeal was filed by the defendant.
The application was allowed.
Yes, application was allowed. Against this order, a appeal was filed before this honorable court by the defendant. And your lordship may kindly see, my lord, in that application, we took up the plea that the appeal should not be heard at the instance of the defendant who had not complied with the order that had been passed because the money had not been paid. And now, my lord, the Honorable High Court passed an order on at page 121. Appeal was dismissed. Kindly see page 124, my lord. Learned senior counsel for the caveator respondent, who is the defendant in the suit, submitted as on today rent due from the appellant is 27 lakhs. That is, we said, my lord, 27 lakhs was due. The learned senior counsel for the appellant would submit that the appellant is running a kindergarten school and due to COVID-19, the appellant could not pay the rent. The rent is not paid from 2020 and we are in 2024 and without any valid reason, this court cannot encourage the appellant by granting time to pay the rent, though the same is not paid from 2020. Hence, no grounds are made out to consider the matter on merits without payment of rent and once again grant time to deposit the arrears of rent and sufficient opportunity has already been given. Consequently, appeal is dismissed. This order has become final. Then, my lord, we moved an application before the trial court saying, please strike off the defense. Now, my lord, the trial court dismisses that application. We are before your lordships against that order. But if the appeal has been dismissed, but until today we have not received 1 rupee, my lord, rent, and they are occupying it even without paying the rent even for the current months. And my lord, if the Honorable High Court has chosen to dismiss the first appeal that had been filed on the ground that there is that they have not complied with the order, I see no reason how my application for striking out defense should not be.
What are the reasons given?
My lord, reason is that, well, this is the matter to be looked at. Kindly see, my lord, the order that has been passed at page number 19. I'll take your lordship straight away to the reasons, my lord.
Yes.
My lord, if your lordship will kindly turn to paragraph number 16. They cite the judgments, my lord.
Anyway, there's no interim order that can.
No
be
interim. I can't ask for it. No, brother, I'm not asking. I only request, my lord, we have not received 1 rupee rent. Kindly fix a date, my lord, for return so that.
But there is some problem.
My lord.
Unlike the provisions contained, express provisions contained in the Rent Control Act.
Yes.
There is no such provision in the Transfer of Property Act
I'm
or even Order 39 Rule 10.
Yes. I'm moving under 151.
Correct. There are many judgments
Yes.
in this regard.
Yes.
I have recently come across these judgments.
There is a direct judgment of the Supreme Court which says that in a situation where you don't comply with the order of the court for payment, the defense can be struck off. Otherwise, my lord, this is a complete abuse of the court. It occupies the property, not paying 1 rupee rent. Arrears to Kotila, current rent to Kotila. And wants to contest the suit.
You cited the judgments?
My lord, we have in the trial court, we cited the judgment, my lord. If your lordship will kindly see para 16.
The Prestige Lights Limited.
Prestige Lights is the most important, my lord. We have cited that.
issue notice to the respondent. The petitioners are also permitted to serve a copy of the petition along with annexures on the learned counsel representing the respondent before the trial court. Release this matter on 3rd of September.
Number 15, Anand Devi.
For petitioner, my lords. Suit for partition was filed by petitioner number 1 and respondent number 1 against her mother. The suit scheduled properties was purchased by petitioner number 1 father. Suit for partition, my lords.
You are the plaintiff.
Petitioner number 1 is plaintiff and petitioner number 2 is respondent number 5 in FDP proceedings. Final decree proceedings ಅಲ್ಲಿ ಇದೆ. ಅಲ್ಲಿ compromise petition ಹಾಕಿದೀವಿ. Petitioner number 1 and petitioner number 2. Petitioner number 1 has given his half share to the respondent number 5 under the petitioner number 2. But the court has accept ಮಾಡದೆ dismiss the compromise petition. As the partial partition compromise cannot be done because respondent number 2, her mother was not party for the compromise petition.
Which is the impugned order?
My lords, annexure K at 99 page number, my lords. Para 8, my lords.
What is this annexure C?
Annexure C is the
RSA.
RSA. RSA no non appeal ಹಾಕಿದ್ದಾರೆ. Petition number 2 has appealed. So, SLP has also appealed by me. All appeals has been dismissed.
ಯಾರು ಇವರೆಲ್ಲ ಹಿಂದೂಸ್ ಇದಾರಲ್ರಿ?
Partition ಹಾಕೊಂಡಿರೋದು petitioner number 1 and respondent number 2 against her mother. ನನಗೆ respondent number 2 ಅವರ ತಾಯಿ ಬಂದು ಮೈನರ್ಸ್ ಇದ್ದಾಗ ನನಗೆ ಸೇಲ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಪಾರ್ಟಿಷನ್ ಹಾಕೋತಾರೆ. when they were minors. ಅವರ ತಂದೆಯ ಭಾಗನ ಹಾಕೊಂಡಿರೋದು. ತಂದೆ ತೀರೋಗಿರ್ತಾರೆ. She married another man. After marrying another person, after the death of her husband, she sold the property of petitioner number 1 father and petitioner number 2.
Please read paragraph number 2. Page number 99.
Para 2, my lords. Under the compromise petition number 1 relinquished all his rights over the suit properties in favor of respondent number 5, thereby permitting him to enjoy the share of petitioner number 1 over the suit properties. In the compromise petition, the petitioner number 1 has stated that the suit properties belongs to respondent number 5. Since his mother has sold the suit properties in favor of respondent number 2 to 4, who in turn sold the same in favor of respondent number 5. Both petitioner number 1 and respondent number 5 are sought to accept the terms of compromise arrived at between themselves.
What objections were raised?
My lords,
Paragraph 3.
para number 3, my lords. The petitioner number 2 has remonstrated such application and contended that the terms of compromise arrived between at petitioner number 1 and respondent number 4 are not in alignment with the judgment and decree passed by this honorable court in OS 250 of 2006. It is contended that the petitioner number lacks the authority to execute any confirmation or concerned deed in favor of respondent number 5 since the respective rights and quantum of shares have not been adjudicated. A significant concern is raised the absence of clear demarcation of the property between parties to this petition. Petitioner number 2 also alleged that petition number 1 has withheld the crucial fact regarding prior agreement of sale deed pertaining to suit properties executed in favor of SV Ashok. He submits that after demarcation of their shares, the parties have to execute registered sale deed in favor of said SV Ashok. Petitioner number 2 alleged that petitioner number 1 along with respondent number 5 have colluded with one another and entered into compromise by ascertaining such compromise as illegally. Petitioner number 2 sought to dismiss such application. No document has been filed.
Issue notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondent before the trial court considering the final decree proceeding.
Yes, ma'am.
Yes.
That stay of further proceedings.
No, sir. Yes.
Serial number 16. Mohan Kumar D.
The suit filed for bare injunction, my lords, so not to interfere with peaceful possession of the plaintiff suit schedule properties, my lords. My lords, the plaint is at annexure E, my lords, page number 83. My lords, I have filed an IA for 39 rule 1 and 2, and my lords in annexure F, my lords. But the trial court is pleased to pass an order for issuing the emergent notice, my lords. So I'm seeking for stay to not to interfere with my peaceful possession, my lords. My lords, annexure A, my lords, I have purchased the property in the year 6/12/2019, my lords. And another sale deed at annexure B, my lords, in the year 2020, my lords. All the revenue records is standing in my name, my lords. Kindly see annexure C and C1, my lords. Party C and all the revenue records is standing in my name, my lords. My lords, the property has been converted, duly converted in page number 77, my lords. The two suit schedule property item number 1 and 2 has been converted, and the POD has also been taken place, my lords. After all these, my lords, the defendants, who is respondent before the respondents, as creating entrance to the petitioner land, my lords, my lords, I have also filed an complaint before the jurisdictional police. My lords, they have issued an NCR. This is a civil in nature.
Police cannot do anything.
Yes, my lords.
Yes.
That's why I'm seeking.
It will be considered after they come.
My lords, because my lords, the land is converted, and my lords, I have putting up the construction in the said suit schedule property. They are creating the unwanted
5 acres, 30 guntas.
Yes, my lord. And 1 acre 19 guntas. My lords, why? Because my lords, conversion agide ella revenue records.
It will be considered after they enter appearance, not
Lords.
yes.
My lords, at this stage, my lords, they are
No.
please
17.
stay not to interfere.
Sridharayan.
My lords, date may be fixed, my lords. Date.
No. Alle ಬಂದ್ಬಿಡುತ್ತೆ ಅಷ್ಟೊತ್ತಿಗೆ. Yes.
Sridharayan.
Appearing for the petition, my lords. Now, there is a suit for partition filed by the respondent number 1 to 4, my lords. When the matter was, their case
Relationship is admitted.
relationship is admitted, my lords. The respondents are the daughters and the petitioners are the sons. During the lifetime of my father, he had purchased certain properties, and those properties were subject matter of certain litigation, which have come across until the apex court, and we have succeeded in those matters, my lords. Throughout the proceedings of the litigation, wherein the petitioners over herein have assisted their father, and considering on those aspects, they have given a will, and under that I am the beneficiary. I deny all the averments made by the plaintiffs before the court below, my lords. When the matter was
Order 11 rule 14.
14, my lords, my annexure F is the
Production of
application.
original will
Please, my lords.
dated 1997
1997.
and partition deed as alleged in the return statement.
Please, my lords. My lords may kindly take annexure F 109, my lords, wherein they have filed an application for order 11 rule 14 application has been filed by the reason which has been assigned is that, since my lords may kindly take page 111, my lords. My lords. Para number 4, my lords. I submit that based on the pleadings of the party, this honorable court has framed issues, and now the matter is posted for my evidence. I further submit that when I went to my counsel office in order to give instruction to prepare my evidence by way of an affidavit, during the course of the discussion, I came to know, though the defendant number 1, 2, 3 have taken the above mentioned contention about partition and will, as mentioned to Pra, they have failed to produce the original documents of the same before the court. Para 5, my lords. I submit that I am supposed to see the contents of the said will and partition deed mentioned to Pra in order to prove my case through my evidence and also enable this honorable court. The application is filed when when the matter is posted for plaintiff evidence, and he is seeking assistance of the court for me to produce the document for him to get it marked, my lords.
You are the defendant.
I am the defendant. Plaintiff produces the plaintiff files the IA, my lords. He seeks that
But
document.
it is said that contention is taken in the written statement,
Please, my lords.
but they have not produced the document.
They have not
They
produced
are
the
seeking to produce it now.
production of the document.
Issues are framed.
Issues were framed, my lords.
Then if
Issues
issue is framed, then they will have to lead evidence by producing the documents.
Please, my lords. My lords may kindly see annexure 107. The issues are framed. framed.
Not 7.
107, my lords, page 107. Annexure F, E, my lords, annexure E. First three issues, whether the plaintiff claims that plaintiff and defendants are tenants in common, whether the plaintiff proves that the suit properties are Mutruka properties of the plaintiff and defendant number 1 to 3, whether the plaintiff proves the sale deed dated 28/6 executed by the defendant number 3 and his wife in favor of defendant number 4. Defendant number 4 is the purchaser, my lords. Is null and void and not binding on the plaintiff, whether the plaintiffs are entitled. My lords may kindly turn to page 108, wherein additional issue was framed. Whether the defendant number 1 to 3 proves that their father bequeathed the suit schedule A properties through a will dated 17/9. The burden is lies on my shoulders, my lords. And since the application, the sole intention for him to file an application for those documents should be produced for his evidence, my lords. It is ultimately he has approached the court, the burden lies on him. Ultimately, if
You took up that contention.
I have taken that
That there is
contention,
a will executed by your
please,
father.
my lords, my father has executed a will.
This application is filed by the plaintiff
Plaintiffs, my lords,
to produce that
produce
document.
the document for him to produce in during his evidence. My lords, burden is on my shoulder to discharge the additional issue number 1. And the plaintiff has 3 issues which it is under his shoulders, my lords. Suppose in the moment I don't produce those documents during my course of evidence, my lords, I will not be the beneficiary of the said contention, my lords. For him to take the ultimately, my
Take
lords,
advantage of it.
my lords,
You take advantage of it.
please, my
You
lords.
don't have the original document with you.
No, I have the original document, my lords.
And they are producing it now.
They are seeking for me to produce during their evidence, my
They
lords.
are seeking
They're seeking production of those documents which are under my custody.
directions to you
Please, my
to
lords,
produce the document.
produce the document.
Anyway, you have taken a stand.
My lords, that during course of my evidence, I will do it, my lords,
Ah.
ultimately.
Ah.
And it is for it is a burden on their shoulders. If at all, he can only seek a liberty before the court to contest by way of a rebuttal evidence after I produce those documents. And during this course and the stage of the proceedings, during his plaintiff evidence, the said application is filed.
Which is the impugned order?
Annexure A, my lords. Page number 18, my lords. There is no speaking order passed by the court below at all, my lords. Order starts at page 20, my lords. It reads that when the matter was pending for the plaintiff evidence, the present application is filed. Lords may see the internal page number 4, wherein last 4 lines, my lords, from the bottom. The plaintiffs have to leave their evidence. As such, it is necessary to give the evidence also on the will and the partition. Hence, defendants have to be directed to produce the said documents, hence sought to allow the application. This is the prayer which has been sought by the plaintiff.
Please read paragraph number 10
Please, my lords.
of the impugned order.
In this case, as mentioned above, the defendants have specifically pleaded about the will dated 17/9/1907, wherein shares are also allotted to the plaintiffs. There is no contention in the written statement about non-availability of the said document. When the defendants have relied on the will and partition to establish their defense, the said documents have to be produced with the written statement. But in the case of defendants failed to produce both of the documents. This is the order, my lords. They rely upon a judgment and wherein they extract Order 8 Rule 1A. And they tell the defendant is necessary to produce the document.
Yes.
It is my burden, my lords. Already an issue is framed on to discharge my evidence. In the event of I don't succeed, my lords, I will not owe the beneficiary as per what I have stated. For the will, he has approached, the plaintiff has approached it, my lords. Written statement was filed way long, my lords. And during their evidence, the application being filed, it clearly demonstrates the intention as to what. From para 11, my lords, there is only the judgment has been extracted. There is no speaking order as to what is there. Only the contention of the parties, what I filed the objections has been demonstrated, has been rendered. That's it, my lords. There is no speaking order as to why an application is allowed, whether the necessity, what makes it, my lords. Ultimately, the plaintiff has approached the court. It is a burden on his shoulders, my lords. In the event I produce it, he has an authority to file a rebuttal evidence. He can lead it, my lord. The reserve, he has the liberty to do that, my lords.
But that judgment says, whatever has been relied upon, that it shall be lawful for the court at any time during the pendency of the suit to order production by any party thereto upon oath of such of the documents
document in his
possession or power.
relating to any matter in question in such suit as the court shall think right and the court may deal with such documents. My lords, ultimately in this, the production of the document had some reasoning in the affidavit which has been filed, my lords. In this application, he tells for him to produce the document, I need to render the documents. For plaintiff to prove his evidence.
You have taken a stand,
Please, my
but you
lords.
have not furnished a copy of the will,
Please,
which
my
was mandatory for you
Please, my
to
lords.
have filed along with the written statement.
Please, my lords.
But without that, the plaintiff also will be in difficulty.
No, my lords, I may take my lordship to order 8, rule 3, my lords, for a moment.
Issue notice to the respondents.
My lords, I am seeking a
Petitioners are permitted to serve copy of the petition along with annexures on the learned counsel for the respondents. Learned counsel representing the respondents before the trial court. Yes.
Serial number 18,
My lords,
Harish Kumar MS.
may I make one submission, my lords? I'll just take my lords to provision of order 8, my lords. I'm not seeking stay of the entire proceedings, my lords.
Serial
Only
number
annexure A concerned, my lords.
No.
Kindly, my lords. Ultimately, I'm not stalling the entire proceedings. I'm only seeking a stay of the impugned order, my lords.
Serial number
Yes,
18,
next
Harish
matter.
Kumar MS.
My lord, I appear for the petitioner in this matter.
Yes.
My lord, the petitioner is the defendant number 12 in the suit, my lord. The plaintiff has filed the suit for declaration and possession. My lord, initially the defendant number 1 was the party in the proceedings. And thereafter, my lord, in the year 2021, the plaintiff has implemented the petitioner hearing. Since, my lord, the petitioner has purchased the suit scheduled property during the pendency of the suit. My lord, kindly see the defendant number 1, who is the vendor of the petitioner, has filed the written statement taking a specific contention that, my lord, the suit is not maintainable for the reason that, my lord, already there was a suit filed against her and that came to be dismissed. Suit for, my lord, it is injunction initially. Thereafter, it was the possession was sought in that. My lord, that suit came to be dismissed and it has reached the finality. Then that contention was taken by the defendant in the written statement. Para 8 and 12 is the relevant the submission and as far as the earlier suit is concerned. My lord, virtually, my lord, she wanted to take a contention that it is barred by res judicata. However, my lord, in the issue, there was no such issues were framed as far as res judicata is concerned.
Application is filed to recall.
Please, my lord.
PW1 for cross-examination.
Yes. My lord, we have filed, the petitioner has filed 2 applications. One is for amendment of the written statement. And another is for, my lord, to recall the PW1 for further cross-examination. But virtually what happened, my lord, when the petitioner was impleaded, by that time PW1 and PW2 they have adduced the evidence and cross-examination by the defendant number 1 was over. After impleadment of the petitioner, PW3 was examined. And the petitioner herein has cross-examined the PW3. And, my lord, he filed an application to cross-examine the PW1 and others by oversight, my lord. In the application, it was not stated properly. However, PW1 and PW2 were not cross-examined by the petitioner here. And, my lord, the amendment has been sought as far as the written statement filed by him is concerned. That, my lord, he wanted to raise a plea of res judicata in his written statement.
Defendant number 1.
Defendant number 12 is the purchaser. He wanted
subsequently impleaded.
Yes, my lord.
When did you file the written statement?
My lord, we have filed the written statement. Kindly see annexure G, my lord.
Annexure
G. My lord, in that we could not go through the papers and we did not take any such contention. However, we said that we rely upon the written statement filed by the defendant number 1. Therefore, my lord,
18/7/2022, you have filed the.
yes, my lord, yes, my lord,
Return statement.
yes, my lord.
Ah,
Now, my lord, we filed an application that is annexure 76. Annexure, page number 76, annexure K, my lord. We have sought for, my lord, amendment to say that, my lord, the suit of the plaintiff is hit by the doctrine of res judicata and thereby is not maintainable. Then, my lord, to say that the plaintiffs have not approached the honorable court.
this stand has already been taken by the defendant
Eight,
number 1.
yes, my lord, but no issues were framed. Therefore, my lord, in order to file an application and to, my lord, make it proper, this application came to be filed. However, my lord, the court below
You want to
has
fill in the
rejected that
lacuna.
application.
You want
Please.
to fill in the lacuna.
Yes, no, not lacuna, my lord. It is
Then
my
what,
right.
What should
because-
have been done by D1? You
No,
will
the
not be
D1 has-
permitted to do.
No, D1 has already taken that. That's the reason, my lord, para 8 and 12 may kindly be looked in. That plea is there. My lord, since I stepped into the shoes of the defendant number 1, and I find a written statement where, my lord, I have taken a contention that whatever the statement given by the defendant number 1 should also be considered as mine. To
These
be
are
more
all
specific,
matters which have already been brought on record at the hands of defendant number 1. There is no need for you to once again bring it on record.
no, I wanted to say in my written statement that it is barred by res judicata. Because, my lord, in para 8 and 12 of the
Not
written
for you to
statement,
say that,
though
sir.
the defendant number 1,
It is not for you to say that. How are you permitted to take that stand? This
my lord,
was not
I
instituted by you
only,
or against you.
yes,
It
no,
was
my vendor
done
has
against
instituted.
defendant number 1.
My vendor. My lord. So I
Yes.
step into the shoes of the defendant number 1.
Nothing, sir.
Therefore, my lord, I wanted to say
Step
only
into the
that, my
shoes
lord,
already, but the party is already there on record.
yes, my
And
lord,
the
the
statement
written
has been
statement,
filed by that party.
yes, my lord, but the only thing is that
You
despite
can't,
that
you
issues,
can't fill up, you can't be
no,
permitted to
I'm
fill up
not,
the lacuna, sir.
no, I'm not feeling, but only
No.
I'm taking, I'm legal words I'm using it, my
Issue-
lord,
issue
otherwise,
notice. To respondents number 1 and 2.
Yes.
You are seeking dispensation of notice to the others.
Yes, my lord, they are the vendors, my
But you
vendors.
have to, learned counsel for the petitioner, however, submits that respondents number 3 to 13
3 to 13.
are co-defendants along with the petitioner, and therefore no relief is claimed against them in the writ petition. Full stop. Learned counsel will therefore seek dispensation of notice to respondents number 3 to 13. Full stop.
Please.
At the risk of the petitioner, notice to response number 3 to 13 is dispensed with. Release this matter on 3rd of September. The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsel representing response number 1 and 2 before the trial court.
Much.
Number 19, Sachin BS.
Pass over. Pass over.
Withdrawal. Appearing for number 20.
Earlier, my lord, before myself entering into the filing Wakala, earlier counsel has filed a memo for withdrawal saying that there is some settlement. But according to me, my lord, there is no settlement. And the original petitioner has passed away. And my lord, in this place, my lord, his wife has been filed application to come on record. My lord, there is objection. My lord, some time may be granted, my lord. Some time may be granted, my lord, to rectify the defects on LR applications. My lord. That memo for withdrawal may be permitted to be withdrawn. My lord.
Sole petitioner.
Sole petitioner.
Sole petitioner was died, my lord. I am for the respond number 2. I have filed an application as under section 1, order 1 rule 10, my lord, impleading as a petitioner. Transpose application was filed. A said application was pending. My lord, during the pendency of the said petition, my lord, the petitioner was died. My lord, the wife has filed an application bringing a loss of the petitioner. Said application was pending. In the meanwhile, my lord, they have filed an application for memo of withdrawal. But the suit, they have stated the suit was settled before the trial court, but my lord, the matter was not settled. As such, my lord,
So that memo is not pressed.
Memo.
they have filed.
Now,
Now, my lord, there is some office objection regarding IAs, but they have come on record. Then, my lord,
Rajini Umapati,
first respondent was filed.
first respondent is the wife of.
No, my lord. First respondent was filed a suit. I mean, she is the daughter of the petitioner hearing.
Daughter.
Please, my lord. Suit for partition and
Now,
separate.
who is seeking to come on record on behalf of
Wife,
petitioner?
wife.
Wife.
Wife, my lord. Anupama.
Suit for?
Suit for partition and separate possession, my lord. After
An office objection is ಮೇಲೆ IA returned with office objection since IA for setting aside abatement to be filed.
I'll file within weeks.
Application for condonation of delay has been filed.
Filed, has been filed.
delay application file, my lord.
Learned Counsel Shri AC Balraj appearing
Withdrawal memo, withdrawal.
on behalf of the
Proposed
applicant in IA number 1 and 2 of 2023 submits that the sole petitioner has passed away and the applicant is the wife of the sole petitioner. Full stop. The learned counsel seeks for a short accommodation to comply with the office objections raised on IAS number 1 and 2 of 2023. Full stop. A week's time is accordingly granted.
Regarding memo for
Come on record first, then we'll see.
withdrawing memo, my lord, is concerned. my lord.
Two may be transposed as petitioner. My lord. He has also filed.
I am also filed an application as a petitioner, transpose application.
We'll consider.
Please.
You please come. We'll consider both the applications together.
Please.
Orders. Serial number 21, GS Srikantegoda.
Applying for petitioner number 1. Lord, office objection with respect to serial number 1 is complaint, my lord.
Complied.
Yes, my lord.
On IA number 1.
My lord, furnishing of FPF, my lord. That is complaint today. Adagide. IA number 1, the office objection is that, my lord, at the prayer para, by mistake, my lord, it's a clerical error that petitioner number 2, the applicants raised this honorable court as to come on record as petition number 2A to 2E or 2B agide.
IA number 1 of 2024.
2024, it's an IA under order 20.
Returned with office objection. Acknowledgement not forthcoming for having served the other side.
But other side copy kortin, my lord.
Kodi. That is the office objection.
And one more office objection is that there is there's a mistake.
And LRs to be
Stated
mentioned as P2A to P2E.
P2E, P2B anta agide. That's a clerical mistake, my lord. The application is well within time, my lord.
ಮಾಡಿದಿರಲ್ಲ ಆಗ್ಲೇ correction. P2E.
P2E.
ಒಂದು ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಅಲ್ಲಿ. Learned Counsel submits that steps have been taken in respect of response number 2 and 3. Stop. If steps are taken, office shall issue notice. Next para. Insofar as the rectification of office objection raised on IA number 1 of 2024 is concerned, Learned Counsel submits that the same will be complied during the course of the day. Please do it. Yes.
For 22.
Grateful, my lord.
P.D. Surana, FPF.
A week's time is granted to the petitioners to take steps for service of notice on the unserved respondents.
23, Shankar T.N.
Petitioner is.
Hmm.
Pray for a week's time to take steps.
A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on respondent number 6.
Interim order may kindly be.
Very 6 Henry.
Very 6.
Yes. Interim order granted earlier stands extended till next date of hearing.
So number 24,
Appearing for the petition.
Kritika Raghavan.
The previous council had filed a memo for retirement. We put our.
Chandrasekhar Patil has come on record. Since learned counsel Shri Chandrasekhar Patil has come on record for the petitioner.
No, my lord.
My lords, we filed a memo for retirement on the previous. Yeah, Chandrakant Patil.
So Kritika Raghavan has come on record.
Yes, my lord.
Since learned counsel Miss Kritika Raghavan has come on record for the petitioner. The name of learned counsel Shri Chandrasekhar Patil, Chandrakant Patil K may be removed from the cause list.
My lords, interim order will be extended.
Interim order granted earlier stands extended till next date of hearing.
Great. Bill number 25, P.N. Arkeshwara, PF, R123, first time.
A week's time is granted to the petitioners to take steps for service of notice on the unserved respondents.
26, Vinayak B. Vishnu, Bhatt, PF, R1B.
Same order.
27, Shilpa Rani, maintainability.
Suit for my lord, permanent injunction and my lord, the claim by the on the private organization, my lord, this land, 5 acres land has been reserved for the Rajiv Gandhi Housing Corporation, my lord. Without any title, my lord, they have filed the injunction suit and obtained the injunction order on 4/1/2023, my lord, 4th of January, my lord. When we went for the cleaning the land, my lord, this injunction suit has been filed.
Anekal.
Anekal.
So therefore, appellate court is there. That is why office objection is raised. Writ petition cannot be maintained.
Permit me to withdraw, then
Learned counsel submits, having regard to the office objection that an appeal provision is available for the petitioner under order 43 rule 1 of the CPC, that the petitioner may be permitted to withdraw the writ petition and approach the appellate court to redress its grievance. Full stop. Next para. The submission of the learned counsel for petitioner is placed on record. Full stop. Accordingly, the writ petition stands dismissed as withdrawn while reserving liberty to the petitioner as prayed for.
28.
The respondent, your lordship.
Some proposal we gave. Arbitration award was there for 80 lakhs with 24%. Rail court, we have deposited 1 crore and 6 lakhs. And this and 20 lakhs by interim order. And I submitted to the learned counsel that we will pay another 1 crore 80 lakhs. Totally 2 crores plus 1 crore and odd paid before the trial court. It comes to about 3 crores and odd. But they are not, the negotiations were going on. They say that I will put a word to my client to settle some amount.
So you want some more time?
Some more time. Otherwise, I don't have any case on merits, only a mercy petition to, because residential house is mortgaged.
Learned counsel for the petitioner.
Your lordship, may I make one submission? This matter was referred for mediation in the month of March by your lordships. During mediation, there were some proposals discussed. Those proposals did not really bear out any settlement that has come forward. Subsequent to that, the matter came back with a mediation failed report.
After that, another request was made that a further chance may be given to the petitioner to arrive at some form of amicable resolution between parties. The proposal that my learned senior friend has submitted, I have taken to my clients. We have had several back and forths. They are disagreeable to the proposal made. The amount that they want to pay is a sum total of 2 crores. The trial court has come up with a calculation based on the decree or the award that is about 2.24 crores as of 2021. The interest clock runs beyond that till date. So for my client to accept the sum that is being proposed to be paid, Your Lordship, would not be possible. And my submission is there's no chance of a settlement in this matter. The matter may be taken up for disposal on merits as and when Your Lordship finds it convenient.
24% interest.
That is the decree that has been passed. Now they don't come forward to appeal that decree. They have 2 layers of appeal available to them. They let a whole decade pass without being vigilant on that point. In the executing court, they decide to make an objection on the interest rate. That, Your Lordship, in my submission is not possible.
28 lakh was the due as per the calculation of deducting the payment. Out of that, I submitted that.
Why you didn't file an appeal?
Award Euro defendant, that is Rajesh expert, they are dealing with these properties. They went there to settle it. Somehow it was not materialized.
Allah, at least in respect of the interest.
Interest they should have challenged. The Supreme Court judgment is there. They cannot charge more than 9% in the arbitration award from the date of. But they. 2 crore 28 the trial court arrived at. Out of which 20 lakhs we are deposited by interim order. I said another 1 crore 80 lakhs.
You file an appeal at least now. Even if it is time bar, you will be permitted to file it along with the application seeking condonation of delay. Let us see.
Let that be done. That appeal can be taken up on its own merits. But in the executing court to try and seek a deviation from the decree, I would submit is not possible.
With that observation, that appeal to be filed and condone some delay.
Allah, see, we will give you 2 weeks time. You file an appeal. Let us see. After you file an appeal, you can make a submission. We'll dispose of the petition.
We will have it on 7th or 8th of August.
At the request of learned counsel for petitioner, release this matter on 5th of September.
6th.
6th. 9th of September. Yes.
Not that it need be recorded, but if by that time, if they have not filed the appeal, Your Lordship may want to consider disposing of this petition.
Yet, anyway, it will be coming up before me. You can make the submission.
Very good.
I will dispose of the writ petition.
Your Lordship, the appeal may come up before the division bench. It's an appeal against an arbitral award.
Correct. No. Not that the appeal will be coming before.
Your Lordship.
You can make this submission that because of the submission and the suggestion given by the court, 2 weeks, the matter is adjourned.
Yes, sir.
And the matter has to be disposed of on that day.
I'm obliged.
Interim order may be extended.
Interim order granted earlier stands extended till next date appeal.
29, Kashinath JD.
Petitioner, my lord, kindly pass over minutes. Pass over minutes. There is no.
You will have to pay the process fee.
Please, my lords, there is no interim order, my lords.
You will have to pay process fee.
Second time, my lords.
Non-compliance. Suit was dismissed when petition was dismissed.
No, my lords. I have filed the IA for bringing legal aids, my lords. They are already come on record.
Other mail office objections.
They are already come on record, my lords.
They have already come on record.
Please. Last date of
Notice was issued.
No, my lords. The council has appeared and
Yaro?
to file wakalat, my lords. They are already filed wakalats.
Notice was not ordered because office objections were raised.
Please, my lords.
ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ?
Pushpalata, respondent number 4A5611A.
How did it come? Retake it.
Eight, seven.
ಏನಮ್ಮ ಮೂರ್ ಜನದ್ದು ಸೇರಿಸಿ ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹಾಕಿದೀರಾ? There are 3 deceased persons, respondents, and you have filed one application in respect of all the 3. ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ. That is the office objection. A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on the unserved respondents. Next para. Learned counsel, however, points out from the cause list that learned counsel Ms. Pushpalata Y has filed wakalat on behalf of the proposed respondents in IA number 1 of 2024. Full stop. However, there is no representation on behalf of the proposed respondents. Full stop. It is noticeable that no notice has been ordered by this court in respect of IA number 1 of 2024. Full stop. Next para. Release this matter
One submission.
on 3rd of September.
Submission.
Full stop.
They have issued a Shukas notice, my lords. A miscellaneous petition was filed before the trial court. In respect of that, they have issued a Shukas notice to deposit the compensation amount before the trial court, my lords. A suit for partition was filed, my lords. There is urgency, my lords. Kindly have it on next week, my lords. They have issued
Show cause
Shukas
notice?
notice, my lords.
Yenamma?
They have issued the Shukas notice on 11/7, my lords.
Show cause notice.
My lords, suit for partition, my lords.
Ah.
They have filed the IA for deposit the compensation amount before the trial court, my lords.
Your
This suit schedule property was acquired by the National Highways, my lords. National Highways.
So you have received the compensation.
I have.
So you are directed to redeposit it.
These lords. They have filed the IA for
Yes.
deposit, my lords.
Yes.
That was challenged before this honorable court, my lords. I have not deposited the amount, my lords. So that they have filed the miscellaneous petition and
Yes.
in that, my lords, they have issued the Shokas notice, my lords.
Yes.
Interim order is not,
You are required to deposit.
no, my lords, there is dispute, my lords, regarding the share of the.
Correct, madam. That will be decided. But you can't say, no, I am not going to deposit it.
No, my lords, the entire
Have to
amount
deposit.
was not received by me, my lords.
So you can say so. You should have filed objections to that one and said, no, I have received only so much and I will deposit only so much. What is the amount that you have received? What have you stated in your petition? The petitioner has received compensation amount of rupees 32 lakhs.
Please.
So you would deposit 32 lakhs then. See in paragraph number 10.
The respondent number 16 deposited the amount of 6,37,000.
Respondent, we are not concerned about respondent number 16. We are concerned about you. If you have made a statement that you have received 32 lakhs, then you will have to redeposit 32 lakhs.
Kindly have it on next week, my lord, sorry.
Next para. Learned counsel for the petitioner, however, submits that the petitioner has made a statement in the memorandum of petition that the petitioner has only received rupees 32 lakhs, while the direction by the court is to deposit rupees 78,82,595. Full stop. Next para. The petitioner is permitted to deposit rupees 32 lakhs in terms of the admission made before this court. Yes.
Number 30, Srinivas V.
Yes, sir. Lord, I received the early hearing application by RPD, what my learned friend have sent. His objection is that, my lord, he has not sent RPD acknowledgement hakila ant heli. I have received he has filed the early hearing application, I have received it, my lord.
Yes.
Lord, I am ready, my lord.
Learned counsel for the petitioner submits that he has received copy of the
Early hearing application.
Yes, you can hear, sir, please.
Yes, I will. May, my lord.
Deliver agide, sir.
a copy of IA number 1 of 2020.
Yes, sir. Served.
Yes.
Lord, in this case, the petitioner have called in question the grant of temporary injunction, my lord. Now, my lord, may I take your lordships to the paragraph, page number 18, my lord, that is the plaint, prayers in the plaint, my lord.
Suit for?
Suit for injunction.
Nimsha, sir. I will address.
Yes, sir.
Thereafter, you can
You are
address.
defendant number 1.
Yes, my lord, I am defendant number 1. My lord, the suit for injunction, mandatory injunction, without seeking any declaration and without seeking easementary rights, nothing, my lord. It's a bare suit for injunction seeking a mandatory injunction. May I just read the prayer for a while, bro? Page number 18 of the plaint. ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಅಂದರೆ ಗಾಡಿ ಜಾಡಿಗೆ ಯಾವುದೇ ತಂಟೆ ತಕರಾರು ಮಾಡದಂತೆ ಶಾಶ್ವತ ಪ್ರತಿಬಂಧ ಮಂಜೂರು ಮಾಡಿ ಹಾಗೂ ಉಳುಮೆ ಮಾಡಿ ಕಬ್ಬನ್ನು ನೆಟ್ಟಿರುವ ಪ್ರದೇಶ ಪೇಜ್ ನಂಬರ್ 18 ಇನ್ ಅನೆಕ್ಷರ್ ಎ ಪ್ಲೇಂಟ್ ಪ್ರಾರ್ಥನೆಯಲ್ಲಿ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಅಂದರೆ ಗಾಡಿ ಜಾಡಿಗೆ ಯಾವುದೇ ತಂಟೆ ತಕರಾರು ಮಾಡದಂತೆ ಶಾಶ್ವತ ಪ್ರತಿಬಂಧಾಜ್ಞೆ ಮಂಜೂರು ಮಾಡಿ ಹಾಗೂ ಉಳುಮೆ ಮಾಡಿ ಕಬ್ಬನ್ನು ನೆಟ್ಟಿರುವ ಪ್ರದೇಶವನ್ನು ತೆರವುಗೊಳಿಸುವಂತೆ ಹಾಗೂ ರಾಜ್ಯ ಹೆದ್ದಾರಿಯಿಂದ ಜಾಡಿಗೆ ಒಳಹೋಗುವ ಮುಂಭಾಗದಲ್ಲಿ ಅಡ್ಡವಾಗಿ ನಿರ್ಮಿಸುವ ಬೇಸ್ಮೆಂಟ್ ಅನ್ನು ತೆರವುಗೊಳಿಸುವಂತೆ ಸರ್ವೆ ನಕಾಶೆಯಲ್ಲಿ ತೋರಿಸಿರುವ ಗಾಡಿ ಜಾಡನ್ನು ಅತಿವೇಗದಲ್ಲಿ ತೆರವುಗೊಳಿಸುವಂತೆಯೂ ಮತ್ತು ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ನಕಾಶೆಯಲ್ಲಿ ತೋರಿಸುವಂತೆ ಗಾಡಿ ಜಾಡಿನ ಪ್ರದೇಶವನ್ನು ಸರ್ವೆ ನಂಬರ್ 16 ಮತ್ತು 49 RTC ಖಾತೆಯನ್ನು ಗಾಡಿ ಜಾಡಿನ ಪ್ರದೇಶವನ್ನು ವಿಭಜಿಸಿ ಈ ಗಾಡಿ ಜಾಡಿಗೆ ಪ್ರತ್ಯೇಕ RTC ಖಾತೆಯಲ್ಲಿ ಬರುವಂತೆ 3ನೇ ಪ್ರತಿವಾದಿನಿಗೆ ನಿರ್ದೇಶನ ನೀಡಿ 1ನೇ ಪ್ರತಿವಾದಿಯು ಉದ್ದೇಶಿತ ಕಾರ್ಖಾನೆಯನ್ನು ಸಂಭವಿಸುವ ಅನಾಹುತಗಳು ತಡೆಯಲು ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳುವಂತೆ ಯಾವುದೇ ಕಾರ್ಖಾನೆಗಳು ನಡೆಸದಂತೆ ಶಾಶ್ವತ ನಿರ್ಬಂಧಾಜ್ಞೆ ನೀಡಿ ನ್ಯಾಯಾಲಯದ ಖರ್ಚು ಹಾಗೂ ಇನ್ನಿತರ ಸಂದರ್ಭ ಪ್ರಕಾರ ನೀಡಿ ದಾಖಲೆ ಮಾಡುವಂತೆ ಕೋರಿಕೊಳ್ಳಲಾಗಿದೆ. Now, my lord, the allegation in the plaint is that, my lord, he is the owner of the plaintiffs are the owners of adjacent lands. The petitioners, they have constructed one scent factory and he has put up a compound wall. That is the allegation. Perfume. So that is the allegations in the plaint, my lord. Now, my lord, your lordship may kindly come to the annexure B, my lord, which is the temporary injunction application. My lord, may I read, my lord?
Early page number?
Page number 22, my lord. Annexure B. ಈ ಕೂಡ ಲಗತ್ತಿಸುವ ಕಾರಣಗಳಿಗಾಗಿ ಅರ್ಜಿದಾರರು ವಾದಿಗಳು ಕಳಕಳಿಯಿಂದ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯವು 1ನೇ ಪ್ರತಿವಾದಿ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಗಾಡಿ ಜಾಡಿಗೆ ಓಡಾಡಲು ಅಡ್ಡಲಾಗಿ ಹಾಕಿರುವ ಗೇಟನ್ನು ಮತ್ತು ಅದರ ಬಳಿ ನಿರ್ಮಿಸಿರುವ ಕಟ್ಟೆಯನ್ನು ಮತ್ತು ಗಾಡಿ ಜಾಡಿನಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ನೆಟ್ಟಿರುವ ಕಬ್ಬನ್ನು ಕೂಡಲೇ ತೆರವುಗೊಳಿಸುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಿ ತಾತ್ಕಾಲಿಕ ನಿರ್ಬಂಧಾಜ್ಞೆ ಆದೇಶ ಮಾಡಬೇಕಾಗಿರುವುದು ನ್ಯಾಯ ಮತ್ತು ಸಮಾನತೆ ದೃಷ್ಟಿಯಿಂದ ಅತ್ಯಗತ್ಯವಾಗಿರುತ್ತೆಂದು ಕಳಕಳಿಯಿಂದ ಪ್ರಾರ್ಥಿಸುತ್ತೇನೆ. Now, my lord, this is a mandatory injunction again. This is not for protection of the property. It is the relief prayed in the main prayer and the interim prayer are one and the same. My lord, the mandatory injunction have been sought without seeking any declaration. And my lord, he is also seeking a temporary mandatory injunction. Now, my lord, he makes an allegation that Tahsildar has given a report that Gadi Jadi ittu anta heli. Now, my lord, he has approached the Tahsildar also. And my lord, though these documents were produced before the trial court, the trial court have not appreciated. It was produced by him, not by me, my lord. May I just pass on the photographs of the property in question and also order passed by the learned Tahsildar, my lord. My lord, these are the photographs. And my lord, Kabbu barta ideyalla suma gadi. That is the petition respondent's vehicle, gadi barta iradu. And this is the main road, my lord. This is a layout. A layout have been formed and he is going out through the layout. This is a public road.
Who has formed the layout?
My lord, one adjacent landowner,
he is the close relative of these respondents, that is the plaintiffs before the trial court. He has formed the layout, and in his road they don't want to travel. They want my land, my lord. Your lordship may kindly see. This is the road what he is approaching. ಗಾಡಿ ಬರ್ತಾ ಇದೆ ಆಚೆ, ಇಲ್ಲಿ ಲಾರಿನೂ ನಿಲ್ಲಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಲೇಔಟ್ ಇಂದ ಆಚೆ. ಆರಾಮಾಗಿ ಕಬ್ಬಿನ ಗಾಡಿ ಓಡಾಡ್ತಾ ಇದೆ ಅಲ್ಲಿ. ಯಾವುದು ರೋಡ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಅವ್ರಿಗೆ. There is an alternative road. Now, my lord, with the same prayer, they have approached the Tahsildar on 31/20/23. My lord, your lordship may kindly see the representation. And my lord, the endorsement is also there. My lord, may read, my lord, ಗಾಡಿ ಜಾಡಿಯನ್ನು ಅತಿಕ್ರಮಿಸಿರುವ ಬಗ್ಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ತಹಸೀಲ್ದಾರ್ಗೆ. Thereafter, my lord, endorsement, I will take your lordships to the endorsement directly, my lord, because the prayer will be one and the same. Endorsement, my lord. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಮನವಿಯನ್ವಯ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಲ್ಲಿ ಉಪ ತಹಸೀಲ್ದಾರ್ ಬೆಳಗೊಳ ಹೋಬಳಿ ಹಾಗೂ
ಪೇಜ್ ನಂಬರ್
ಅಲ್ಲ ಇವಾಗ ಕೊಟ್ರಲ್ಲ
ಅದರಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ. ದಿಸ್ ಇಸ್ ಯುವರ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಆಯ್ತು, ನೀವು ಇದರಲ್ಲಿ ಯಾವ ಪೇಜ್ ಮಾಡಿದೀರಾ ಅಂತ.
ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ರಿಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಓಕೆ.
You did not give this copy to him?
ಸರ್ ನಮ್ಮ ಹತ್ರ ಇದೆ ಸರ್. ವಿ ಹ್ಯಾವ್
ಲಾಸ್ಟ್ ಪೇಜ್ ನೋಡಿ
ಸರ್.
ಬರೀ photos
ನಮ್ಮ ಸೆಲ್ಫ್ ಫೋಟೋ ಸರ್. ಇದು ನಾಟ್ ಗಿವನ್ ಬೈ ಅಸ್, ಬೈ ಹಿಮ್.
I think last time. Yes. May just read the endorsement and I'll pass it on to my friend also, because this was the document produced by them, not by me, my lord. This document they have relied upon. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಮನವಿಯನ್ವಯ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಲ್ಲಿ ಉಪ ತಹಸೀಲ್ದಾರ್ ಬೆಳಗೊಳ ಹೋಬಳಿ ಹಾಗೂ ತಾಲೂಕು ಭೂಮಾಕರು ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕುರವರಿಗೆ ಬಿ ಅಗ್ರಹಾರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಜಮೀನುಗಳಿಗೆ ಗಾಡಿ ಜಾಡು ಇದೆಯೇ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬುದರ ಬಗ್ಗೆ ಜಂಟಿ ಕಾರ್ಯಾಚರಣೆ ಮೂಲಕ ಅಳತೆ ಕಾರ್ಯ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ತಾಲೂಕು ಭೂಮಾಕರು ಸೋನ್ಸೋ ಜಂಟಿ ಸ್ಥಳ ತನಿಖಾ ವರದಿ ಸ್ಥಳ ಸ್ಕೆಚ್ ಸಹಿತ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಸ್ಕೆಚ್ನಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಹಳದಿ ಬಣ್ಣದಿಂದ ಗುರುತಿಸುವ ಪ್ರದೇಶ ಹಾಲಿ ಸ್ಥಳದಲ್ಲಿ ಗಾಡಿ ಜಾಡು ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಹಾಲಿ ಸ್ಥಳದಲ್ಲಿ ಇದ್ದು ಬಿ ಅಗ್ರಹಾರ ಸಂಬರ್ ಉಪಯೋಗಿಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ನೀಡಿರುವ ಕ್ರಮ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಪಾಲಾಳಿಗೆ ಸೇರಿದ ನಂಬರ್ದಲ್ಲಿ ದನ ಕರು ಗಾಡಿ ವಗೈರೆ ತಿರುಗಾಡಲು ನಾವು ಬಿಟ್ಟಿರುವ ಪ್ರದೇಶದಲ್ಲಿ ನೀವು ಸಹ ಉಪಯೋಗಿಸಿಕೊಳ್ಳುವ ಅವಕಾಶವಿರುತ್ತದೆ ಎಂದು ನಮೂದಿಸಿರುತ್ತದೆ. ಹಾಗೂ ಈ ದಾರಿ ಬಗ್ಗೆ ಇಲ್ಲಿ ಲಾರ್ಡ್ ಐ ವಿಲ್ ಟೇಕ್ ಎಂಫಸಿಸ್ ಆನ್ ದಿಸ್. ಹಾಗೂ ಈ ದಾರಿ ಬಗ್ಗೆ ಸರ್ವೆ ನಕ್ಷೆ, ಮೂಲ ಟಿಪ್ಪಣಿ, ಹಿಸ್ಸಾ ಟಿಪ್ಪಣಿ, 2ನೇ ಪ್ರತಿ ದಾಖಲೆಗಳಲ್ಲಿ ಗಾಡಿ ಜಾಡು ಬಗ್ಗೆ ಖರಾಬು ದಾಖಲು ಇರುವುದಿಲ್ಲ ಎಂಬ ಮಾಹಿತಿಯನ್ನು ತಿಳಿಸಲಾಗಿದೆ. My lord, this report is also got up by them. Why he made this statement is this ಗಾಡಿ ಜಾಡು ಅವ್ರು ಏನ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಗಾಡಿ ಜಾಡೇ ಇಲ್ಲ. Now, my lord, their main contention is that in 1957 a sale deed was executed in their favor, and in that he mentions that there is a ಗಾಡಿ ಜಾಡು. ಅದ್ರಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹಾಗಾಗಿ ನಮಗೆ ಗಾಡಿ ಜಾಡ್ ಬಿಡಿ ಅಂತ. ಇವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಹೇಳಿರೋದಕ್ಕೆ ನಮಗೆ ಗಾಡಿ ಜಾಡ್ ಬಿಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೇಳ್ಕೊಂಡು they have filed this, my lord. And this is the document. This is what I wanted to demonstrate before your lordship, that there is no document in the survey records that ಗಾಡಿ ಜಾಡ್ ಇದೆ ಅನ್ನೋದಕ್ಕೆ. And this is the clear cut endorsement. Now, my lord, the trial court and both the courts didn't appreciate. My lord, both the courts have failed to appreciate that the main prayer and the interim prayer are one and the same. Mandatory injunction, temporary injunction ಕೊಟ್ಬಿಟ್ರೆ temporary injunction what he is paying, my lord, suit ನಡ್ಸೋದೇ infructuous ಆಗೋಗುತ್ತೆ. Because by that time the suit completes, everything will be demolished. The question of me contesting the matter does not arise at all.
Which is the impugned order?
My lord, the impugned order, my lord, in both the courts, my lord, have allowed the application filed by them. My lord, annexure, page number 48 is the trial court's order, my lord. 41, my lord, 41 annexure E is the trial court's order.
So you contended?
Yes, my lord.
That there is no prayer seeking declaration?
Yes, my lord.
And without seeking declaration,
and
they are simply seeking a decree of mandatory injunction.
Mandatory injunction.
How is that considered?
My lord, it has not been dealt, my lord. The court, both the courts have not dealt with it at all. They only state that there is one, my lord, may I just take your lordships to the page number 61, paragraph number 42, my lord. On perusal, on perusal of all material particulars available on record, without going to the merits of this case, this court opines that at the stage prima facie plaintiffs to succeed the place on records with regard into existence of cart road or gadi radu in the suit property, which has been used by the villagers of Bommuru Agrahara village to reach out their agricultural lands in survey number 183, 184 and 185 since so many years. Even there is recital in the sale deed dated 21/1957 and 5/1/1957, our sale deed. With regarding to the leaving of the space in survey number 183 and 194, 193 and 194 for it to use as a road. If the said cart road or gadi jadu is blocked by fixing the gate and constructing basement and planting sugarcane on the cart road, it is going to cause obstructions to the villagers to use the said road to reach out their agricultural lands, which in turn cause irreparable loss and injury, which cannot be compensated through any means in future. Even the balance of convenience also lies in favor of the plaintiffs. Plaintiffs have made out grounds to consider yes, so and so, so and so.
Yes.
Now, my lord, the first appellate court, even before the first appellate court, my lord, the grounds have been raised in ground number 9, my lord, page number 67. Page number 67, ground number 9, I will read, my lord, even before the first appellate court.
67,
my lord.
Point number
9, ground number 9.
Hmm.
ಮಾನ್ಯ ಕೆಳ ನ್ಯಾಯಾಲಯವು ಸಿಪಿಸಿ ಕ್ರಮಾದೇಶ 39 ನಿಯಮ 1 ಮತ್ತು 2 ರೀತಿಯ ಪ್ರತಿಬಂಧಕ ನಿರ್ಬಂಧ ಆಜ್ಞೆ ಮಾತ್ರ ಮಂಜೂರು ಮಾಡಲು ಅವಕಾಶವಿದ್ದು, ಯಾವುದೇ ಆದೇಶಾತ್ಮಕ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಮಂಜೂರು ಮಾಡಲು ಅವಕಾಶವಿಲ್ಲದಿದ್ದರೂ ಮಾನ್ಯ ಕೆಳ ನ್ಯಾಯಾಲಯ ಪ್ರಶ್ನಿತ ಆದೇಶ ಮಾಡಿರುವ ಕ್ರಮ ಸರಿಯಲ್ಲ. So now, my lord, it's only a prohibitory injunction can be granted, my lord. Mandatory injunction at the time of under Order 39 Rule 1 and 2 cannot be granted. That was the contention, my lord. Now, my lord, even the first appellate court have not dealt with it in properly, my lord. My lord, the reasoning starts from paragraph number 7, page number 82.
Let us see the provisions contained in Rule 1 and 2 of Order 39. This application is filed under Rule 1 and 2.
Rule 1 and 2 of Order 39 Rule.
What are our CPC code?
May, my lord. Cases in which temporary injunction may be granted, where in any suit it is proved by affidavit or otherwise that any property in dispute is in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditor, that the defendant threatens or disposes the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal, or disposition of the property or disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in the dispute as the court thinks fit until disposal of the suit or until further orders. Now, my lord, this is the
Injunction to restrain. Petition or continuance of breach.
Yes, my lord. Danger of being wasted, damaged, or alienated. My lord, that is only preventing, my lord. They can only prohibit. It's all nature of injunction, temporary order in the nature of prohibiting doing something else. Now, my lord, here is a mandatory injunction permitting removing things which is already in existence.
Yes, sir.
Yes, sir. Illi two courts namma plaint na
There is no provision under Rule 1 and 2 to issue such a direction. That is the contention.
Yes. We will give a citation. We will give a
Citation ಏನ್ರಿ? Citation ಹೆಂಗ್ ಬರ್ಕೊಳ್ಳಿ. Learned Counsel. Sri Nagaraja B.
Yes, sir.
Has entered
For
appearance
R1 to R7.
for response number 1 to 7. You are the plaintiff.
Yes, sir. They are the plaintiff. Their plaintiff.
You are the plaintiff.
Yes, sir. Yes, sir.
The other response number 8 and 9 are co-defendants.
Co-defendants, my lord, they are taluk officers, my lord. that is.
Some
Yes,
individual person, sir, 8 individual person.
Is individual.
Individual,
Ah.
individual.
In Karnataka.
They know.
They are
sir.
defendant
We
number
don't.
2, co-defendant along with me. Not necessary, my lord, it may be dispensed. I'll file a memo to that effect.
Learned counsel, for the petitioner has filed a memo insofar as respondent number 8 is concerned, stating that respondent number 8 is a co-defendant. And no relief is sought against him in the present petition. Full stop. Therefore, dispensation of notice to respondent number 8 is sought. In full stop. Next para, at the risk of the petitioners, notice to respondent number 8 is dispensed with. Next para, learned AGA takes notice for respondent number 9. Learned counsel for the petitioner is directed to serve.
My lord, it is
sets of-
already dispensed. Notice is already dispensed on 29.
AGA
2020.
AGA serve ಆಗಿದೆ sir. AGA ಆಗಿದೆ, serve ಆಗಿದೆ. Everything is clear.
ತಗ್ಬಿಡಿ ಅಲ್ಲಿ. Dispensation notice ವರೆಗೂ ಇರಲಿ, ಅದಾದ್ಮೇಲೆ ತೆಗ್ದ್ಬಿಡಿ. At the risk of the petitioner, notice to respondent number 8 is dispensed with. ಅಲ್ಲೂರ್ಗೂ ಇರಲಿ, ಅದಾದ್ಮೇಲೆ ತೆಗ್ದ್ಬಿಡಿ. Next para. Learned counsel for the petitioners submits that in a suit filed at the hands of response number 1 to
7.
hearing, they have sought for permanent injunction and mandatory injunction to remove the sugarcane crop grown on the cart road. And to remove basement.
Basement. my lord.
Yes sir. ಅಲ್ಲಿ objection sir.
Basement.
Objection clear ಇದೆ sir.
Basement.
Basement. my lord. For establishing of ಇದು incense factory, scent factory.
Basement.
Basement.
Bari basement.
ಬರೀ ಬೇಸ್ಮೆಂಟ್. ಬೇಸ್ಮೆಂಟ್ ಅಂಡ್ ಗೇಟ್ ಇದೆ ಅಲ್ಲಿ ಅಷ್ಟೇ, ಇನ್ನೇನು ಮಾಡಿಲ್ಲ ನಾವು. We have not done, still it is a
Sir, ಅಲ್ಲಿ
sugarcane is there.
Basement and gate. Full stop. Learned counsel.
Marigold.
Learned counsel submits that without seeking declaration of the rights of the plaintiffs, the plaintiffs could not have made such a prayer. Full stop. It is further contended that in the interlocutory application,
Annexure B, page number 22. Same prayer.
filed under order 39 rule 1 and 2 of CPC, read with section 151. Direction is sought by the plaintiffs to the contesting respondents to remove the sugarcane crop,
Gate.
the basement and gate, which is similar to the main prayer. Full stop. The learned counsel would therefore submit that such a prayer could not have been granted by the trial court. Full stop. It is further contended that having regard to the provisions contained in rule 1 and 2 of order 39, the trial court could not have allowed the prayer or issued directions to the defendants, contesting defendants, to remove
Gate fixed at the entrance of the cart road.
the sugarcane crop, the basement and the gate fixed, since the provision does not permit the court to pass such an order. Full stop. What is permissible is grant of temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal or disposition of the property. Full stop. Next para. Learned counsel has made out prima facie case. Full stop. Accordingly, there shall be an interim order of stay of the impugned order.
Interim order
Status
already in
quo.
existence.
ಆಗಿದೆಯಾ?
Status quo vacate last date alle vacate ಆಗಿದೆ sir. Vacate ಆಗಿಲ್ಲ sir. Interim order was extended and it was adjourned for today. Adjourned ಅಷ್ಟೇ.
So matter has to be disposed of.
Matter has to be disposed.
Yes, sir.
It is only for disposal we have.
Last sentence ತಗ್ಬಿಡಿ. Next para. The learned counsel for the contesting respondents, namely respondents number 1 to 7, who are the plaintiffs before the trial court, seeks to justify the impugned order passed by the trial court as well as the first appellate court. Full stop. Next para. Having regard to the express provision contained in Rule 1 and 2 of Order 39, it would be impermissible for the court. Where is that impugned order?
Page numbers.
To have issued such a direction.
41. Court's
to
order is at
remove
63, my lord.
the gate fixed at the entrance of the cart road for Gadi Jadu and the basement constructed therein in the suit property, as well as the sugarcane plants planted on the cart road for Gadi Jadu. Full stop. Next para. The courts below have also erred in not considering the contentions raised by the petitioners or defendants regarding the maintainability of the suit insofar as the mandatory injunction is concerned, without seeking a declaration of the title or rights of the plaintiffs in that regard. Full stop. Next para. Accordingly, the writ petition is allowed. The impugned orders dated 2/11/2023 on IA number 6 in OS number 97 of 2023 and order dated 8/2/2024 in MA number 14 of 2023 are hereby quashed and set aside. The applications filed in
OS number.
IA number 6 under Order 39, Rule 1 and 2. Rule 1, read with Section 151 of CPC, is accordingly rejected.
Much.
Yes.
Number 31,
But appear on.
Petitioner in this case, all the office objections were complied in the last date of hearing. We are not sure of what other office objections.
Thank you.
My lords, if I could make a submission, my lords, I am appearing for respondent number 10, my lords. I have received instructions. I'll be appearing for the contesting respondent. That is respondent number 10. My lords, this is a suit for specific performance. Court issued notice, the trial court issued notice, and we are now before my lords, my lord.
What has happened, my lord, is only on the basis of notice, saying that since their application for injunction is not considered, so they have filed this writ petition, and there is an interim order granted that the respondent number 10 should not, or the respondent should not alienate. However, liberty was granted for the respondents to file an application for vacating. So they also want to file an application for vacating. And my lord, the matter is listed in the trial court on 25/9. If your lordships, my lord, could have it next week, my lord, we would.
No, that application is still not considered.
Is not considered.
Therefore, we'll issue a direction to the court to consider the application.
Yes, if your lordships, my lord, then my only request is, since the matter is listed on 25/9, and our only thing is that once this court, my lord, even once if it says that they should not alienate, though if your lordship says it should not be influenced, their apprehension is that the court will be influenced by the order of this honorable court, and then.
No, we'll say because there is no reasons.
No reasons have been granted.
Therefore, we will say that the application shall be considered.
And my lord,
until orders are passed.
The interim order to continue. Yes.
This order will continue.
Please,
that's it.
Yeah, yes, my lord, my two requests for that, my lord. One, though, my lord, it is listed on 25/9. May I request your lordships, my lord, that to fix a date, since both of us are there on an earlier date, and your lordship may fix a time frame for them to decide. And other request is, my lord, that without being influenced by Lord, may I request, my lord, one matter is reaching.
Yes.
Public.
Although matter is coming up in orders list. Come on. And with the consent of the learned counsels on both the sides, the matter is taken up for final disposal. We'll stop. Next para. The petitioner, plaintiffs are before this court contending that the trial court did not pass orders on the application filed under Order 39 Rule 1 and 2 for an ad interim temporary injunction, ex parte temporary injunction. Full stop. However, this court, by order dated 4/3/2024, directed the parties not to alienate, encumber, and or create third party rights over the suitable property till the next date of hearing. Full stop. Liberty was also reserved to the respondents to seek vacation or modification of the order. Full stop. Next para. Learned senior counsel Shri Gurudas Kannur appearing on behalf of
respondent number 147.
Respondents number 1, 4 and 7. And learned counsel
Mr. Abhilash Raju.
Shri Abhilash Raju
For R10.
appearing for
Respondent number 10.
respondent number 10.
Please.
Submit that the trial court may be directed to consider the application filed by the plaintiffs under Order 39 Rule 1 and 2 within a specific time frame. Full stop. Next para. Accordingly, the writ petition stands disposed of with a direction to the learned senior civil judge and JMFC, Devanalli, to consider IA number 1 of 2024 filed by the plaintiffs in OS number 30 of 2024 on the next date of hearing and pass orders as expeditiously as possible without wasting any further time. Full stop. Next para. The matter in OS number 30 of 2024 is directed to be listed before the learned senior civil judge and JMFC, Devanalli on 2nd of September 2024. Full stop. The parties are also directed to appear before the court on 2nd of September 2024, without waiting for any further notice. Full stop. The learned senior civil judge shall consider IA number 1 of 2024, hear the parties and thereafter proceed to pass orders on the said application. Full stop. Orders shall be passed within a period of 2 weeks from the date when which the submissions are heard on behalf of the learned counsels for the parties. Full stop. Next para. Till the learned senior civil judge considers and passes orders on IA number 1 of 2024, the interim directions issued by this court that the parties shall not alienate or encumber or create third-party rights over the suit schedule property shall continue. Full stop. Needless to also observe that the application shall be considered on merits and the directions issued by this court shall not influence the learned senior civil judge. Yes.
The order,
Grateful.
that's right. My lord, the order, impugned order may be set aside.
It's which order?
We are challenging that impugned order 27/1/2024, where the order doesn't record anything with respect to IA number 1.
Correct. It is not considered. That is why we are directing that to be considered. Yes.
32, VP Kumar.
I appear for petitioners, my lord. Kindly pass over, my lords.
For what, madam?
Let's address the argument.
You are required to take steps.
Kindly pass over, my lords.
Huh? ಏನಕ್ಕೆ 2 to 6 learned counsel for petitioner has filed a memo dated 1/7/2024 seeking dispensation of notice to respondents number 2 to 6. Since no relief is sought against respondents number 2 to 6.
Yes.
Stop. At the risk of the petitioners, notice to respondents number 2 to 6 is dispensed. Yes.
But only one aspect, not the document is ordered to be impounded. But the date of the document is 11/8/1995.
95.
95.
What document is it?
It's a Palupatti.
Palupatti.
The learned judge impounds it on the ground of non-payment of stamp duty. The provisions of section 46A is now amended. And 46A, a recovery insofar as stamp duty is concerned, but is not available.
What is? ಏನ್ರಿ ಇದು
46 capital A.
ಇಟ್ಕೊಡ್ರಿ ಸ್ಟಾಂಪ್ ಆಕ್ಟ್.
Stamp Act.
46A, section
Yeah.
46A.
46A. But that provision came to be amended. This is what is read, where any instrument chargeable with duty has not been duly stamped, Chief Controller, Revenue Authority, or any other officer authorized with the state government, herein referred to as authorized officer, may within 5 years. It's now it is amended, it's 5 years. From the date of the commencement of the Stamp Act, Amendment Act, or on the date on which the duty became payable, whichever is later, serve notice on the person on whom duty was payable, requiring him to show cause why proper duty or amount required to be make up the same should not be collected from him, provided
See,
that
this
where-
has been clarified.
Yes.
By the division bench in Digambar Varti. This applies to case where the documents is compulsory registrable.
Yes.
It does not apply to a document which need not be registered.
Yes, that's all what is.
Ah.
Therefore, he could have allowed me to mark the document.
No,
Marking is
no,
refused.
this provision.
Yes.
You cannot invoke. See, if it is a compulsory registrable document and there is a short levy.
Yes.
You please see this. Recovery of stamp duty not levied or short levied.
Yes.
That is why the division bench has clarified. This would apply to compulsory registrable documents.
Yes.
There may be many other documents which is not compulsory registrable.
Exactly.
In respect of those documents, the court has still got power to impound them and levy the stamp duty and collect the penalty. You are saying this is a palpati.
Yes.
It's not a compulsory registrable document according to
Exactly.
you. But even without the document needing registration, does it require any stamp duty to be paid?
But that's the only point.
Ashta.
The learned judge could have gone into that aspect. He could not have impounded it at threshold. Mere on confrontation.
Yes, what do you say?
Lord, the learned judge, my lord, while observing that, my lord, the document is a compulsorily registrable document. Considering the same, the determination of duty and penalty on the said document, the same is impounded in page number 15.
Page 15. Okay.
Page 15.
Where is the document?
The document is produced before the court at page 49.
In page number 49, annexure E.
Vibhaga Patra.
Vibhagada Palupatti.
Houdu.
This is not
between the two brothers.
If it is a partition, then it will become a compulsory registrable document.
But aspect has to be.
It is not recording of a past event.
But it's a past event that was taken consideration.
You please point out.
But that's not a word insofar as this document is concerned. Only aspect that may have to be gone into, you could have taken it, at least considered it at the time of arguments, whether there is a division between the two brothers or there is no division. Instead of impounding at threshold.
This document cannot be looked into at all.
But
if it is a compulsory registrable document, it is not registered.
That's an aspect, but at the time of confrontation, she admits the signature. That's the only reason for which it was confronted. But when I produce it in the course of my evidence, but that aspect could have been gone into by the court. At the stage when it was sought to be confronted. But kindly look at the order.
Yes.
Document which is confronted to the witness, in which the witness identifies the signature of her brothers, he is styled as Vibhaga Palupatti on 11/8/95. On perusal of the contents of the said document, under the document, parties herein have partitioned the properties mentioned therein and taken the possession. The said document is prepared on a stamp paper of so and so. Therefore, on confrontation, it is done. I only wanted the signatures to be taken consideration.
You please go through this judgment in Digambar Party.
There is afterward, there is one more judgment of our High Court also. AIR online, Karnataka, page 282. That is
ಯಾವ party?
2022.
Name of the party so that he'll also come prepared.
Please, I'll give the name
Huh?
also. Yes, please.
Please go through that and there is one more judgment of the Supreme Court,
Yes,
2024.
24. I've seen that.
Huh?
Yes.
ಅದನ್ನು ನೋಡಿ, you please pass on the citation.
Please, madam.
Both of you come prepared to argue the matter.
Only thing is, not the case is pressurized for cross-examination for that.
Release this
Yes.
matter on 29th of August.
Please.
Full stop. Till the next date of hearing. The trial court is directed not to precipitate the matter.
Please.
Yes.
33. Petition GS.
Lord, this matter has been, matters before the court on counsel submissions, my lord. The, Lord, on counsel submission, this matter is posted before this honorable court, my lord. The office
Petitioner
objection-
not party in FTP petition.
Yes, my lord.
To be clarified.
Yes, my lord.
You have filed an application.
No, my lord.
Huh?
Your lordship, may kindly see the FTP petition is at annexure G, my lord. Annexure G at page number. For a moment, my lord. Page number 96, my lord.
Yes.
Lord, in this FTP petition, my lord, my mother was arraigned as respondent number 5, my lord. Gauramma, major. In fact, she had already died when this FTP petition itself was filed. And the death certificate is at annexure E, my lord. Your lordship, may kindly see at annexure. Annexure E, page number 89, my lord.
2016.
In 2016 itself, my lord. During the pendency of the suit itself, my lord, my mother had died, my lord. And that aspect was not brought to the court notice at all. And judgment was passed.
Suit for?
Suit for partition, my lord.
Partition?
Yes, my lord.
All family members?
All family members, my lord. In the absence of my mother, my lord, since your lordship may kindly see, initially there was already a partition with annexure A, and this in respect of suit schedule properties, the petitioners and their mother were held as entitled to half share in the suit schedule properties at annexure A, my lord. Annexure A, page number 19, my lord.
56 of 1996.
Yes, my lord. There was already a partition, and petitioners herein and their mother were entitled to half share in the suit schedule properties, my lord.
Manjunatha.
Yes, my lord. They were minors then.
Manjunatha.
Nandisha, Gauramma.
Gauramma.
Yes, my lord. Petitioner number, plaintiff number 1 and 2 herein are the petitioners in this case, my lord.
Represented by
Mother.
Natural Garden Mother Gauramma.
Yes, my lord. There was already a partition.
Filed only against Shivanna.
Yes, my lord. Uncle.
Shivanna.
Shivanna, uncle.
Huh.
Lord, subsequently, this was challenged, my lord. Even in the RA, my lord, this order was set aside, was upheld, my lord. RA is at annexure B, page number 36, my lord. I was entitled to a half share in the suit schedule properties, my lord. Subsequently, my lord, another suit came to be filed seeking for declaration and injunction by one Mahadevaya, my lord. In respect of the very suit schedule properties, this was also dismissed, my lord.
Same plaintiff.
Yes, my lord.
Mahadevaya, son of late Puttaya.
Yes, my lord.
This FDP is arising out of this suit.
No, my lord. Subsequently,
209 of 2008.
Not 209, my lord.
Declaration and consequential relief of injunction.
Yes, my lord. Even
against Shivanna and Gauramma.
Yes, my lord. Not 209, my lord. OS number 290, my lord. Which is at annexure D, page number 73, my lord. Annexure D. This FDP is arisen out of OS number 290 of 2015, my lord.
209.
290, my lord. 290, annexure D, page number 73, my lord.
Mahadevaya.
Yes, my lord. And my mother was arraigned as defendant number 5, my lord, which is page number 4.
The suit was filed in the year 2015.
Yes, my lord. 2015, my lord.
Gangamma, Gauramma,
Shivrudraya, Suvarnamma, and Gauramma. That is defendant number 5, my mother, my lord. My mother had, during the pendency of the suit itself, my lord, on 3/10/2016, had died, my lord.
And this judgment was passed in the year 2018, my lord, without bringing the legal representatives on record, my lord. And I was not at all aware of the suit proceedings at all, my lord. After this judgment, my lord, I had filed regular appeal before the appellate court, my lord. That RA was also pending, my lord. And without making me as a party, my lord, by arraying my dead mother as a party, FDP proceedings was instituted, my lord. And in the FDP, my lord, they filed compromise petition before the Lok Adalat, and the Lok Adalat court accepts the compromise petition, my lord. And I have challenged that fraudulently entered compromise petition before the Lok Adalat, my lord. Your lordship may kindly see annexure H, my lord. Annexure H at page number 99, my lord. Page number 99, my lord. This is the compromise petition that was filed before the Lok Adalat court, my lord. And the Lok Adalat court, by its order dated 11/2/2023, which is at annexure J, my lord, 103, and relevant page is at page number 113, my lord. For a moment, your lordship may kindly see 113, my lord. The Lok Adalat court accepts this compromise petition and directs the office to draw decree as per the compromise petition filed before the Lok Adalat court, my lord. Now, without making me as a party to the full FDP, my lord.
Where is the division? What is the manner in which it is divided?
Lord, the compromise petition is filed at annexure page number 99, my lord.
99,
my lord. Without allotting any share to me, my lord, this FDP.
That is your mother.
My lord. Yes,
your
my lord.
mother.
Yes, my lord. My mother, my lord.
Gauramma.
Yes, my lord. And by making dead person as a party to the FDP, and even the FDP court, my lord, Lok Adalat court, my lord, without taking into consideration all the parties to the FDP proceedings are also not before the court. It allows the FDP to be this thing compromise petition to be accepted by the court, my lord. And my lord, on the basis of this compromise decree, my lord, they have already initiated.
Also, it is true that a compromise petition entered before the Lok Adalat can be questioned only by filing a writ petition.
Yes, my lord.
But that would apply to the parties to the proceedings. In case the person is not a party to the proceedings, then what is the avenue?
Not that aspect has to be pleaded before the writ petition court only.
No. You will have to approach the same court which has drawn the compromise decree.
No, my lord. On this very point, my lord, this honorable court, Justice Srishananda's judgment is there, my lord.
What is it?
I'm handicapped on one copy, matra. Last operative portions, my lord, last page, my lord, last probably 4 or 5 paragraphs, my lord. In fact, the order passed by the appellate court was set aside, and the parties were directed to approach the High Court in the writ jurisdiction, my lord, seeking cancellation of the compromise petition that is fraudulently entered.
That's what I said. There is no doubt that only a writ petition can be filed. But then that would pertain to the parties who are before the court. They cannot file another suit. And a compromise, though, can be questioned on the ground of fraud. But then again, that cannot be questioned before the same court. You can file only a writ petition. That is the law laid down. There is no doubt about that.
Fraudulently entered,
But,
my lord. I am having no other remedy at all, my lord. Now,
sir, you can simply say the compromise decree has been obtained, although they knew that Gauramma was dead, and without bringing the LRs on record, the compromise has been entered into. But having regard to the bar found in Rule 3A of Order 23, that no suit will lie. Please see the provision.
and in addition to that, my lord, if a matter has been settled before Lok Adalat, my lord, no suit proceedings can also lie against the
Correct.
judgment.
Adana ಹೇಳಿದೆ ನಾನು ಸ್ಟಾರ್ಟಿಂಗ್ ಅದೇ ಹೇಳಿದೆ.
Yes, my lord.
That is the law laid down. But that would apply to the parties who have entered into the compromise. That would not apply in a case where the person is not a party to the compromise. You are not a party to the compromise petition.
Not a party, my lord.
So therefore, whether that principles would apply in your case is the question. Has it been considered in this writ petition, this petition? Has it been considered here?
In fact, he was a party, my lord, in that writ petition, my lord. He was a party.
Therefore,
He was
that
impersonated.
law is laid down already. That only by filing a writ petition you can challenge it. But the question here is, you are not a party to the compromise petition.
I'm not a party, my lord.
Then rule 3A would apply.
I have to go before the same court.
Yes.
Your lordship may kindly see, I have also filed after, if your lordship kindly see, after page number 115, my lord, that is the order sheet of the FTP, my lord. After 115, your lordship may kindly turn to 116 of my compilation, my lord, 116. I have made an application before the same FDP court saying that we were not made parties also and my mother was already dead. Now the FDP court is saying now the proceedings are already terminated. FDP is no longer remaining. So it has only issued notices and it is just going like that, my lord. Even FDP court is also not taking any action. And my lord.
So you could have questioned that order. An order has been passed?
No order has been passed, my lord. It has only issued notice and nobody is appearing before the court. And FDP court is expressing opinion saying that since FDP proceedings are already over.
It has issued notice.
It has issued notice, my lord.
Then they will have to appear then.
And on the basis of this FDP decree, my lord, and on the basis of this FDP decree, my lord, they have fraudulently made application before the revenue authorities and getting the kata changed to their name on the basis of this FDP proceedings, my lord. I have also sought for stay of the order accepting the compromise petition, my lord. At least that may be granted, my lord. And my RA is also pending, challenging the said judgment, my lord. And the appellate court is expressing opinion saying that final decree is already drawn. Nothing survives in the
RA Barala, miscellaneous petition only is maintainable. RA cannot be maintained. And separate suit also cannot be filed.
And the matter is still pending before the FDP court, my lord. It has just issued notice. Though final decree is already drawn, my lord.
Decree that was passed in that 56 of 96.
Yes, my lord. Decree is
which are the suit schedule properties there?
It is the same scheduled properties, my lord. If your lordship turn to page number 48, my lord.
Page number 26.
Page number 26.
Survey number 29/1.
Same. Yes, my lord.
Survey number 8/1.
Same, my lord. It is renumbered, my lord, there now.
Guduvangatta. Guduvangatta village.
Guduvanagatta village.
Guduvanagatta.
Yes, my lord.
One day. There is only one survey number.
No, my lord. 24.5 guntas in survey number 29/10.
Measuring 1 acre 9 guntas, out of which.
And another 1 acre 5 guntas, my lord. In survey number 8/1.
ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ಇರೋದ್ರಿ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 8/1 measuring 2 acres 13 guntas, out of which
1 acre 5 gunta, my lord.
1 acre 5 guntas. So 29/1B and 8/1.
8/1, my lord.
ಯಾವ ವಿಲೇಜ್ ಅಂತ ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ. ಅದು ನಿಡುವನಘಟ್ಟನಾ?
ಗುಡುವನಘಟ್ಟ ಅಂತ ಇದೆ.
Where is this compromise petition?
Not compromise petition.
99.
99, lord.
(29/1B).
Now numbered as 29/10.
(28.08 guntas). (24.5 guntas).
Yes, my lord. And that 8/1 is renumbered as separate numbers, my lord.
What happened to that suit filed by Mahadevaya?
Suit for partition, my lord. That was partition is ordered in that case, my lord. OS number 290 of 2015, my lord. Annexure D, page number 73, my lord. Plaintiff and defendant number 3 are entitled to 2/5 share, which is at forthcoming at page number 84, my lord. Decree.
So your mother participated in the proceedings?
My mother was participating, my lord. She died in the year 2016. I was not at all aware about the suit proceedings. Legal representatives were also not brought on record. In the absence of my mother, my lord, against a dead person, this order has been passed. Pursuant to that, FDP was also filed, making my dead mother as a party. And there, leaving me, my lord, FDP compromise has been filed, and the same has been accepted by the Lok Adalat court, my lord. Now they have also received copy of the this thing.
Nim ತಂದೆಯವರ ಹೆಸರೇನು?
Shivanna, my lord.
ಶಿವಣ್ಣ?
Yes, my lord. Shivarudraya, my lord.
ಶಿವರುದ್ರಯ್ಯ.
Against both husband and wife, my lord. This case was filed, my lord. In fact, husband is not staying with me. He has developed all sort of illicit things and all, and he is not taking care of the family, my lord. He has sided with other family members.
You are defendant number 5.
Yes, my lord.
Gauramma.
Yes, my lord.
Wife of Shivarudraya.
Yes, my lord. After the death of the mother, children, that is the petitioners herein, are not made as LRs.
So you are not a party to the proceedings in 56 of 1996.
I was a minor then, my lord.
Yaru?
56 of 1996 ali Manjunath and Nandish. I am plaintiff number 1 and 2, my lord. Since we were minors, we were represented by mother, my lord.
But that was filed only against one person.
Against one person, my lord. Yes, my lord.
Shivanna?
Yes, my lord. And in this, the plaintiffs were ordered for a half share in the suit schedule properties, in this suit schedule properties, my lord. This was challenged. That was also dismissed, my lord. And in respect of the same property, suit for injunction and declaration was filed. That was also dismissed. Later, Mahadevaya filed suit for partition by arraying my mother as parties. During the life of this suit, my lord, my mother expires. We are not been arrayed as
notice to the respondents. The petitioners are also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondents before the trial court, which was considering the final degree proceedings. Next para. Learned counsel for the petitioners submits that the first respondent herein filed a suit for partition and separate possession.
In OS number 290 of 2015, annexure D 73.
In OS 290 of 2015. Common knowing fully well that in OS number 56 of 1996, a judgment and decree was passed by the learned additional civil judge and JMFC, Tiptur, declaring then that the plaintiffs herein are entitled for 1/2 share of the suit schedule property bearing survey number 29/1B measuring 24.5 kuntas and survey number 8/1 measuring 1 acre and 5 kuntas. Full stop. Although the suit was filed in the year 2015, the petitioner's mother, who was arrayed as defendant number 5, passed away
On 3/10/2016, my lord.
on 3/10/2016. Full stop. Nevertheless, the legal representatives were not brought on record, and the suit was decreed declaring that the plaintiff and the defendant number 3 are entitled for 2/5 share each in the suit schedule properties which are the same as the suit schedule property in OS number
56 of
1996. Full stop. Final decree proceedings were initiated in FDP number 25 of 2018. And during the course of the final decree proceedings, a compromise petition
By making dead Gaurama as party in FDP, my lord.
huh?
By making a dead Gaurama as party in FDP, my lord.
ಏನಿದೆ? Was filed by the parties knowing fully well that the petitioner's mother, Srimati Gauramma, who was defendant number 5 in the suit, was dead. Full stop. No share is allotted to the petitioners or their mother. ಲೋಕದಾಲತ್ ಆಗಿರೋದ ಇದು?
Yes, my lord. Before the Lok Adalat, the compromise petition was filed and then matter
Compromise
was
petition was filed before the Lok Adalat ಅಂತ. Full stop. Learned counsel submits that no sooner the petitioners came to know of the fraudulent act on the part of the respondents, the petitioners filed a regular appeal.
No, my lord. Regular appeal was filed even prior to that itself, my lord.
Huh?
Even prior to that, RA was filed, my lord, without knowing that FDP is also pending, my lord. They were prosecuting RA, my lord. RA was pending, my lord.
During
the
the FDP proceedings.
In the FDP proceedings, they have initiated FDP proceedings. In the FDP proceedings, they have entered into compromise, my lord.
RA was filed by whom?
We had filed RA, my lord.
So when did you come to know of this decree?
It was in 2019, my lord.
Huh?
In 2019, my lord, I have filed RA 4 of 2019.
Filed RA
4 of 2019, my lord.
4 of 2019.
challenging the judgment passed in OS number 290 of
and the regular appellate court
had just issued notice and it is still pending, my lord.
and the regular appeal is still pending consideration.
Yes, my lord.
Full stop. Nevertheless, when the petitioners came to know of the final decree proceedings and the compromise petition, a compromise decree passed in the Lok Adalat, the petitioners also filed an application before the trial court,
FDP court, my lord, same FDP court.
Trial court, which was considering the final decree proceedings. And the trial court has issued notice to the respondents. Full stop. The learned counsel further submits that taking advantage of the turn of events as stated herein above, the respondents are seeking to get the record of rights transferred in their name in terms of the fraudulent compromise decree
Entered in FDP.
Full stop. Next para. Although this court is of the opinion that the maintainability of the present writ petition will have to be considered, having regard to the express provisions contained in order 23 rule 3A and the fact that the petitioners are not parties to the compromise petition filed before in the during the FDP proceedings. Nevertheless, having regard to the predicament of the petitioners, directions are hereby issued to the respondents not to precipitate the matter any further in respect of the transfer of the in respect of the mutation entries in the record of rights, till the next date of hearing.
And my lord, order of the Lok Adalat dated 11/2/2023 may be stayed, my lord, wherein they have accepted the compromise petition, my lord. Order dated 11/2/2023 of the Lok Adalat court accepting the compromise petition may be stayed, my lord. If that is stayed, my lord, no revenue authorities will give effect, my lord.
ಅದನ್ನ ಇವಾಗ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. You please take a copy of this order and give it to the revenue authorities.
May I seek for hand delivery of the order, my lord?
Yes, yes.
Grateful.
Sir. Sir, serial number 50. Yeah, nice. 50. Najan agila.
Sir, 56 idena sir.
Adena.
Adena agila.
29. 39.
55, sir. 55.
Adena.
ಆನ್ಲೈನ್ ಲಾಗಿನ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. ಆನ್ಲೈನ್ ಟಿಕೆಟಿಂಗ್ ಲಾಗಿನ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ನಾಟ್ ರಿಕ್ವೆಸ್ಟ್ ಝೂಮ್
ಅದು ಇದು ಬರುತ್ತಲ್ಲ ನಿಮ್ ಇದ್ರಲ್ಲಿ ಅದು ಐಡಿ ಬಂದಿರುತ್ತೆ ನೋಡಿ ಅದು. ಅಡಿ ಈಗೇನು ಝೂಮ್ ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೊಡೆದ್ರೆ ಹೈಕೋರ್ಟ್ ಕೊಟ್ಬಿಟ್ಟು ನಿಮಗೆ ಕೇಸ್ ಬಂದಿದೆಯಲ್ಲ ನಿಮಗೆ ಮೆಸೇಜ್ ಬಂದಿರ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ ಐ ಡಿ ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಡಿ ಅದ್ರಲ್ಲಿ ಹೊಡೆದ್ರೆ ಬರುತ್ತೆ ಐಟಮ್ ನಂಬರು ಮತ್ತೆ ನೀವು ಕೇಸ್ ನಂಬರು ಹಾಕ್ಬಿಟ್ಟು ತೋರಿಸ್ಬೇಕಿದೆ ಕನ್ಸರ್ನ್ ಅಡ್ವೊಕೇಟ್ ಹೋಗಿರುತ್ತೆ ಕೇಳ
ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೋ ಬರಕ್ಕೆ ಹೇಳಿ. ಥರ್ಡ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೇಳಿ, ನಂಬರ್ ರಾಂಗ್ ಇದೆ. ನಾಳೆ ನಾನು ಚೆಕ್ ಮಾಡಿದ್ರೆ ಟ್ಯಾಲಿ ಬರಿಬೇಕಾ ಕರೆಕ್ಟಾಗಿ
ಅದು ಇನ್ಫ್ರಕ್ಚುವಸ್ ಆಗಿದೆ, ಅದು ಇನ್ಫ್ರಕ್ಚುವಸ್. ನಾನು ಒಂದೇ ನಿಮಿಷ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಬರೋದ್ರೊಳಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದ ಟೈಮ್ 21 ವರೆಗೆ ಇಂಜಂಕ್ಷನ್ ಕೇಳಿರೋದು, ಅದು ಮುಗಿದೋಗಿ 3 ವರ್ಷ ಆಗೋಯ್ತು.
ನಂಬರ್ ಇಲ್ಲ ಅಂತೇಳಿ ಇಲ್ಲ ಅಂತ. ಒಂದೊಂದು ಕೇಸ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ ಟ್ರೈನ್ ಮಾಡಿಸ್ಬೇಕಲ್ಲ
ಸರ್,
ಅದು ಟ್ರೈನ್ ಮಾಡಿಸ್ಬೇಕಲ್ಲ ಗೊತ್ತಾಗಿದೆ.
ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಹೇಳಮ್ಮ. ಇನ್ನೂ ಇಲ್ಲ ಕೊಟ್ಟಲ್ಲಿದ್ದೀನಿ.
ಅದೇ ಸರ್.
ಓಕೆ ಓಕೆ
ನೋಟಿಸ್ ಆಗಿದೆ, ನೋಟಿಸ್ ಆಗ್ತದೆ ಯಾವುದು ಇನ್ನೂ ಹೋಗಲ್ಲ. ನೋಟಿಸ್ ಆದ್ರೆ ಅಯ್ಯ ಹಾಕ್ಕೋಬೇಕು, ಅಲ್ಲಿಗೆ ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, ಬೀಗುಟ್ಟು ಗೊತ್ತಾಗತ್ತಿಲ್ಲ ಇನ್ನೊಂದು ಸೀನಿಯರ್
ಸರಿಲ್ಲ ಅಯ್ಯ ಹಾಕೋಣ
ನಾನು ಮುಗಿಸಿದೆ ಅದಾದ್ಮೇಲೆ ಜಾಸ್ತಿ ಮಾತಾಡೋಕೆ 5 ನಿಮಿಷ. ನೋಟಿಸ್ ಆಗಿದೆಯಾ, ನೋಟಿಸ್ ಆಗ್ತದೆ ಅಯ್ಯ
ಆ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ಅಂತಾರೆ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ? ಅದೇ
ಹಲೋ
ಸೀರಿಯಲ್ ನಂಬರ್
ನಾಳೆ ಇದೆ ಕೇಸು, ಬರ್ತೀನಿ ನಾಳೆ ಬರ್ತೀನಿ. ಹಲೋ ನಾಳೆ ಇದೆ ನಾನೇ ಬರ್ತೀನಿ.
1 ವೀಕ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಹೋಗಿ
ಬರ್ತೀನಿ ಬರ್ತೀನಿ.
ಬರೋಷ್ಟಿಲ್ಲ ರೀಚ್
ಆಗ್ತಿದೆ ರೀ ಮಾತಾಡೋದು. ಆಯ್ತು ಆಯ್ತು ಬರ್ತೀನಿ ರಮೇಶ್ ಅವರೇ ಬರ್ತೀನಿ.
ಹೇಳ್ರಿ ಇವನೇ ಏನಿಂಗ್ ಅದ್ರ ತೋರ್ಸತ್ತೀರಿ
ತರಿಸ್ಕೊತಿದ್ದೆ
ಕಾರ್ಡ್ ನೋಡ್ರಿ. ಹೇಳಿ ನಂಬರ್ ಹೇಳಿ. 956 ನಿಮಿಷ ಬರ್ಬೇಕು. ಏನ್ ಕರೆದ್ರು ಖರೀದೆ ಅಂತ ನಮ್ಗೆ ತೋರಿಸ್ತಾ ಇದೆ.
ಸರ್ ಅವ್ರು ಬರ್ತಾರ ಅಥವಾ ಊಟಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ ಸರ್?
ಟ್ರೈ ಮಾಡ್ತೀನಿ ನಾನು ತಗೋತೀನಿ ನಮಗೆ ಇಲ್ಲ. ಕೊಡ್ತಾರೆ ಇಲ್ಲೇ ಹೋದ್ರೆ ಇಲ್ಲ. ಬೆಳಗ್ಗೆ ಆಪೋಸಿಟ್ ಕೊಡ್ತಾರೆ. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಕೇಳಲ್ಲ. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಕೇಳಲ್ಲ, ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದು ಕೇಳಲ್ಲ. ಎದುರಿಗೆ ಇರ್ಬೇಕು ಅಂದ್ರೆ ಡಿ ಸಿ ಲೆವೆಲ್ ಇರ್ಬೇಕು, ಎಸ್ ಅನ್ಬೇಕು. ಮೆಮೊ ತಗೊಳ್ಳೋದ
ಸರ್ ಹೇಳಿದ್ರಲ್ಲ ಒಪ್ಕೊಂಡ್ರು ಎಸ್ ಅಂತ ಅಂದ್ರು. ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಸರ್? ಅಲ್ಲ ತಗೊಳ್ಳಿ ಅಂತಂದ್ರಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ ಸರ್.
26 ಏನಾಯ್ತು ನೋಡಿ ಸರ್?
ಸಿಗುತ್ತಾ ಸರ್ ಸಂಜೆ?
1 week.
26 1 ವೀಕಾ?
ಸಂಜೆ ಬರ್ತಾರೆ ಸರ್.
ಸಂಜೆ ಆಗುತ್ತೆ RMS.
ಸರಿ ಸರ್.
ಸಂಜೆ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಹೇಳೋಣ, ಹೇಳಿರ್ತೀನಿ. ಪಾಪ ಇವಾಗ ಹೋಗಿದ್ದಾರೆ ಮಾಡ್ಬೇಕು. ಸಾಹೇಬ್ರು ಬಂದ್ಬಿಟ್ಮೇಲೆ ಸಾಯಂಕಾಲನೇ ಸಿಗ್ನೇಚರ್ ಆಗೋದು. 5 ಗಂಟೆ ಮೇಲೆ
ಅದೇ ಚೇಂಜ್ ಆಗ್ಬಿಡುತ್ತೆ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಅಲ್ಲ ಟ್ರೈ ಮಾಡಿ
ಹೇಳೋದು ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 26
ಹೇಳಿದ್ ನಾನು 1 week.
1 ವೀಕ್.
Kindly move. Secondly, serial number 5. Not survive for consideration. Already suit before the trial court has been disposed.
ಯಾವ್ದು OS number?
OS number 96 of 18, Lordship.
Disposed upon?
Disposed on 23/4/24.
Same order. Submitted by learned counsel for petitioner.
Please, madam.
Yes.
Serial number 34, Anand SC.
For the petitioner, regarding the submission, office objection submission, office objection regarding the submission. The petitioner was not a party to the suit. He has challenged the compromise petition, Lok Adalat award passed by as per annexure E, and the petitioner is the purchaser of the property. The suit the property was purchased from the third respondent and their family member. Without made the petitioner, the third respondent and our daughter filed the suit and compromised. This suit was filed on 11/10/2023. And thereafter it was got the advanced. Then 9/12/2023 it was got the compromised before the Lok Adalat.
You are an agreement holder.
Not agreement holder. I am the purchaser. I filed the annexure B is the sale deed.
Annexure?
B, my lord, page number 19.
Sale deed.
Registered sale deed.
Lakshmamma.
That is the third respondent's mother. The third respondent is the Venkatesh is the third purchase vendor.
N.L. Venkatesh.
Yes, my lord.
N.L. Venkatesh.
Yes, my lord. He is the third, is the vendor of petitioner, one of the vendors. The respondent number 1 and 2 are the his children.
Soumya and Sandeep.
Yes, my lord. The suit was got compromised before Lok Adalat. I sought for the set aside the award passed by the Lok Adalat as per annexure E, page number 50.
What is the nature of the property?
It is the agriculture land, and moreover, other properties are standing in the name of the third respondent. I have produced the RTC also.
as per Annexure F, those properties did not include in these suit. It is only collusive suit filed and got the compromise by filing the collusive compromise petition without made the petitioner as a party.
Office objection is overruled. Issue notice to the respondents.
And interim
The
order.
petitioner is also permitted to serve. Well, you issue notice to the emergent notice to the respondents.
My lord, they are
Next para.
going to get the interim revenue record on the basis of company.
Previous one matter ಅಲ್ಲಿ
Yes.
ಇದನ್ನ ಹೇಳಿದ್ನಲ್ಲ, directions not to precipitate the matter regarding mutation entries in the RTC. Same order.
Obliged.
Yes.
35. CP Muttarna.
My lord, last time this matter came up before this our court. Regarding maintainability, this honorable court decided it is maintainable. Nowadays, notice has been ordered, my lord. In this case, my lord, I have requested for the stay of the order passed by that, because the stay is not granted. Now, a lot of problem is created. These petitioners, my lord, they claim to be a tenant, not under this owner, respondent number 2.
Sir, but at the time of admission, if we have not granted any interim order, this is not the stage. They have to appear and then only we'll consider, not now. List this matter after service of notice on response number 1 to 3.
Ajay Govindraj.
Appear for the plaintiff in this case, petition in this case, my lord. It's a plaintiff's petition, suit for partition. My lord's office objection is, my lords, I have not made all the parties as parties to the writ petition. My lord, contesting the respondent is only the respondent number 1. And my lords, I have not claimed any relief against others. Note ಹಾಕಿದ್ದೀನಿ ನಾನು.
Chaduranga Kantaraj Ars
Is the petitioner.
Is also the plaintiff.
Plaintiff, yes. Because my relief is only against the first respondent, not against others. Office raised an objection saying that not others have not made parties. I think my statement is, my lords, relief is only against the first respondent, and others are not necessary parties.
You are aggrieved of what?
My lords, what happened in this case was, my lords, after the notice was ordered, this first respondent entered appearance immediately. My lords, now after 5.5 years, my lords, filed written statement. And my lords, the issue is, the application for condemnation of delay is filed by the counsel, not by the party, which is not permissible at all. Apart from 5.5 years delay, my lords, kindly have a look at, my lords, page 38 is the affidavit filed by the counsel, in page 38.
Delay in filing the written statement.
Yes.
And permit the second defendant to file a written statement.
Your page 38. My lords are saying page 38, my lords, that is the affidavit filed by the counsel.
But this application is filed only under section 5 of the Limitation Act.
Absolutely, yes. The party has to file.
No other application.
My lords, they have filed 2 applications, my lords.
Which is the other one?
Other one is on page 26.
26. Under section 151.
Yes. To recall that order.
And permit defendant.
My lords, the issue is, my lords, can a counsel file an affidavit for a condemnation of delay? My lords are very well aware, my lords, of this position. Kindly have a look at the affidavit, page 38. The affidavit is filed by the counsel for the party.
Both the applications and affidavits are filed by the counsel only.
Yes, absolutely. Not permissible. And trial court says, my lords, it's okay.
This issue was raised.
Absolutely. I find my objections, my lords. Kindly have a look at my objections at page 41. my lords, para 4, page 42. Specifically.
And it has been considered in the impugned order?
Yes, yes.
Ellie?
Page 67. Page 67, my lords.
67.
Page 67. My lords, at notes of para so as per the terms of the said provision, it is mandatory for defendant to file a written statement within 60 days. But as per the finding of our Honorable High Court as well as Apex Court, as held in canton of decisions, said provision is not mandatory. On the other hand, it is directory in nature. If the application is filed after lapse of 90 days, then the party has to give proper explanation. Here the judge says party has to give proper explanation, but not still. He says for the delay caused in the filing of written statement with appropriate reasons. In the present case, the counsel appearing for the defendant number 2 himself has filed affidavit showing the reasons of his ill health and undergoing treatment for various diseases suffered by him. These facts were not been specifically denied by the plaintiff. I have denied it in toto. I said it's not permissible for the counsel to file an affidavit like this in my objections. This is the only issue, my lords, apart from the delay of 5.5 years.
5.5 years.
How though? 5.5 years. And very casually, my lords, the court says, no, it can be allowed. No, if this is permitted, my lords, then it will lead to chaos. People will not take court seriously at all. And my lords, in this case, the party entered appearance after 1 month, filed application for objections to my IA for injunction, also filed application on Order 7, Rule 11 to reject the plaint. They have done all that, but did not file written statement. And my lords, kindly have a look at the application, my lords, filed by the counsel at page 35.
Purple. Issue notice to the respondents. Respondent, office objection is overruled. Next para. Issue notice to the respondent. The petitioner is also permitted to serve copy of the petition along with annexures on the learned counsel representing the respondent before the trial court. Next para. Learned counsel for the petitioner submits that in a suit filed at the hands of the petitioner in the year 2015 in OS number 25185 of 2015, the respondent herein, who is arrayed as defendant number
2,
entered appearance
on 10/4, 10/4/2015, the entered appearance.
on 10/4/2015
itself, the entered appearance.
2015.
How though?
Full stop. However, a written statement is sought to be filed along with the 2 applications.
On 13/8/21.
Number 8 and 9.
How though?
On
13/8/21.
13/8/2021.
Yes.
21 now.
How though?
When was this order passed?
This was passed, my lords, on 6/4/2024. COVID ಎಲ್ಲ ಆಯ್ತಲ್ಲ ಆ ಟೈಮಲ್ಲಿ.
After a lapse of more than 5 years.
5.5 years, my lords.
More than 5.5 years.
Yes.
Full stop. Moreover, the application and affidavits accompanying the application are filed not by the respondent but by her learned counsel on record. Full stop. Though serious objections were raised to such an affidavit being filed at the hands of the learned counsel, and the provision requires the affidavit to be filed by the parties, nevertheless, such objections are brushed aside and the impugned order has been passed taking on record the written statement which is filed after 5.5 years after receipt of, after the respondent entered appearance in the suit. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order.
And also, my lord, further proceedings also.
And all further proceedings. Allah, why do you want to ask for stay of the proceedings?
ನಾನೇ plaintiff.
ಅದೇ.
ಈಗೇನ್ ಜಡ್ಜ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಈಗ she's gone on to frame the issues and has told me to lead evidence. How can I, my lords, on this this thing? ಅದಕ್ಕೆ ನಾನು ಮುಂಚೆ ಪ್ರೇಯರ್ ಮಾತ್ರ ಮಾಡಿದ್ದು only for stay of that order. But now it's become inevitable that I get the proceedings stayed.
And all further proceedings in OS number 25185 of 2015 on the file of the 73rd Additional City Civil and Session Judge, Bangalore, CH-8 till the next date of hearing.
It's a date, my lords. I'll serve him tomorrow itself. Yavatru on date.
Illa.
The date.
37.
No, not.
Very well. Obliged.
Yes.
Lord, I represent the petitioner. R5 is not, my lord, the service is, my lord, not yet done for R5. I'm filing a memo. R5 has died, my lord, in year 2020 itself.
Mutta?
Suit
How did you arrive a party here?
Suit abate agogide avar ಮೇಲೆ. My lord, we found out that his death was not reported, my lord, even before the trial court. Now I've found out his death certificate, my lord. I'm filing a memo to that effect. Anyway, the suit is pending, my lord, before the trial court. Only we'll file the necessary applications, my lord, for seeking setting aside of the abatement, etc.
All others are served.
All others are served, my lord. The matter is, my lord, a short matter.
The other side yaru ilvalla ನೀವು ಇವತ್ತು ಹೇಳಿ ಏನು ಪ್ರಯೋಜನ? It is coming for orders. I can't pass orders like that.
It is not an adversarial.
Please feel that whatever you want.
It is not an adversarial, my lord, petition in the sense. The petitioner is one of the plaintiffs, my lord, one of the two plaintiffs. My lord, the suit was filed for declaration. My lord, during the pendency of the suit, my lord, differences arose among the plaintiffs inter se. And my lord, the same learned advocate was representing both the plaintiffs. And in respect of the petitioner herein, an NOC was given by the learned advocate. Now, my lord, I want to engage another advocate. And I don't want to proceed with the case, my lord. I've also filed an application on Order 23 Rule 1 seeking abandonment of the suit claim. But the learned trial judge has relied upon a 1960 Bombay High Court judgment saying that in the same case, different counsel cannot represent. Although I have secured no objection from the previous learned counsel. Only on that short point, my lord, writ petition is filed. I have also filed the 23 Rule 1.
ಏನು ಮಾಡಬೇಕು? Without hearing the other side, can I pass orders?
My lord, it may one date kodbodu ashte. One short, may I request for a short?
Learned counsel for the petitioner has filed a memo stating that respondent number 5, Shri C. Ramachandra Reddy, passed away on 13/10/2020. Full stop. The legal representatives have not been brought on record in the suit. Full stop. Therefore, the suit has abated as against respondent number 5 herein. Full stop. The learned counsel would therefore submit that the writ petition may be dismissed insofar as respondent number 5 is concerned. Full stop. Next para. The submission of the learned counsel for petitioner is placed on record. The writ petition stands dismissed insofar as respondent number 5 is concerned. Full stop. Next para. Release this matter on 29th of August.
38. Satisha, DJ.
I'm for the petitioner.
Yes.
On
List this
7-8.
matter after service of notice on the respondent.
I served the.
Huh?
I served the copy to the opposite advocate, trial.
Advocate. But that cannot be taken as service of notice. It has to come, you notice ತಗೊಂಡಿದ್ದೀರಾ. It has to return, we'll see. Yes.
39. SP Prakash.
My lord, I have heard the petition, my lord.
Yes.
Kindly the submission, advocate submission may kindly be rejected, my lord. Some word directed. We have made a certain submission. It is not in correlation with that office objection, my lord. It is to be corrected. Kindly next week it will.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Oh, bless.
40 Sampathi.
Was directed to serve on the BDM, my lord. I served Mr. Murugesh Charati, sir, my lord, panel counsel. The memo is also filed, my lord. The Murugesh sir's name may be shown for respondent number 1.
Office is directed to show the name of learned counsel Sri Murugesh B. Charati for respondent number 1.
Please. Please.
Release this matter on 28th of August. Please.
41. Withdrawal. Manjunath Prasad V.
Petition, filing memo to dismiss the petition as not present. The matter is likely to be settled between the parties.
Learned counsel for the petitioners has filed a memo dated 21/8/2024 stating that the matter is likely to be settled. Full stop. Nevertheless, the learned counsel seeks for leave to withdraw the writ petition as not pressed. Full stop. Next paragraph. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as not pressed.
Much obliged.
42. Sachin PS.
Preparing for the petition, my lord. Lords, we have served the copy, my lords, on the trial court advocate, my lords, so we'll be filing the acknowledgement. Date may be fixed, my lords, so that.
That is not service of notice, sir.
Yes.
We will only ask you to serve if the bandra well and good.
Yes.
But you also taken steps for.
We have taken steps.
List this matter after service of notice on the respondent.
43.
Petitioner,
Mr. Kumar Gowda, action.
exception.
A week's time is granted at the request of learned counsel for petitioner to take steps for service of notice on response number 1 to 5.
Much obliged.
44. Sandesha AS.
Lordship, 3 days time may be granted. We will apply this.
A week's time is granted
3 days merits.
at the request of learned counsel for petitioner for complaints of office objection. Office objections are complied. List this matter for preliminary hearing. Yes. Obliged.
Passed over matter. Serial number 2.
For the petitioner, my lord. My lord, the respondent here in my lord, the file the IF for amendment, my lord, that has been allowed on February 20th, 2024. This is the changing of the nature of the suit, my lord. The suit for my lord filed by the respondent, my lord, for the partition, my lord. Later they have filed the amendment application for the declaration, my lord. That has been allowed on 20th February, my lord. Which the survey number, which is the scheduled property in filed in amendment application, my lord, they have respondent and father has been sold to the one person, my lord, that is a 1992 Kare Unnisa. The petitioner herein have purchased in 1992, my lord. 1982 sale date, my lord, the respondent and respondent father has been sold, my lord. The petitioner 1992 petitioner have been purchased, my lord. And that will not come to the joint family property, my lord. And the oral partition is done. And
All of you are members of the same family.
All of same family, my lord. They have sold the property in 1982. Now they are claiming partition now, my lord, which I have purchased in 1992, my lord.
Therefore, you are taken that stand in the return statement.
Please, my lord.
Now, the plaintiff filed an application
Please, my lord.
for converting the suit into one for declaration.
Only they adding that scheduled property, my lord, which they sold,
Huh?
that scheduled property has been added in the IA. Both scheduled
Application
property
paying
is
for amendment of plaint.
plain, my lord. The both scheduled property is the
The
different, my
plaintiff
lord.
state that he has filed a aforesaid suit paying for half share in Schedule A property, which was excluded in the oral partition due to some differences, that the defendants had admitted to execution of Ottige Helike Pramana
Opinion
Patra
Pramana Patra.
and have started to deny and disturb his possession. That he came to know
Which is not.
but they had denied the right of plaintiff over suitable property. That the plaintiff's father and brother, one Kairunisa. Huh?
Yeah, here in responding, plaintiff have been already sold this
And
property
brother
to
of one
Kairunisa,
Kairunisa.
1982. Then
That
petitioner.
the plaintiff's father and brother of one Kairunisa purchased the scheduled property to registered sale deed dated 26/8/1982.
1982, they have sold to the Karyunnisa, my lord. From Karyunnisa, defendant has been purchased in 1992. In the same line, the defendant purchased the scheduled property from Karyunnisa in the year 1992. This is self property, my lord. We have purchased it. Before that, it was a joint family property, but it went to the defendant, respondent hearing, my lord, to the plaintiff. From they have sold it, my lord. Then we have purchased it. That they have included now in the partition suit, my lord. Which their share they already sold it, my lord. They included the scheduled property here and claiming the partition, my lord, and declaration. The nature of suit will change, my lord. Schedule in the page of 13, my lord.
According to you, it changes the nature of the suit.
Nature of the suit, my lord, and which they have already.
A suit for partition
This is
cannot
suit
be
for
converted
partition.
into a suit for declaration.
Declaration.
Any judgment you want to rely upon?
I already relayed of the judgment, my lord. That is not considered by the trial court.
Revajitu builders.
Ravajitu builders and developers, my lord. That
Where
is
have they
also
said?
page number 41, 5, my lord. May I read, my lord?
Huh?
Page number 41, my lord. In the judgment,
Hmm.
whether the proposed amendment constitutionally or fundamentally change the nature and the character of the case. Hence, my lord, that has been.
You should be more specific, Amma. A suit for partition
Suit
cannot
for
be
partition.
permitted to a suit for declaration.
Declaration. And
Normally a suit for permanent injunction can be converted into a suit for declaration, but not so in respect of a partition suit ಅನ್ನೋದು ಎಲ್ಲಿದೆ?
I'll produce some judgment.
You should come with preparation. ನೀವು ಅದೇ same judgment if you are citing what has been considered, what is the use then?
The scheduled property also changed, my lord. Page number 13, partition for the partition schedule has been produced, my lord. And for the declaration, my lord, the schedule is different, my lord. That schedule also added up. Page number 13 is the partition suit schedule, my lord.
30.
Page number 13, my lord.
13.
13, my lord. Later on, page number 27, one more schedule property is added, my lord.
Page number?
27, my lord. May I read,
Add
my lord?
the scheduled property.
To add schedule property. The land bearing survey number 110/2, measuring 25 guntas out of 1 acre 11 guntas, including 1 gunta Karab land, situated in the so-and-so Ramnagara district. This schedule they added, money. And seeking declaration for this scheduled property.
They are only adding.
Please, ma'am.
25 guntas ಅನ್ನೋದು ಇರಲಿಲ್ಲ ಔಟ್ ಆಫ್ ಅಂತ ಅದನ್ನು ಸೇರಿಸಿದಾರೆ ಅಷ್ಟೇ ಈಗ.
For this, they are declaring the suit, my lord. And declare the plaintiff that absolute owner and possession of the scheduled property. This is the scheduled brief property. For that, they are seeking declaration, which they already sold this to someone from Kari Unnisa, my lord. We have purchased it in 1992. That EC also produced, my lord. EC at the page 45, my lord. The plaintiff itself is with the father. They sold the property, my lord. Same survey number. Chikka Muddaya Muddai Veeraya Palakshaya. Plaintiff father and plaintiff brother. All three of them has been sold.
ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondent. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsel representing the respondents before the trial. Stop. Next para. Learned counsel for the petitioner submits that on the petitioner's entering appearance in the suit filed at the hands of the respondent for partition and separate possession, and after filing written statement and taking a stand that the suit scheduled property is the self-acquired property of the respondent, of the petitioners herein, and it is not available for partition. An application was filed by the plaintiff seeking to amend the plaint. Stop. In the application for amendment, the petitioner is seeking to convert the suit into a suit for declaration and seeking changes in the description of the suit schedule property. Full stop. Learned counsel submits that the amendment will change the nature of the suit, and it would be impermissible for converting a suit for partition into a suit for declaration. Full stop. Next para. Consequently, there shall be an ad interim order of stay . of the impugned order dated 2024 in OS number 24 of 2022 till the next date of hearing. There is no need for staying the proceedings. Yes.
Serial number 19. Sachin BS.
Yes.
And also, there was a suit for eviction and for arrears of rent. I'm for the tenant, as a defendant.
Judgment debtor.
Judgment debtor.
Proceeding, execution
Yes,
proceedings,
yes, yes, ma'am. There was a compromise, just my lords, in a suit, what had happened was my stand was, it was a permanent lease. My stand was that it was for permanent lease. We used to do budget, we have, ourselves has put up the construction. And we are doing the, carry on the activities of Bhajana Mandir there. And our stand was, it was permanent lease. And same thing was accepted by the trial court. However, the eviction, because as per the lease, the eviction was not permitted. And trial court has only partly decreed the suit, directing the defendant to pay the arrears of rent. It was the partial decree which was passed by the trial. The rent is only 12 rupees because 1937 is the lease. 1937 is the lease. So 12 rupees was the rent as such. Then landlord took up in appeal. There was a compromise. This goes to the root of the matter, my lords. Kindly see the compromise petition. I have annexed the document on record. My lords would find it at page number 114. 114 may be kindly below. 114. This typed version, my lords would get it at page number 117. 117. My lords, this is there was a decree in RA in terms of the compromise petition. Therefore, I am taking my lords to the compromise petition. Plaintiff appellant has agreed to provide the defendant respondent the structure by constructing the pillars, first and second, and one side of the wall measuring 550 square feet of 12 feet height, whatsoever length and breadth in the first floor of the building, excluding staircase, 1.5 feet width, along with the direct entry exists to a common area leading to a road to be constructed by the appellant plaintiff in number so and so, Mangalore, Tota village, Mangalore Taluk, within Poige Bazaar ward of Corporation of the city Mangalore, on measuring 0.04.5 acres, extended by the plaintiff appellant on perpetual lease for religious use of the defendant respondent. So also the plaintiff appellant or successor shall use the ground floor.
Shall not use
the ground floor or any portion of their building for slaughtering or for sale of liquor, non-vegetarian items. Next, 3. Defendant respondent shall hand over the vacant position of the land now occupied by them within 1 month from the date of the receipt of the notice by the defendant respondent from the plaintiff appellant in writing after obtaining the building license from the Corporation of City of Mangalore. Next, plaintiff appellant shall deliver the first floor of the structure agreed to the handover to the respondent within 10 months from the date of the delivery of the vacant portion of the land now occupied by the defendant respondent. Next, 5th one, in case plaintiff appellant failed to complete the construction within the time agreed upon, the defendant respondent shall be entitled to commence and complete the construction, the ground and first floor of their portion of the building structure. And as such, an event of defendant shall be entitled also for reimbursement of the amount spent for the construction of the same. Full stop. In the case defendant appellant fails to deliver the vacant portion of land in their occupation within time agreed upon them, the defendant respondent shall also entitled for a benefit agreed upon here above, and plaintiff appellant shall be entitled to levy execution, obtain the position of land in the occupation of defendant respondent. Next, 6. The plaintiff appellant while constructing the second floor of the proposed building shall leave 5 feet width from the center from front portion of the proposed building.
What is it that you want?
Next, my lords, kindly see. I'll skip 7th point also, which is not relevant. This is very important. My lord, this thing, 7th point, my lords. On obtaining the occupancy certificate or completion of the proposed building, plaintiff applicant shall execute necessary registered perpetual lease deed. Kindly mark this. In respect of the portion of the building at the cost of the defendant respondent within 30 days thereafter to be used as they wish. Now, from point number 1 to 6, there is no dispute. Now, point number 7 is concerned. Insofar as the execution of lease deed, what the landlord does is that he files an execution for executing the lease deed in execution proceedings pursuant to this compromise decree. Well, pursuant to this compromise petition, RA was decreed pursuant to the compromise petition. Thereafter, a decree holder files an execution petition to execute the lease deed, which my lords would find it at page number that is 125. Yes, 125 is the prayer. My lords, in that J column ali nimage prayer siktade. So in the lease deed, the executing court asked the decree holder to submit the draft lease deed. In the draft lease deed, my lords, the landowners includes the recitals of the payment of rent, including the enhancement of rent. That is a dispute. In the draft lease deed, executing court asked the decree holder to prepare the draft lease and submit to the court. In the draft lease deed, the landowner includes the recitals of payment of rent of rupees 5,500 per month and also for enhancement of rent after 1 year. For that we have objected because in a compromise decree there is no recitals of payment of rent is concerned. My lords, my lords, what the reason is this? I know.
First of all,
yes,
the provision for perpetual lease itself is not valid.
My lords, we are not doing any.
There is a rule against perpetuity, sir.
My lords, I do understand.
This kind of a compromise, which is against law, first of all, should not have been permitted by the court. There is a rule against perpetuity, sir.
My lords, can I make this submission? My lords, I can understand if I am doing some commercial activity.
No.
Here it is for religious purpose.
The Transfer of Property Act contains a provision that would prevent any contract or any transfer which is perpetual in nature. So this compromise itself is against law. It should not have been accepted.
But the trial court has not gone to that issue.
Trial
court says that.
How can you say no? I will not give any rent.
My lords, because first floor I myself has constructed.
Sir, the property does not belong to you.
Definitely.
Then
37 in
just because you put up one floor, you will permanently have the ground floor, is it?
We are not, my lords. We are doing religious act. Bhajana mandir ಮಾಡ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ.
Let them come, we'll see. Issue notice to the respondent. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing the respondent before the executing court.
I was having benefit of interim order before appellate court. Appellate court interim order because lease deed approve ಮಾಡ್ತಾರೆ, register ಮಾಡ್ತಾರೆ. Now trial court has approved the lease deed.
There may not be any difficulty for you to use the ground floor.
No problem. ಈಗ lease deed register ಮಾಡ್ತಾರೆ. Now trial court what it does is that no, it is not 5,500. It should be fixed as 3,000 and directed to approve the lease deed to register the lease deed. I was having the benefit of interim order before the appellate. The opponent itself has said that we will not pursue.
The executing court is directed not to precipitate the matter any further till the next date of hearing.
Great. Number 2.
Here is number 1. Narasimhamurthy GB.
Here number 2. Narasimhamurthy GB.
The regular appeal in RA 141 of 2014 has been allowed by order dated 16/9/2020. Disposed of.
Number 2, B.K. Manjunath.
Matter is called out, there is no representation.
ವೇರಿಫೈ ಮಾಡ್ತಾ ಸಮಯ OS ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ 1 ವೀಕ್ ಟೈಮ್ ಕೊಟ್ಟು ವೆರಿಫೈ ಮಾಡ್ತಾ ಸಮಯ OS ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ ಅವರು ಯಾರು.
ಇಲ್ಲಿ ಇದೆಯಲ್ಲ 26/8/2022 dismissed with cost. OS 113 of 2006 was dismissed on 26/8/2022. Disposed of.
Serial number 3, Raghunath MD.
OS 26587 of 2013 has been decreed on 12/1/2024. Disposed of.
Serial number 4, Sudha B.
OS 4549 of 2018 has been decreed on 23/9/2022.
List number 1. Hearing interlocutory application. Serial number 45. Amrutesh C.
For petition, a week's time may be granted, Lord's file. Week's time may be granted, Lord's.
Matter is called out. There is no representation for the respondents. Release this matter
Kindly have to third, Lord.
on 3rd of September.
Interim order may kindly be.
Interim order granted earlier stands extended till the next date of hearing.
Date 3rd September.
Serial number 46, Kevin Narasimhan.
Here for the petitioner. I've made an application seeking extension of the interim order. The interim order, my lord, was granted to me on 15th of June 2023. My lord, emergent notice was ordered, and also, my lord, I had been
The prior
permitted
date
to
for interim order is not considered for the reason that though the petitioner was permitted to serve the learned counsel for the respondents.
Yes.
In the suit before the trial court, he has not made use of the said accommodation granted to him. Had the petitioner served the notice to the learned counsel for the respondents, in the trial court, probably they would have notified at the earliest and appeared in the matter further. The nature of the notice orders were also emergent in nature. Reject
the emergent notice, my lord, was taken out by me immediately. My lord, it was parallelly, my lord, I had been permitted to take out the service on the learned counsel appearing before the trial court.
What happened to the notice?
I have served, my lord, and they are also represented by
Notice
counsel.
also is served.
Yes, my lord. Yes, they are served by the council also. Pardon, they are represented by the council. Okay.
Order on IA number 1 of 2024. Or 23 now?
23 months. 23.
23.
Please.
The application is filed by the petitioner seeking extension of the interim order of stay passed by this court on 15/6/2023. Full stop. Next para. On 15/6/2023, the order of stay was passed by this court till the next date of hearing, while directing emergent notice to the respondents and permitting the petitioner to serve a copy of the writ petition on the learned counsel representing the respondents before the trial court. Full stop. On the next date of hearing, that is 12/10/2023, although the learned counsel pressed for the extension of, why you had to file application for extension?
My lord, what happened is that was, my lord, an oral.
The copy was not served to us, my lord. Since the copy was not served, they had obtained the.
Why you had to file the application for extension?
My lord, because my lord, on that day, since it was not extended by a specific order of this honorable court. The interim order, my lord, was not extended on 12/10/2023.
ಅದಾದ್ಮೇಲೆ ಈ application.
ಅದಾದ್ಮೇಲೆ ಈ application.
ಏನ್ ಹೇಳಿದೆ? Although the learned counsel prayed for extension of the interim order, nevertheless, this court observed that the petitioner did not make use of the permission granted to him to serve a copy of the writ petition on the learned counsel representing the respondents before the trial court. Thereafter, this application has been filed. Full stop. Learned counsel submits that as directed by this court, emergent notice was taken out by the petitioner and the same was dispatched on 27/2023. Full stop. Therefore, no fault can be found on the petitioner for disobeying the directions issued by this court. Full stop. Moreover, the respondents are now represented before this court. Full stop. Next para. Consequently, the application is allowed. The interim order of stay passed by this court on 15/6/2023 stands extended till the next date of hearing.
Serial number 47, I appear for the petitioner. Report from the civil court as well as the Bangalore rural court is awaited. Matter relates to territorial jurisdiction of the subject matter of the suit. Reports were called for. It is awaited.
Let's I appear for the. Respondents.
Report were called for.
Yes, my lord. The report to say whether the suitable property falls within the territorial jurisdiction of the civil court.
In addition thereto, Registrar Judicial of
Yes.
this court is directed to obtain a report from the Registrar of the City Civil Court, Bangalore City, and the Registrar, Bangalore Rural District, as to whether the suitable property is situated within the territorial jurisdiction of the City Civil Court, Bangalore, or Bangalore Rural District by the next date of hearing. Liberty is reserved to.
May I submit this? Let's kindly come to the impugned order. Let's.
It was
impugned order.
It's a very short order. Let's, irrespective of whether the property falls within this court's jurisdiction or let the impugned order, does it call for any interference? Let's kindly come to the impugned order.
May I submit now? The
Yes,
reference is
yes.
made to section 18 CPC. Now that was impermissible. If we look
Let's
into
kindly
the
come to the impugned order. I will point out. Kindly come to the impugned order. Let's, the defendants 4 and 5 have
page
filed.
number ಹೇಳಿ.
Huh?
Page number ಹೇಳಿ.
ಅಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಅಂದ್ರೆ ನಾನು ವೆಕೇಟಿಂಗ್ ಹಾಕಿದ್ದೀನಿ, ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 24. ಯಾಕೆಂದ್ರೆ ಅವರು ಸ್ಟೇ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಮೆಮೊ ಹಾಕಿದ ತಕ್ಷಣ ನಾನು ಮೂವ್ ಮಾಡಿದೆ. ನನಗೆ ಇನ್ನೂ ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿನೇ ಬಂದಿಲ್ಲ. ಬಟ್ ದಟ್ ಡಸಂಟ್ ಮ್ಯಾಟರ್. Let's, I have produced that impugned order at page 24. 21.
Annexure A is the impugned order.
Annexure A.
Annexure A.
There, kindly come to the next defendants 4 and 5.
ಯಾವ paragraph?
Annexure D. Annexure D
Beginning
is
and
the
then
impugned order.
Annexure B na.
D.
ABC.
D at page
Annexure
55.
D is the impugned order.
Kindly come to that. It's a short order. Let's, defendants number 4 and 5 have filed the memo stating that the suit property is situated in Yelachanahalli village, Bangalore South Taluk. As such, in view of section 2 and 3 of the Bangalore City Civil Codes Act, read with notification bearing number so and so. The suit property falls within the Bangalore, within the city of Bangalore, and the jurisdiction of this court is expressly boosted. As such, this court has no territorial jurisdiction to try the suit. Hence, dismiss the suit. The learned counsel for the plaintiff submitted that he has got no objection to the memo and to return the plaint to submit it before the proper court if the suit property does not come within the territorial jurisdiction of this court. The learned counsel for defendant number 4 and 5, along with the above memo, produced notification dated so and so. In the said notification, the government of Karnataka, in exercising the power conferred under subsection 3 of section so and so of the CPC, prescribed the limits of the metropolitan area comprising of the city of Bangalore. In the said notification, insofar as jurisdiction of metropolitan area comprising in the city of Bangalore is concerned, LHNL is concerned, it is as follows. Further, it runs along the village boundaries of Hongasandra, Devarachikanhalli, and turns towards south and proceeds along with the village boundaries of so and so, Yelachenhalli, as it reaches the eastern corner of so and so. From the above description of the notification, it is uncertain whether the property situated within Yelachenhalli village comes within the jurisdiction of the metropolitan area comprising of the city of Bangalore. As per section 4(4) of the City Civil Codes Act 1979, the jurisdiction of the civil court is described as under exercising the jurisdiction only within the local limits of the city of Bangalore immediately before the appointed date shall on and from the said date cease to function and are hereby abolished. Exercising jurisdiction within the local limits of the city of Bangalore as well as outside such limits immediately before the appointed date shall on and from the said date cease to have jurisdiction within the local limits of the city of Bangalore. It is also necessary to note the notification bearing number so and so issued by the government of Karnataka, which says as follows. In exercise of the powers conferred by class C of section 2 of the Karnataka Civil Codes Act, Karnataka Act 21, and in supersession of the previous orders on the subject, the government of Karnataka hereby notifies that for the purposes of the said act, the area comprised within the revenue district of Bangalore, excluding the city of Bangalore, shall with effect from the 24th July 1978 be a district called the Bangalore Rural District. From the combined reading of the above two notifications as well as section 4(4) of the Karnataka Civil Codes Act, it is clear that the jurisdiction of revenue district of Bangalore Rural District is the area comprised within the revenue district of Bangalore, excluding the city of Bangalore, and as stated in the notification dated so and so, there is uncertainty as to whether the property situated in Yelachenhalli comes within the jurisdiction of city civil court. Even there is no specification in any notification as to whether the property situated within Yelachenhalli village comes within the jurisdiction of this court. Thus, it could be said that there is uncertainty as to whether the property situated at Yelachenhalli village comes within the local limits of this court or city civil court. When such is the situation, section 18 of the CPC comes to the rescue. Section 18 speaks that when there is uncertainty within which
of local jurisdiction of two courts, the property is situated either of the courts on being satisfied about the uncertainty as to the local jurisdiction by recording the reasons to that effect, entertain the suit and dispose of the suit. Section 18 CPC reads as under. Place of institution of the suit and local limits of jurisdiction of the courts are uncertain. Where it is alleged to be uncertain, within the local limits of the jurisdiction of which of the two or more courts any immovable property is situated, any one of these courts may be satisfied, is satisfied that there is a ground to the alleged uncertainty, record a statement to the effect that thereupon proceed to entertain and dispose of any suit relating to that property, and its decree in the suit shall have the same effect as if the property were situated within the local limits of this jurisdiction, provided that the suit is one with respect to which the court is competent as regards the nature and value of its jurisdiction.
Here, what is your difficulty?
Difficulty, I don't have any.
This order is in your favor.
The order is in my favor. Now this
What is the difficulty for the defendant?
My lord, according to me, my lord, this LHNL village, that is a subject matter of the suit, my lord, falls within the city of Bangalore in view of the notification at Annexure C1. Annexure C. So therefore, my lord, the trial court will not have any jurisdiction.
It has been considered.
Therefore,
the
my lord,
notification has
had
been
filed a
considered.
memo.
What is the
Considered,
prejudice
my
that
lord,
is
the
being
London
caused to
trial
you?
court says.
What is the
Lord,
prejudice that is being
prejudice
caused
is-
to you, sir?
My lord,
Both are
my
in the
lord is
same
aware.
building.
No,
Both the
building
courts are in
is
the
same.
same building.
I can completely agree to that, my lord. But however, insofar as appeal is concerned, my lord, it will have different consequences.
So?
The property is situated in the city of Bangalore. There is no
The-
ambiguity. The Learner trial court has
The
committed a
court has
grave error.
considered both the notifications and it is saying there is some confusion.
That is
And it has
perverse.
fallen back on section 18.
No,
What
that
is
is
wrong?
perverse finding. The ambiguity is there. The finding of the Learner
If there
trial
is,
court
if
that
there is
says,
complete clarity, please show.
please, my lord, please take
Please show.
Annexure C. Annexure C1, my lord,
Yes.
typed copy is at Annexure C1 at page 51.
Yes.
My lord is aware, my lord, how the boundary is defined.
Yes.
In exercise of the powers conferred by subsection 3 of section 8 of the Code of Criminal Procedure 1973, the government of Karnataka hereby extends with effect from the 17th day of November 1918 the limits of the metropolitan area comprised in the city of Bangalore declared in notification number so and
This is
so.
under the CRPC.
My lord, the Bangalore
This is
City
under the
Civil Code Act
CRPC.
refers to CRPC only. My lord. Bangalore City Civil Code Act
Where is
refers
that?
to CRPC.
Where is that?
My lord, section 4. I shall point out.
City Civil Courts Act is in.
Bangalore City Civil Court. In my memo itself, my lord, I had referred to section 2 and 3. All areas, my lord, falling within the metropolitan area will be falling within the jurisdiction of the Bangalore City Civil Code Act. Not this notification. I may permitted to read this further, my lord. So far as that is concerned, there is no ambiguity. Areas, Bangalore North and South taluks of Bangalore district comprised within the running boundary. My lord, this is important.
Yes. In terms of section 8 of the Code of Criminal Procedure.
Yes, this is a notification issued under section 8 of Code of Criminal Procedure.
Yes.
And specified to column 2 of the table below to the areas in Bangalore North and South taluks of Bangalore district comprised within the running boundary specified in column 3 thereof. Note the keyword is comprised within the running boundary.
Yes.
My lord, the boundary is defined. May I request my lord to kindly take up page 53. 9th line from bottom, which is extracted in the impugned order itself. My lord gets that. My lord, the south and proceeds along the village boundaries of.
The boundary commences from the northwestern corner of Vaderahalli and turns area comprising the city of Bangalore as defined in the City of Bangalore Municipal Corporation Act.
I'm sorry, my lord, where?
Vadayaranhalli and turns along the boundary of Swamenahalli.
And page 53, my lord. May I request my lord to kindly go to page 53. Ninth line from the bottom. My lord finds Hongasandra, Devar Chikkanhalli.
ಇದಕ್ಕೇನು ಒಂದು ಇದು ಮ್ಯಾಪ್ ಹಾಕಿಲ್ವೇನ್ರಿ?
Map hakilla, my lord. The key word is, my lord, within the running boundary. So whatever falls within that boundary, my lord, falls within the city, Bangalore city. Therefore, it comes within the jurisdiction of the Bangalore City Civil Court. Hongasandra, Devara Chikkanhalli, and turns towards south and proceeds along the village boundaries of Nayapanahalli, Yelayanhalli, till it reaches the eastern corner of Pulimau. That means, my lord, entire Yelayanhalli village comes within the jurisdiction of the Bangalore Civil Court. And therefore, my lord, the jurisdiction of the rural court is completely ousted. In the light of the same, my lord, I had filed a memo. My memo was rejected by the impugned order. In the light of this ambiguity, my lord, this honorable court was pleased to call for a report. But there was no occasion for the learned trial court to, my lord, invoke section 18 of CPC, because there is no uncertainty here. It's very clear. Whatever falls within the boundaries of Yelayanhalli, my lord, will fall within the jurisdiction of Bangalore City Civil Court. And for that reason only, my lord, in fact, the plaintiff had also considered that para 2 of the impugned order, it is noted.
ನೀವೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಲ್ಲಿ ಮತ್ತೆ ಯು ಆರ್ ರೈಸಿಂಗ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಾವು.
ನಾನಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದು, ಅವರು ಪ್ಲೇಂಟಿಫ್ ನನ್ನ ಮೆಮೋಗೆ ಅವರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲ, ದೇ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಅಲೋ ಮೆಮೋ ಅಂತ ಹೇಳ್ತಾರೆ. At para 2 of the impugned order, page 56. The learned counsel for plaintiff submits that he has got no objection to the memo and to return the plaintiff to submit before the proper court. That would have solved all the problems. Even they realized it.
Yes, sir. All these villages that are named here.
Yes, my lord. It falls within Bangalore City.
Fall within the limits.
I don't mind, let's if the court says, let it go to the city civil court, I don't mind. Though they have filed the memo, they should have filed an application under Article 7, Rule 10 for the return of the plaintiff. I am not standing on the technicalities, but my difficulty is this. Let's 2 or 3 injunction applications are filed by me. Now for deciding this question, my applications being getting deferred. ಅದಕ್ಕೆ ಇಲ್ಲೂ ಹಾಕಿದ್ದೀನಿ 2 application, not to alienate one, not to change the nature of the property ಅಂತ ಹೇಳಿ. I don't mind, let's facing prosecuting the matter either in the rural court or in the city civil court. Writ petition allow ಮಾಡಿದ್ರೆ ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. What I am requesting is this.
All right, we'll direct them not to alienate the suit schedule property
and not to change the nature.
On merit, my lord,
are considered by the city civil court.
In fact, the Supreme Court has said.
May I make one submission?
Pending
may I make one
question
submission?
of jurisdiction.
Let the application be
There cannot
by
be any
the
bar
learned
for
trial court
considering the
expeditiously.
injunction application ಅಂತಾನು Supreme Court
Yes.
judgment ಇದೆ.
Yes.
May I make this submission, my lord?
Yes.
We will completely cooperate with the learned trial court disposing the matter at the earliest. Lord, what happens is, my lord, the 2006 is the agreement. They have sold the property way back in the year 2006. May I request, my lord, to kindly look into the prayer made. Page 39 of the writ petition.
What I request
The
then
second
is
prayer.
grant an
This is
injunction
super
for a limited
declaration
period.
of title.
Let the trial court consider the
They are
matter
not in favor.
of injunction on merits.
No, my lord.
You have already disposed of the
I have
property now.
purchased the property by paying huge amount. I have purchased the property by paying huge amount. I have
ನೀವು
got
ಯಾರಿಗೂ
it.
ಮುಂದೆ
My lord,
ಮಾರಬೇಡಿ
both
ಅಂತ
sides are-
ಹೇಳ್ತಾ ಇರೋದು.
My lord, my difficulty
Don't
is this,
sell
my
it.
lord. No, my lord. May I make this submission? Now, my lord, I have made huge investment, got the property converted for residential purposes, so formed a layout, entered into various agreements also. So at this juncture, my lord, any restraint order, my lord, will.
You have formed a layout. You have
Yes,
formed
my
a
lord.
layout.
Yes, my lord. It's got converted. Layout is formed. I entered into several agreements. 7, 8 sale deeds were also executed. They are seeking for cancellation of an agreement of the year 2006, my lord. This is a registered agreement coupled with interest, and based on that, my lord, I have purchased the property in the year 2023, prayer number E. Lord, since 2006, my lord, they were quite silent. And having allowed all these transactions to happen, my lord, now I am targeted.
You have filed a suit for?
Declaration of
and
title,
permanent
my lord. Prayers are found at page number 39. First prayer is, my lord gets that, page number 39. Internal page number 26 of the plaint.
With respect to the 2023 sale deed, it sets up an agreement of year 2006. There the
Declare
court
that the
can
plaintiffs are the
make
absolute
out the
owners of the
manifests.
social property.
Whatever it is.
Second prayer, declare that the agreement of sale dated 16/12/2006 entered into between the plaintiffs and the defendant 2 and 3 at the instant of defendant number 1, agreeing to sell and purchase scheduled property for valuable consideration of rupees so and so is barred by limitation, is not acted upon as the defendants have not complied with the terms and conditions of the same. Prayers are not available, my lord, in such terms. My lord, the third prayer is, declare that the registered agreement of sale dated 16/12/2006, which is registered before the office of the sub-registrar Bangalore Central as so and so, obtained by defendant number 2 and 3 at the instance of defendant number 1, by way of playing fraud, misrepresentation, and abusing the good faith of the plaintiff by mentioning only a sum of rupees 1 crore as sale consideration amount, and the entire amount is paid to them, leaving the balance amount of rupees 1 lakh is illegal, fraudulent, null and void, and not binding on the plaintiff. Declare that the GPA dated 15/12/2006 is forged, created, and fabricated, one by forging the signature of the plaintiffs, and that the same is illegal, null and void, and not binding on the plaintiff. Declare that the registered sale deed dated 3/4/2023, which is registered before the office of the sub-registrar Bangalore as document number so and so, is sham and collusive one between defendant number 2 to 5, and the same is also sham, collusive, illegal, null and void.
You are claiming
these
to
are-
be the true owner of the property.
Yes, my lord, I'm the true owner of the property
That's
in the
right.
possession
Yeah.
of the same, what it
Plaintiff.
You are claiming to be the true owner of the property.
That's right.
Huh?
That's right.
This power of attorney was
Vendors.
executed by whom?
by them only.
Who executed the power of attorney?
Defendants.
Admittedly, it is by them.
15/12/2006. There is a registered agreement dated 16/12/2006, and there is a power of attorney.
It's all admitted in
Who
the plaint.
executed this one?
Defendants 2 and 3 in favor of defendants 4 and
Not
5.
you.
Not me.
No, 2 and 3, my lord. No. Plaintiffs and defendants.
No.
Lord, may kindly
Agreement is
appreciate the
mine,
second
but
prayer.
power of attorney basis ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿರೋದು.
Correct. The plaintiffs have executed
There's a
registered
registered
agreement
agreement.
of sale and GP in favor of defendants 2 and 3.
23 ನಲ್ಲಿ power of attorney holder executes the sale deed. That's
Prayer
the
only
one which is
answer.
called in question. Therefore, Millets, I said, Millets, I don't mind taking up an order on merits either in this court or on that court. My immediate difficulty is this. The jurisdiction ಪ್ರಶ್ನೆಯಿಂದ ನನ್ನ injunction application ನಿಂತೋಗ್ಬಿಟ್ಟಿದೆ. Let's if the court holds that it's the city civil court which has the jurisdiction, let's I don't mind, I will take the return and present it. If the court holds that this court has jurisdiction, all that I am requesting is whether this court or that court direct the court to hear my injunction applications expeditiously and dispose of
Yes, my lord, we will cooperate.
That
We
is
will
what
not
I
seek
am
for any
asking.
adjournment.
I don't mind with whichever court has the jurisdiction. In fact, Supreme Court says this question is pending consideration. It will not bar the jurisdiction of the court to hear the injunction application. And then the injunction order granted by the court is valid, though ultimately it is found that that court did not have the territorial jurisdiction. And section
there are much more
21
to say.
says that these questions can be entertained only if there is a failure of justice. ನಾವು ಕೇಳ್ದಂಗೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲ ಈ ಕೋರ್ಟ್ ಪಕ್ಕದ ಕೋರ್ಟ್ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮದ್ರಾಸ್ಗೋ ಡೆಲ್ಲಿಗೋ ಹೋಗಿ ಅಂತ ಹೇಳಿದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ನಾವು ಹೇಳ್ದಂಗೆ
what happened is
this court that is the other court in the same building.
In order to extort me, in order they have created agreement of sales. They have produced before the learned trial court. Now the FIR has been registered in respect of those agreements.
Let us not go into all those aspects.
Yes, my lord.
What did you submit regarding the interim prayer?
Here, my lord. No, my lord, it will cause prejudice to me in the sense that, my lord, I have purchased the property and I have got it converted and formed a layout. And, my lord, the suit is based on forged and created documents. And with regard to those documents, my lord,
See,
FIR has also been
you have
registered now.
purchased the property only on 3/4/2023.
Correct, my lord. Thereafter got it converted. I have produced the documents before the Learned Trial Court. along with
Where
my
is the, when did you get the layout approved?
But I have produced all the documents before the Learned Trial Court. I said, it's in the trial court. Before the trial court, we have produced, my lord, along with the application. Because I have also filed an application for rejection of the plaint. Along with that application also, my lord, it's all produced because I have raised the
Please
issue of
tell me,
court
sir,
fee.
when did you get the layout approved? From whom?
My lord, around 15-20 days before filing of the suit, my lord, got the land converted. Now I have entered into various transactions, sale deeds are registered. I have stated so in my application before the Learned Court below. So, my lord, we will not seek for any adjournment in the trial court.
Though the matter is coming up for hearing on interlocutory application. Come on, nevertheless, with the consent of the learned counsels on both the sides, the matter is taken up for final disposal. Full stop. Next para. The issue brought before this court lies in a narrow compass. Full stop. The issue is whether the suit schedule property falls within the jurisdiction of the Bangalore Rural District Court or whether the City Civil Court, Bangalore. Full stop. The impugned order has been passed by the first additional senior civil judge, Bangalore Rural District, on a memo dated 12/2/2024, filed by the petitioner, defendants number 4 and 5. Full stop. Defendants number 4 and 5 took up a contention that the property is situated at Yelenahalli village, Bangalore South Taluk, and in terms of the notification bearing number law 247 LCE 80 dated 10/11/1980, the suit schedule property falls within the territorial jurisdiction of the City Civil Court, Bengaluru, and not within the territorial jurisdiction of the Bangalore Rural District, Rural District Court. Full stop. That contention was negatived by the learned first additional senior civil judge, while considering the notification dated 10/11/1980, and section 4(4) of the City Civil Courts Act 1979. And accordingly, it was concluded that there is no clarity on this aspect of the matter, and there was definitely uncertainty. Full stop. Therefore, falling back on section 18 of the CPC, which provides that where it is alleged to be uncertain, any one of the courts may record a statement to that effect and thereupon proceed to entertain and dispose of any suit relating to that property. Full stop. Next para. Learned counsel for the petitioner, however, draws the attention of this court to the notification dated 10th of November 1980 and submits that the notification has been issued by the government of Karnataka in exercise of powers conferred by subsection 3 of section 8 of the Code of Criminal Procedure, 1973, declaring the limits of the metropolitan area comprising the city of Bengaluru. Full stop. Further, attention of this court is drawn to the definition of the term city of Bangalore as found in subsection 2 of section 2 of the Bangalore City Civil Codes Act, 1979, which defines the city of Bengaluru to mean the area for the time being included in the metropolitan area comprising the Bangalore city declared under section 8 of the Code of Criminal Procedure, 1973. Full stop. The learned counsel would further submit that the notification dated 10th of November 1980 declares that the limits of the metropolitan area comprising the city of Bangalore and specified in column number 2 of the table given there below shall comprise all such area within the within the running boundary specified in column bracket 3. Full stop. The learned counsel would therefore submit that all the villages mentioned in column number 3 of the notification will be included within the limits of the city of Bengaluru and not excluded. Full stop. Therefore, the learned counsel would submit that the village Yelenahalli is found in column number 3 and therefore it would be included within the city of Bengaluru and not excluded. We'll stop. Next para. Learned counsel for the respondents bar plaintiffs, however, submits that the predicament of the plaintiffs is that while grappling with the technicalities of the matter, the court has not considered the interlocutory applications filed by the plaintiffs, more particularly seeking an order of temporary injunction directing the defendants not to alienate or create any encumbrance on the suit schedule property during the pendency of the suit. Full stop. Learned counsel would fairly submit that it does not matter to the plaintiffs as to whether the jurisdiction would lie within the city civil court or the Bangalore Rural District Court. Full stop. Learned counsel submits that if this court accepts the contention of the petitioner or defendants and directs the plaint to be presented before the city civil court, the plaintiffs will bow down and accept the verdict. Full stop. However, the interest of the plaintiffs should be protected having regard to the predicament as stated herein above. Full stop. Next para. On hearing the learned counsel for the petitioners and the learned counsel for the respondents, and on perusing the petition papers, this court is of the considered opinion that having regard to the notification dated 10th of November 1980, which undisputedly holds the field insofar as the identification of the territorial jurisdiction of the courts. In the city of Bengaluru, there cannot be any confusion that all the villages found in column number 3 in the table appended to the notification will be included within the city of Bengaluru, and therefore Yelenahalli, the name of the village being found in column number 3 would be included within the jurisdiction of the city of Bengaluru. Full stop. In that view of the matter, the plaint was required to be presented before the city civil court, Bengaluru, and not the Bangalore Rural District Court. Full stop. Next para. Nevertheless, this court is also of the considered opinion that
my application for rejection of plaint is also pending, so that may have to be considered.
Huh?
I have filed an application for rejection of the plaint also before the London trial court.
No difficulty.
They are asking the return
all
of the
applications
plaint.
will be considered, but even before the applications could be considered, you should not be permitted to do something that would cause prejudice to the plaintiff.
Lord, looking at the conduct, my lord, the nature of the
No, sir.
No, may I make this submission, my lord? With regard to the agreements,
I will
which they
give
have
necessary
produced-
directions to consider all the applications, including your application. But till then, you please maintain status quo.
But my only apprehension is this, my lord. If this honorable court restrains me, my lord, that will have direct influence on the learned trial.
No, not on the
They will be
merits of the
inclined.
matter. It is only having regard to the problem that is created because of the jurisdiction of the court. That is all. I have not considered anything on the merits of the matter.
I understand that, my lord, but
Yes.
our experience says when such an order is passed.
No,
by
I will give a time
honorable-
frame within which the application should be considered.
No, my apprehension is this: since the High Court has granted interim relief, I will also grant.
Rey,
that
ಮತ್ತೆ
will
ಅದೇ
be the,
ಹೇಳ್ತಿರಲ್ರಿ. I have not considered anything on merits of the matter, sir. I will make it clear.
Please.
When was the plaint presented?
So it was presented on 27/1/2024.
27th January. 27th January.
27th January. ಏನ್ ಹೇಳಿದೆ?
This memo was filed on 21st March. 5 months, exactly 5 months ago.
The interest of justice would require certain directions to be issued in the interregnum to ensure that appropriate orders are passed by the city civil court considering the interlocutory applications filed by both the parties. Full stop. Next para. Accordingly, the writ petition is allowed. The impugned order dated
Thirteen three 2024. 13/3/2024. 13th March.
13/3/2024.
Sorry, 15/3.
15/3/2024. On memo dated 12/2/2024 is hereby quashed and set aside. Full stop. The plaintiffs
Trial court is directed to return the plaint.
The trial court is directed to return the plaint to the plaintiffs to enable the plaintiffs to present the same before the city civil court, Bangalore. Full stop. The plaint shall be returned to the plaintiffs, and the plaintiffs are directed to present the plaint before the city civil court. Represent the plaint before the city civil court within a period of 1 week from the date when which the plaint is returned to the plaintiffs. Full stop. The parties are directed to maintain status quo in respect of the possession of the suit scheduled properties for a period of 8 weeks to enable the city civil court to take up the interlocutory applications of the plaintiffs as well as the defendants. And pass appropriate orders within the time frame granted by this court. Full stop. It is also made clear that this court has said nothing on the merits of the matter, and therefore the directions issued by this court to the parties to maintain status quo shall not in any way prejudice the case of either of the parties before the city civil court. Full stop. Next para. Since a time frame has been fixed by this court, the petitioners herein are also put on notice that no sooner the plaintiff is represented before the city civil court, they shall ensure that they will receive notice at the hands of the city civil court.
That Order 7 Rule 10A takes care of that.
ಹೌದಾ?
Represent ಮಾಡುವಾಗ ಈ ಕೋರ್ಟು ಹೊಸ ಕೋರ್ಟ್ಗೆ ಇಂಥ ದಿವಸ ಅಪಿಯರ್ ಆಗಿ ಅಂತ ಅವರೇ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು ಅಂತ Order 7 Rule 10A.
But administrative settle it has to be allotted and subject
Therefore,
to
the
return.
Present court may also be directed to fix a date for appearance of the defendants in the city civil court as contemplated under Order 7 Rule 10A.
They will enter appearance before the city civil court in terms of the directions that would be issued by the
Court returning the plaint.
court returning the plaint in terms of
Order 7 Rule 10A.
Order 7 Rule 10A. Full stop. Ordered accordingly.
Grateful.
Grateful.
Number 48.
Per the petition. Yes.
To make on submission.
Yes.
Entered appearance today in the morning. This morning.
Learned
filed
counsel
Mokala.
Shri
Shrikant Patil K.
Shrikant Patil K submits that he has entered appearance for
respondent, sole respondent.
for the sole respondent.
Please.
Full stop. Office to verify and show the name of the learned counsel in the cause list.
Next.
Release this matter on 3rd of September.
Interim.
Huh?
Interim order.
Interim order granted earlier stands extended till the next date.
IA ಇದೆ ಸಮಯ ನಮ್ಮ
ಅದಕ್ಕೇನೆ
ಅಲ್ಲ IA ಕಾಪಿ ಸರ್ ಕೊಡ್ತೀನಿ ಪ್ಲೀಸ್ ಐ ವಿಲ್ ಕಲೆಕ್ಟ್
ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ.
Yes.
Further hearing.
Huh?
For further hearing. Serial number 61. Pramod Mallur.
ಯಾವ್ದು ಇದು? Matters called out. There is no representation for either of the parties. Release this matter on 3rd of September.
Hearing in B group. 49, Rajgopal Naidu.
Matters called out. There is no representation for either of the parties. Release this matter on 3rd of September.
Serial number 50. Putika Raghavan. For the petitioner, my lord. Lord, we are seeking a short adjournment in this matter.
At the request of learned counsel for petitioner, release this matter
Next week, my lords, 28th or 29th of next week.
on 28th of August.
Grateful. Are you, interim order may be extended.
Interim order granted earlier stands extended in the next date of hearing.
Grateful. 51, HR Ananta Krishnamurthy.
We are for the petition this case, my lord.
Ah,
We are for the petition this case.
ah,
Annexer H is the dispute, my lord. The moment your lordship turn to the
matters called out. There is no representation for the respondent. Stop. Release this matter on 3rd of September.
much of it.
52. Pramod Gaud B. Chambagi.
No, the suit is for declaration and injunction.
ಇದು ಅಷ್ಟೇ. ಈ ಹಳೆ ಮ್ಯಾಟರ್ಗಳು ಯಾರು ಬರೋದಿಲ್ಲ.
Interim order ಇರುತ್ತೆ ಹಂಗಾಗಿ.
Matter is called out. There is no representation for the respondent. Release this matter on 3rd of September.
Number 53.
Within the counsel for petitioner. There is another connected matter, Manad, it may be called along with that.
Yavadu?
That is Manad 38,688 of 19.
38
688
of
19, same.
list this matter along with WP number 38688 of 2019 on 3rd of September.
Interim order may kind.
Interim order granted earlier stands extended till next date of hearing.
Before Ajesh Kumar, yes.
For the respondent, senior is in VC, my lord.
Mr. Abhinav.
Mr. Abhinav Ramanand Aidara.
Yes, my lord. I appear for the respondent.
Yes.
My lord, an arbitration award came to be passed, my lord, as per Annexure B at ink page 38. Subsequent to which, my lord, I sought to execute the arbitration award. One fact I should bring to my lord's kind attention is that this arbitration award was challenged by the respondent under section 34. And a part of the award came to be modified. So both of us are before the Honorable High Court under section 37. But what I am impugning, my lord, is the imposition of penalty on the stamp duty. My lord, as per the law declared by the Supreme Court, that the stamp duty payable on the award is only at the time when I'm going to enforce it, not prior. So, my lord, when I submitted the award for execution, the trial court, the executing court, my lord, got the office to calculate what is the stamp duty on the award. And I accordingly paid it. Thereafter, the judgment debtor, my lord, filed objections saying that the stamp duty paid is not sufficient. The executing court, my lord, asked me to pay a further sum of 5 lakhs and odd, but also asked me to pay the amount of penalty. I have 10 times. That's as per section 33 of the Stamp Act, saying that I have
on the award,
on the stamp duty, on the stamp duty. My lord is pleased to see
stamp duty for
the award, on the award. Because, my lord, I can only pay the stamp duty only when it is submitted for execution.
Which is the provision?
Yes, my lord. Section 33. If I may take my lord to the Arbitration Act.
That.
Section 36.
Because.
Yes, it doesn't provide for stamp duty. Yes. Section 36, my lord, of the Arbitration Act says about enforcement. It says that subsection 1, where the time for making an application to set aside the arbitral award under section 34 is expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure in the same manner as if it were a decree of the court. Therefore, my lord, the only time the Supreme Court says that you have to pay the stamp duty only when you submit it. Now, having submitted, in fact, a coordinate bench of this honorable court has held that an arbitration award is not an instrument like any other instrument. Therefore, the question of 10 times doesn't come in. So only to that extent, my lord, at ink page 148.
No, where is the question of delay?
Delay is not there. That's what I'm saying. Delay is not there.
See, if a decree is passed.
Yes, ma'am.
And a decree is to be drawn.
Yes.
They'll ask you to give the requisite stamp papers.
Yes.
So, they will calculate.
Yes.
Or you will calculate what is the stamp duty payable on the decree.
Yes.
If it is to be written as an instrument.
Yes.
And you will calculate and accordingly pay it.
That's
the cause of action arises at that point of time, and you are paying it at that point of time. Where is the delay?
Yes, madam.
To levy penalty?
Yes, that's what fell for my lord is exactly what a coordinate bench also has held.
Yes.
And my lord is pleased to see the order sheet, exactly what fell for my lord. Ink page 125. Ink page 125. On the top left, my lord is pleased to see
that as per section so and so, on the award amount so and so, that is 4,25,000 pay deficit duty of 12 lakhs. So that, my lord, the next page, 7-6, same page at the bottom, I've paid this. The counsel for decree holder along with the memo submitted DD bearing number so and so towards payment of stamp duty.
Yes.
Then, my lord is pleased to see, ink page 134, because it's a matter of review, on 4/4/2018, my lord, pursuant to objections raised by the judgment debtor, the executing court asked the office to once again calculate the stamp duty. Thereafter, my lord, the impugned order came to be passed on ink page 148. Asked me to pay deficit stamp duty of 5,60,000, which I will not dispute, I will pay. And 10 times the penalty amount. That's the only part I am concerned with.
Yes, Mr. Abhinav.
My lord, there is no
penalty ಹೆಂಗ್ ಬರುತ್ತೆ
there is no dispute, my lord, that the award has to be, my lord, stamped only at the time of execution. I am not disputing that proposition. But before, my lord, he initiates execution, he should get the award stamped. Or, my lord, what he can do is he can file the execution and then it has to be impounded and penalty has to be paid. Now, what has happened in this case is, my lord, he files the execution and then, my lord, there is a certain stamp duty that is paid. According to him, my lord, stamp duty is adequate. We raised an objection saying that the stamp duty as per the Karnataka Stamp Act is not paid. Therefore, the award is insufficiently stamped. We did not raise an objection as regards the timing of payment of the award. Award, my lord, stamp duty has to be paid only when it is brought in execution. There is no dispute about that and we are not raising that objection. But once it is brought for execution, it has to be adequately stamped. If it is not adequately stamped, then, my lord, it has to be impounded and balance amount has to be paid with penalty. That is our submission. That has been accepted by the executing court. We are not saying there is a delay. When an insufficiently stamped instrument comes to the notice of the court, my lord, court is duty bound under 33 to impound it. Now, court did impound it because it felt that the stamp duty paid is 5 lakhs less. And therefore, my learned friend has also said, as a matter of fact, that it is insufficiently stamped. If it is insufficiently stamped, then the consequences under 33 and 34 will follow. That is what we have told the court and court has said it. So therefore, we did not say that. Office, my lord, not by me. My lord, he cannot now. My lord, the Stamp Act does not say that, my lord, the office has to calculate the duty and penalty. In fact, my lord, provisions of the Stamp Act would say he is required to get this stamped and then produce it before the court. He does not. Where? Stamped before the registrar, my lord. District registrar.
Is that the provision?
Yes, my lord. That's the argued Dilli Babu's case, my lord. Yes, my lord. Dilli Babu's case, my lord, coordinate bench. Coordinate bench, my lord, Justice Bopana, as he then was, my lord, said that the duty and penalty has to be calculated on the day the award is passed. But it will have to be paid before you levy execution. That is not done in the case. So therefore, they produce an unstamped, my lord, award before the court. Then, my lord, since it is unstamped, my lord, the registry of the civil court calculated, my lord, the duty, stamp duty payable at a certain rate. And then, my lord, it was stamped. We raised an objection saying that even now, after the duty and penalty, duty is calculated by the registry, it is insufficiently stamped. Since it is insufficiently stamped, please proceed to take action.
Insufficiently stamped Allah. You could have said, yes, there is still deficit.
The deficit and insufficiently stamped, because this honorable court, my lord, in Dilli Babu's case, held that, my lord, all provisions of the act.
Let us see. Which is that judgment, we'll see.
My lord, there's a recent judgment which addresses Dilli Babu's case.
Yes.
My lord, before that, if my lord is pleased to see section 33. Section 33 of the Stamp Act covers, my lord, what fell from my lord only for instruments. And a arbitration award has been held by a coordinate bench of this court. That an award is not an instrument, section 33. Examination and impounding of instruments.
Is a decree passed by the court an instrument?
In Dilli Babu's case, my lord, it is held to be an instrument.
A decree passed by.
Yes, my lord. Please see the
competent
definition
court.
of the word instrument, my lord. My lords will get the definition of the word instrument.
Before Mr. Abhinav proceeds, my lord, I just place the judgment.
Yeah, my lord, he can
Covers that.
finish, my lord. Once he finishes, my lord, I'll reply, my lord.
My lord, please to see Anasuya Devi's case, my lord, insofar as stamping is concerned. Section 33, my lord, is pleased to see in that.
Yes.
That specifically says examination and impounding of instruments, subsection 1. Every person having by law or consent of the parties authority to receive evidence, and every person in charge of a public office, except an officer of the police before whom any instrument chargeable in his opinion with duty is produced or comes in the performance shall, if it so appears to him, is not duly stamped, impound the same. For that purpose, every such person shall examine every such instrument so chargeable, so produced before him. Therefore, my lord, if we take Mr. Abhinav's logic, then the day I give it, because it's not stamped, the day I present it, therefore, that first day itself, because if it is a sale deed, which is not stamped, then Mr. Abhinav's argument, I would also concede. It's not stamped, the court has the duty under section 33 to impose 10 times. Then I will go before the registrar and I will plead my case saying that please give me a concession for the grounds available. But here, my lord is pleased to see that because Mr. Abhinav touches on the deficiency, in Anasuya Devi's case, my lord, in para 4, the Supreme Court addresses, in paragraph 4, my lord, the 4th line, the question in paragraph 4, my lord. In fact, the issue was premature, so and so. The question as to whether the award is required to be stamped and registered would be relevant only when the parties file the award for its enforcement under section 36 of the Act. This is one aspect. Now, this is further elaborated, my lord. Therefore, only at that stage. And then, my lord, in the case of Shakil Pasha, my lord, I just placed for my lords, 3 questions were framed by the Honorable Court, page 15, my lord, paragraph 14, page 15. 3 questions were whether the impugned order under challenge in determining the stamp duty in terms of amended Article 11B2 of the Karnataka Stamp Act suffers from infirmities and is contrary to the law laid down by the Honorable Apex Court in the case of Anasuya Devi, followed by the court in case of Dilli Babu. That would not be relevant for us, my lord. The second and third would be whether an arbitral award, though falls within the definition of instrument as stipulated under the Stamp Act, can be really treated as an instrument in true sense and therefore would warrant penalty while enforcing the arbitral award under section 36 of the Arbitration Cancellation Act. And 3.
Mr. Abhinav? You have a copy of this judgment?
No, my lord, I'll retrieve it. I think he is.
I've given it to his colleague.
Yes, my lord.
Yes.
And third question, whether the court below was justified in levying penalty on the arbitral award by entertaining an application filed by the judgment debtors in the execution proceeding under section 36 of the Act. My lord is pleased to see para 17 at page 18. That is question 2 and 3, my lord.
Yes.
Interestingly, the Act of 1996 does not mandate parties to pay stamp duty on arbitral awards. It is the Karnataka Stamp Act which expressly requires stamp duty to be paid on arbitral awards, failing which the unstamped or inadequately stamped awards can be impounded and will be inadmissible in courts. The Stamp Act is a fiscal statute that levies a charge on the execution of instrument. An instrument is defined as a document by which any right or liability is or purported to be created, transferred, limited, extended, extinguished, or recorded. The logic behind an award being subject to stamp duty is that an award falls under this definition of instrument. There appears to be no available literature which explains the basis for subjecting an arbitral award to stamp duty. While the courts have had several occasions to dwell into the question of whether an unstamped or inadequately stamped award is inadmissible, can be impounded, or can be used as a valid ground to set aside the award. However, the question of whether the arbitral award falls within the definition of instrument as stipulated under the Stamp Act in the first place, and should it even be subject to stamp duty, need consideration at the hands of the court. An arbitral award stems from adjudication of a dispute where one party wins and the other party loses, subject to any settlement agreement entered into between the parties during the arbitration proceedings, which will anyway be subject to applicable stamp duty. An arbitral award is not a creature of consent, but a unilateral expression of adjudication, which conclusively determines the rights and liabilities of the parties in relation to the subject matter in dispute. And then, my lord, the next paragraph, it is trite law that an arbitration proceeding is the nature of quasi-judicial proceedings, and that the arbitral award is a decree of court vis-a-vis its enforcement. Presumably, an award was mistakenly believed to be in the nature of a settlement agreement facilitated through the process of arbitration, mediation, or conciliation. This misplaced understanding is also reflected in Section 89 of the Code of Civil Procedure, where arbitration is perceived to be a mechanism to execute settlement agreements, and hence an award stemming from an arbitration is possibly misconstrued to be an instrument. Taking note of the interplay of both the acts, it is evident that an award cannot be acted upon by the court unless it is duly stamped. The Honorable Apex Court in the case of Anasuya Devi opined that the question of stamping the award is uncalled for at the stage of setting aside the proceeding under Section 34 of the Act of 96. Further, the Apex Court has held that non-stamping of the arbitral award is not a ground for challenge under 34 of the Act, but can be considered as ground to object at the stage of enforcing the award under Section 36 of the Act. Various high courts, while taking note of the Apex judgment rendered in Anasuya Devi, have often faced difficulties as the law regarding impounding unstamped, insufficiently stamped award while hearing a petition under 34 of the Act is unsettled. In the above backdrop, the anomaly with respect to the application of Section 33 of the Stamp Act while hearing a petition for setting aside an award under Section 34 of the Act still continues to subsist. Several recommendations are made by the Law Commission in light of the arbitrators appointed under the new Act, have raised several questions as to what should be done when the original award, once it is signed. There have been recommendations to incorporate a new provision to Section 31, subsection 1 of the Act on the lines of 14(2) of the Arbitration Act, which would clear all the problems relating to stamping of arbitral awards. The recommendations are also made to amend 31(1) and 31(5) of the Act, and in addition to provide that if the award requires compulsory registration under 17(1)(b) of Registration Act to have it duly registered. Therefore, unless there's an amendment to Section 31(1) of the Act of 1996 mandating award to be duly stamped and compulsory registration, whatever it is required, this anomaly will continue. In the present case in hand, the question that requires consideration is as whether the executing court was justified in imposing penalty. An insufficiently stamped instrument, if tendered in evidence, has to be immediately impounded by the court or an officer receiving the document. We are dealing with the case of an arbitral award, which requires stamping only at the stage of enforcement. It is trite law that a domestic award has to be stamped just before its execution. Therefore, I'm not inclined to accept the mandate under Section 33 imposing the duty on the court to immediately impound in respect of insufficiently stamped arbitral award. We are dealing with an arbitral award which by fiction assumes the character of a decree. Therefore, stamping and registration of an award is a matter which the court has to see only when the parties file an award for its enforcement. The concept of imposing penalty on an insufficiently stamped instrument cannot be applied to an arbitral award in an execution proceeding. In light of the discussion made supra, if an arbitral award by fiction assumes a character of a decree, the executing court cannot impose penalty. An arbitral award is sought to be enforced and is not subject matter of adversarial lists which cannot be tendered in evidence for want of sufficiently stamped duty. The principles applicable to an insufficiently stamped instrument under Section 33 and 34 of the Stamp Act cannot be extended to an arbitral award when the same is sought to be executed under Section 36 of the Act of 96. A decree holder has not tendered an arbitral award for adjudication. On adjudication, an arbitral award is passed by an arbitrator. The said award on dismissal of the application so-and-so is sought to be enforced by the decree holder. If a decree holder has paid the stamp duty and has sought for enforcement, even if the stamp duty deposited by the decree holder is found to be insufficient, that will not attract the provisions of Section 33 and 34 of the Stamp Act in execution proceedings. As rightly pointed out by learned counsel appearing for the decree holder, it is really agonizing to learn that the decree holder is unable to enjoy the fruits of the arbitral award. The decree holder is virtually compelled to go through so much struggle to execute the award which has already been granted in his favor after a hard and arduous battle. Then the next is about the other aspect. My lords, please turn to page 25. Just before para 25, the second sentence. Therefore, the question of imposing penalty would not arise. Therefore, the order of the executing court in imposing penalty is liable to be set aside by this court. The stamp duty collected by the executing court is also contrary to the law laid down by the Honorable Apex Court in the case of Anusuya Devi. And then next page, my lord, page 26. Just before conclusions, all the decree holder is required to do is pay the requisite stamp duty to enforce the arbitral award seeking recovery of money. And then the conclusions are given. Conclusion 2, after the arbitration process is completed, the merits are given finality by issuing an arbitral award. By way of legal fiction, the award is to be treated as a decree. Such legal fiction is created for the limited purpose of enforcement of an award. Arbitral award is tendered in execution proceedings for enforceability of an award. Therefore, Section 33 and 34 of the Stamp Act, which mandates and requires an insufficient stamped instrument to be impounded and consequently to be imposed, cannot be extended and applied to arbitral awards. An award stemming from arbitration is possibly misconstrued by the executing court to be an instrument. The executing court, therefore, erred in impounding the arbitral award in executing proceedings under Section 36 of the Act. And this is the repetition. My lord, please to see para 4. The executing court has imposed 10 times penalty, which is not at all sustainable. The cost of implication for award holders negatively impacts the choice of arbitration as a method of alternate dispute resolution. And if the courts start imposing penalty on an arbitral award, then the decree holder would have benefit of an arbitral award, have to unnecessarily incur additional costs for enforcement despite having an award in his favor. And on this ground, my lord, the order passed at page 31, para 26. The writ petition is allowed in part. The imposition of penalty is set aside. Only the third part, my lord, because the Honorable Supreme Court this had gone up to the Honorable Supreme Court. Para 3 came to be modified by the Supreme Court. I'll just pass on that part.
Para 3 of the operative portion.
Operative portion.
That is, the executing court shall redetermine the stamp duty payable in terms
Yes.
of unamended Article
Yes.
11B of the Karnataka Stamp Act, and
Yes.
thereafter proceed. The
Supreme Court says that the question of penalty is not the duty of the court, the appropriate authorities. Only to that extent, otherwise the order has been upheld.
Now, for the benefit of Mr. Abhinav,
Yes.
you can read this.
Yes, ma'am.
My lord, I have the judgment, my lord, of the
Yeah,
Supreme Court.
all right.
Yes, my lord.
Now that the matter is decided by the Supreme Court.
Yes, my lord. Now what the Supreme Court now says, my lord, is in terms of modification made to clause 3 of, I am reading the Supreme Court
Yes,
order, my lord.
yes.
In terms of the modification made to clause 3 of para 26 of the operative portion of the impugned order, impugned judgment, and the clarifications made above, appeals are allowed in part. Now,
Yes.
what is the change that is made is, my lords will kindly see. Please turn to the first page itself, my lord, second paragraph. Now there is a dispute between the parties that the stamp duty payable on the award will be in terms of Article 11 of the schedule of the Karnataka Stamp Act 1957. To that extent, clause 3 of para 26 of the operative part of the impugned order is modified, as clause 11B was brought on schedule by an subsequent amendment with effect from 1st March 2014, and the award was made earlier to that. That will not apply to our case. In this case, the executing court, in purported exercise of powers under 33 and 34 of the Karnataka Stamp Act, directed penalty to be paid on account of non-payment of stamp duty and the arbitral award. The observations made in the impugned judgment will have to be understood in the context in which the same has been made. Under the Karnataka Stamp Act, there is no power conferred on the courts to direct payment of penalty. My lord, this may not be strictly correct, but ultimately, my lord, this is what the Supreme Court has held.
That is falling out from the
Yes,
Supreme
my lord, it is falling foul of section 33 and 34.
Ah.
Now, under the Karnataka Stamp Act, there is no power conferred on the courts to direct payment of penalty. It is the power of the appropriate authorities under the Stamp Act to impose penalty. So, therefore, the net effect is, my lord, if it is insufficiently stamped, penalty will have to be imposed. Now, what the learned Supreme Court says, my lord, is there is no power. Of course, that may be an obiter because there is a clear power conferred under 33 and 34. Even if that is taken into account, that is the Supreme Court order is taken into account, penalty will have to be decided by the appropriate authority under the Act. That is what the Supreme Court says. So, therefore, my lord, penalty nevertheless becomes payable. At best, my learned friend can use it to the extent saying, look here, the executing court could not have decided on penalty. It will have to be the competent authority under the Stamp Act to impose penalty. But fact remains, my lord, penalty will become payable.
This is to respond, my lord. The issue which the Supreme Court addressed was at page 15, issue number 1. That was the issue of 11B2, which I never read out because it's not applicable in my case. If my lord is pleased to see page 15, para 14, issue number 1, that concerns 11B. Supreme Court has not interfered with the finding insofar as whether an arbitration award is an instrument at all. And the finding of the learned single judge has attained finality to the extent that an arbitration award for the purposes of levying penalty is not an instrument. Issue number 1 came to be addressed at paragraph 15 to 16. That is what finds its place in paragraph number 26 subclause 3, 11B. 11B is concerned with para 26 subclause 3. Here, my lord, if we take Anasuya Devi's case and this judgment of the coordinate court, I go before the court to say, sir, I want to execute it. The court tells me pay 12 lakhs. I pay 12 lakhs. After I pay 12 lakhs, therefore there is no intent for me to avoid payment of stamp duty. After I pay stamp duty, the judgment debtor says, no, the calculation is wrong. So to that extent, I am bound to pay that 5 lakhs. I am not disputing. The only aspect is penalty. That's all.
Lord, he cannot put the blame on the executing court, my lord. If he wants to execute an award, my lord, the provisions of the Karnataka Stamp Act says stamp duty must be levied. In fact, he should have got it stamped and then produced it before the court because he knows he is going in for execution. So therefore,
Notice was issued only after I paid the stamp duty.
So
Notice
therefore,
was
obligation was on him to pay stamp duty and then to put the stamped award in execution. He does not do so. He produces an unstamped award before the executing court. The registry of the executing court, my lord, in its wisdom, my lord, says this is the duty and penalty. And therefore, my lord, some duty is collected. Now he cannot, my lord, say, no, this is the duty which the executing court collected and therefore I am absolved. The primary duty was on him to pay the requisite stamp duty, get it stamped and thereafter produce it before the executing court. Because he wants to rely on this to execute the award. And Anasuya case, my lord, says that it is at that point in time that the court must consider the aspect of stamping and registration.
11.
Article.
Yes, my lord. Article 11, my lord. Yes,
Article
it is,
11.
my lord, in fact, peculiar only to Karnataka, my lord. This is the only place where such huge, my lord, stamp
Article
duty is collected.
Article 11B, because this is for money. And this is the standard procedure, my lord, where everybody, when they execute the award, they file the award unstamped before the trial court. It's not that I have done something out of the way. This is the procedure followed. We file the award, then the court directs the office to calculate the stamp duty, and we pay it. Only after that notice is issued. My lord is pleased to see even the order sheet. It's not taken on record till the stamp duty is paid, in page 126. Notice is issued only after that. So it's not that after post notice that the stamp duty was paid.
So there is no provision under the Arbitration Act.
No.
No,
not at
provision.
Arbitration
In
Act
fact,
does
for
not say,
international
my lord,
awards, the Supreme Court has already clarified that there is no stamp duty required because this award is interpreted to mean only domestic awards. So if I get an international award against my learned friend's client, then I don't have to pay stamp duty also.
Lord, it is only probably in Karnataka, my lord, that there is a separate article, my lord, which says that this is the stamp duty payable on an award. Otherwise, my lord, in all other states, I am given to understand, my lord, that a clause similar to Karnataka Stamp Act, my lord, is not there.
Actually, what my lord may be pleased to kindly consider that if some guidelines are given to the executing court, that when, my lord, in fact here, when we went to execute it, we said, should we pay it first? Then it was told to us by the office that you file your petition, deposit it, the office will calculate it. Because if it is the High Court, my lord, the High Court will not calculate on its own. It will direct the district registrar to calculate it and then the High Court will pass orders. Here, my lord, the court will pass the order on its own. There's a distinction between the High Court and the
Lord, in fact, my lord,
trial court. Therefore, the procedure which is accepted is that you file the execution petition with the award, the office will calculate the stamp duty, we pay it. Because what Mr. Abhinav is concerned with stamp duty, I have paid it. And it is only after I have paid it that the office has issued, the court has issued notice. Till then, the court has not even taken cognizance of it to that extent.
No, that is why so much has been said in this
Yes,
judgment.
yes. Even to the effect of that instrument, whether it's an instrument equal to a sale deed or a sale agreement.
So this judgment has not been fully considered.
Yes.
They have gone only on
Yes.
the first issue.
First
as you
issue.
said.
Second
Yes.
and third issues upheld,
It
But
remains
Lord-
undisturbed.
undisturbed.
Yes, my lord. To that extent, it is there. But what the Supreme Court does say is, my lord, question of penalty, let the authorities decide it, because under
That
the
is if it
Stamp
is
Act,
an-
court does not
Clause
have the
one.
power
No,
to, my lord.
no. In this judgment,
Yes, my lord.
the coordinate benches clearly held
Yes, my lord.
no question of levying penalty. That has not been disturbed by the Supreme Court.
My lord, in fact, if my lord can
It has been clearly held. No, it is not impermissible
yes, my lord.
for the court to
Correct,
levy
Lord.
penalty.
My lord, that, my lord, with great respect, my lord, runs contrary to the Stamp Act, which I will demonstrate. My lords may kindly take the definition of, my lord, instrument. Under the Stamp Act, my lord, please take the definition of the word instrument. My lords will get it at 2J. Please have section 2J, my lord. Instrument is defined.
Yes.
Instrument includes every document and record created or maintained in or by an electronic storage and retrieval device or media by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. So therefore, my lord, if award is an instrument, if it, my lord, records any right or liability, my lord, in the present case, a liability is fixed under the award. Of course, my lord, my learned friend was fair enough to say, my lord, now under section 34, it was challenged and there is partial, my lord, setting aside of the award. And both of us are now before, my lord, the commercial appellate court challenging it. That is a separate aspect. But if my lords were to strictly see, my lord, an award does come within the definition of the word instrument under 2J because it is a document by which...
No, if that is the case, see,
yes.
Unlike the other instruments, where whenever it is executed,
yes, my lord,
you are required to pay the stamp duty.
That is what, my lord, in Dilli Babu's case, my lord, Dilli Babu's case, my lord.
No, I have it.
Yes, my lord. Dilli Babu's case, my lord, ILR 2015, 4336.
Good.
I think, my lord,
Yes, I have it
Mr. Rajesh has passed it over,
Yes,
passed
yes.
it on to the court. There, my lord, please see, they consider Anasuya's case, and thereafter, my lords will kindly come to, my lord, para 7. A perusal of the same would no doubt indicate that the Honorable Supreme Court has held that the date on which it would be relevant to consider the validity of the stamping is the date on which the award is sought to be relied upon or sought to be enforced or executed in accordance with law. However, the issue for consideration herein is the relevant date to apply and levy the stamp duty if the stamp duty prescribed is not the same on two dates. That is, on the date of execution of the instrument and the date of its enforcement. In that light, a perusal of section 17 of the Act extracted supra provides that it shall be stamped before or at the time of execution.
At the time of execution.
Therefore, it is the option to be made by the party taking benefit of the instrument to pay stamp duty either before or at the time of execution. The question, therefore, would be with regard to the purport of the word execution as contained in section 17 of the Act. The word execution as defined in section 2F of the Act is as follows. Executed and execution used with reference to instruments mean signed and signature. From the above, it is clear. Whatever be the relevant, what would be relevant for the purpose of quantifying the stamp duty payable on the instrument is the date on which the instrument was signed. However, the question or issue as to whether the document is appropriately stamped will arise for consideration only when it is sought to be relied upon and is available to be executed under Section 36 of the Arbitration and Conciliation Act as held by the Supreme Court in the decision cited supra. Hence, it is clear, though the question in that regard would arise for consideration when parties seek enforcement, as held by the Honorable Supreme Court in the cited decision, the amount of stamp duty payable would have to be computed with reference on the date on which the instrument was signed. In the instant case, instrument is the arbitral award. So therefore, my lord, that it is an instrument, my lord, has already been, my lord, held by Dilli Babu's case. This has not been considered by, my lord, his lordship in the later judgment.
So it's referred to.
And my lord, no, that it has been declared as an instrument has not been noticed.
No. In fact, even the coordinate bench has held that it is an instrument.
Yes, my lord. If it is an instrument,
it is held as an instrument.
Yes, my lord.
But
if it is an instrument, now please have a look at the wordings in Section 33 and 34 of the Stamp Act.
Sir, but how can you ignore Ansuya's case?
Ansuya's case I am not ignoring, my lord.
So the question of payment of stamp duty would arise.
Yes, my lord.
Only when the award is sought to be executed.
No difficulty, my lord.
Section 36.
Yes, my lord. I am not, my lord.
See, there is another problem.
Yes, please, my lord.
There is another problem. See, as in your case only, both of you are now before the appellate forum.
Yes, my lord. Yes, my lord.
So therefore,
in that
if it is modified again.
Yes, my lord. In that sense, it is not finality.
The award remains.
Huh?
Award remains.
Award remains.
Yes.
But it also depends on the type of modification that would be passed. If the claim is reduced.
But I can't pay less, my lord.
Huh?
I can't pay less because the award remains as is. Either, actually, what would happen, my lord, is the award was reduced already.
Huh.
I was awarded repayment of my refundable deposit of around 20 crores with damages of 25 crores. That has been reduced by the Section 34 application saying 25 crores of damages should not be allowed. That is right. That's why we are both before Section 36.
Correct.
Even that I was pondering, my lord, whether that modifies the award insofar as execution is concerned. Because the award remains as is.
No. But what is the basis for payment of stamp duty?
My lord, in Dilli Babu's case, my lord,
Yes.
it is
So
the
it
date
all
on
depends.
the award is made.
On what you are entitled for. So if that is modified again,
I hope
again there should be a reduction.
My lord, that is why I
Does
think
it mean that the stamp duty will be repaid to you? If you have paid more.
As per this judgment of the coordinate bench, my lord, that is for only penalty, not for, then I probably will have to take a remedy under 226 or 227 if I have already paid. If I have, like in my case, I have already paid the stamp duty.
See, but the problem is, as you rightly said, there has to be certain rules.
Yes, my lord.
Yes, my lord.
To guide
Yes.
the parties
Yes.
and the advocates, in fact.
And the advocates, my lord.
None of them know
Yes.
when it has to be paid. Should it be paid immediately after the signature is done?
Yes.
By the arbitral tribunal?
No, madam. That's clear now.
No, but going by the definition of instrument.
Yes.
It says signed.
Signed. Only 36 and Anusuya Devi changes the root of that.
See, essentially, this is not an instrument.
Yes.
Merely because it is brought under the Karnataka Stamp Act, we are falling back on the definition given to instrument. It is not an instrument. It is a decree.
It's a decree. That's why it's as executed as a decree in the...
It's a decree. See, you are paying court fees there.
No. We are paying...
In the normal circumstances.
Yes, we are paying arbitrators.
What cases are required to come to the civil court?
Yes.
Is now being diverted to the arbitral tribunal. Basically, it is a suit only.
It's a suit.
And therefore, an award is nothing but a decree.
Yes, ma'am.
Executable as if it is a decree passed by a civil court,
Please, ma'am.
competent court.
Absolutely.
Therefore, it cannot be construed as an instrument.
In paramateria to any other instrument?
Yes.
Like a sale
It's a
deed or?
decree.
Yes.
Lord, that is why.
Whatever is applicable to a decree should be made applicable here also.
Well, that is why, my lord, probably no other stamp act, my lord, there's a provision similar to the Karnataka Stamp Act which says it must be stamped. In fact, my lord, that Article 11 also, my lord, notwithstanding
If someone challenges that, it will
Yes,
go.
my lord. Yes, my lord. It should go because, my lord, as my lords pointed out, we are paying, my lord, the arbitrator's fee. Everything is paid for. And as my lords
You are paying
pointed
much
out-
more than what would have paid as a court.
Yes.
And then, my lords, it is a decree of the court.
Then
It
Mr.
is-
Abhinav should support my petition.
No,
No,
no.
no, I am
He is fairly saying that because he knows the difficulty. He would have also appeared for many of the decree holders.
Dilip Babu was argued by him. my lord.
Ah. So therefore, if something has to be done in the general interest
Yes, my
of
lord. In fact, some guidelines from my lord, by my lords, that, my lord, I think what I have found, which was actually subject to what my learned friend would say, is that if you are executing it, when we give it to the office of the executing court, my lord, that they calculate the stamp duty, we pay it, then after that notice is issued. And that's exactly what, my lord, they have done. That seems to be convenient with nobody having any prejudice. Because if I don't pay the stamp duty, no notice is issued by the court. And in fact, consistently the word used, because even Dilip Babu, there was no penalty imposed. The moment I file, the office raises the objection saying, please pay it. I pay it. Only after that, it's only, I think, what Mr. Abhinav argument may further sustain is if I, by mistake or by oversight, no stamp duty is paid and notice is issued, then the stamp duty would be paid later. But then by the coordinate bench's judgment, question of penalty will never come. That will never come. It's like me going to the sub-registrar's office to register the sale deed.
Yes. When
he
he says-
receives the document.
when he says, no, you have to pay more.
Pay more.
You calculate and again you will
Yes.
pay the remedy.
Please, my lord, yes. And if the sub-registrar, if I would go by Mr. Abhinav's argument most respectfully, then I submit a sale deed on a white sheet. Moment the sub-registrar receives it, because he will be an authority under section 33.
He does
Straight
not
away
have the
say,
power to
pay
receive
penalty
evidence.
of 10
No, no,
times.
no. That is entirely different, my lord. He is the registering authority. He is the person, my lord, who has to calculate the stamp duty. That
No,
analogy
he doesn't have to
is correct.
calculate. I can
That
calculate.
analogy is not correct, my lord. That analogy is not correct.
I can also calculate.
No. See, all this is because there is no proper
Yes, my lord.
guidelines.
Yes, my lord.
There
Yes,
are
my
no
lord.
rules.
True, my lord. True.
And as you rightly said, this provision is found only in our
Yes, my lord.
statute.
Yes,
In
my
no
lord.
other state it's
No other
found.
state.
No other. There's a
Then
flat.
there is no question of stamp duty, penalty, nothing will come.
Nothing.
In all other states, my lord, there's
That's
a
why
flat-
other states are becoming more arbitration friendly.
No, my lord, there's a flat, my
In fact,
lord.
if you go
fixed
to
stamp
Delhi or
duty.
the
And, my
first
lord, what the
Section 34
arbitrator
comes
does.
to the High Court. Man. Section 34 in Delhi and Bombay, I think even Madras, if I'm not wrong, would come to the High Court. Then 37, because the learned retired former judges of the High Court or Supreme Court are presiding on it. So there's some seriousness about the matter. My lord is pleased to give some guidelines, my lord, in terms of execution. Because even we faced the difficulty when we were seeking enforcement of this award. And the same question was before us. Do we first?
So we will have to request the High Court to formulate some
Yes.
rules.
Yes, my lord, there are already arbitration rules, my lord, formulated by the High Court. My lord, I think we will have to include a provision in that, my lord.
But that is 2004 rules, if I'm not wrong.
Yes, my lord. 2004 rules are there.
Very, they need probably a fresh look because Arbitration Act has gone through amendments 2015, 19. Again, amendments are coming. The rules are not yet. In fact, when we see other courts, my lord, other jurisdictions, the rules are sacred. We look at London Court of International Arbitration, International Court of ICC, Paris, Singapore. The main basis of arbitration are the rules, my lord, which give everybody clarity. And as it fell for my lords, that whether we go before the court or the arbitrator, we are only seeking adjudication of a dispute, nothing more, no creation of a right.
I'll pass orders then.
Please, Madam.
Heard reserved.
Well, the interim order may be extended. Madam.
Interim order granted earlier stands extended in the next date of it.
Grateful.
We will file a short synopsis and give the judgments, my lord.
All right, yes.
Yes, my lord. Grateful.
Serial number 57. 55.
R1 to R.
57 ಇವತ್ತು ರೀಚ್ ಆಗಿದೆ ಫ್ರೈಡೇ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಫಾರ್
No dates. ಎಲ್ಲಾರು ಹಂಗೆ ಹೇಳೋದು.
ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್
No dates.
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಫ್ರಮ್ ದಿ ಗವರ್ಮೆಂಟ್
It is not come, if it is not reached today, it will come up next week.
Monday.
I can't give any dates to any of the matters.
56.
Sir, next week.
Sir, 50. Sir.
Date ಕೊಡಕ್ ಬರ್ಬೇಕು. Sir, next week ಅಂತ ಅಲ್ಲ. ನಾವು
Reach ಆಗಿಲ್ಲ. Reach ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಇಂಟ್ರಿ
ಮಾಡಿದ್ರೆ extend as it is.
Number 51.
55 ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್
55. ಇಲ್ಲ next week sir.
51 sir. 51.
5139. ಮೂರನೇ ತಾರೀಕು. ತಂದ್ರಲ್ಲ ಇಲ್ಲ ಇಲ್ಲಿ ಅಳಿಲ್ಲ ಇಲ್ಲಿ
ಬುಕ್ಸ್ ಎಲ್ಲ ಒಳ್ಳೆ ಚೆನ್ನಾಗಿ ಚಿಕ್ಕ ಅವೈಲಬಿಲಿಟಿಗೆ ಇಲ್ಲಿ 14 ಬುಕ್ಸ್ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ. ಅದು ಒಂದು ರೀತಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಒಂದು ಕೆಲಸ ಮಾಡೋದು ಕಮಾಂಡಿಂಗ್ ಪಾಯಿಂಟ್ ಪ್ಲೇಸ್
ಬರೋದಿಲ್ಲ ಹಿಂಗೆ ಬಂದು ಹೋಗಿದೆ ಸರ್ ಅದು ಐಎಗೆ ಇರ್ಬೇಕು ಹೇಳಿದ್ರೆ ಐಎ ಫಾಲೋ ಅಪ್ ಐಎ ಇದೆ ಅದು ಬೆಳಗ್ಗೆನೆ ಹೇಳಿದೆ ನಾವು ಐಎಗಿದೆ ಅಂತ ಐಎ ಅಂದ್ರೆ ಬಿ ಗ್ರೂಪ್ ಹೋಗುತ್ತೆ ಅಂತ ನೋಟಿಸ್ ಆಗಿದೆ ಅಂತ ಅದು ಐಎ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ ಹೇಳಿಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು ಅದನ್ನೇ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ನಾವೇ ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ನೋಡಿ ಅಂತ ಹೇಳಿದ್ದು ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಅಲ್ಲ ಅದು ಅದನ್ನ ನೋಡಿ ಕೊಟ್ಟಿದ್ದು ಅದನ್ನ ನೋಡಿದ ತಕ್ಷಣ ನಿಮ್ಗೆ ಅದನ್ನೇ ಹೇಳಿದ್ದೀನಿ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಲಿಸ್ಟ್ ಆಗ್ತಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ ಆಗಲ್ಲಮ್ಮ ವಿ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಸೇ ಅಂಡ್ ಪೋಸ್ಟ್ ನೀವು ಅಲ್ಲಿ ಕೇಳ್ಬೇಕು ಇದನ್ನ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗ್ತಾರ ಅಂತ ಕೇಳ್ಬೇಕು ನೋಡ್ಕೊಂಡು ಹಾಕ್ತಾರ ಅವ್ರಿಗೂ ಇರುತ್ತೆ ಬ್ರಾಂಚ್ ಕೇಳಿ ಅವ್ರು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತಾರ ಅಲ್ಲಿ ನಾವು ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ ಆಗಲ್ಲ ನೀವು ಯಾವ ಕೇಸಸ್ ನಾವು ವಿಲ್ ನಾಟ್ ಪೋಸ್ಟ್ ಬೈ ದಿ ಕೋರ್ಟ್ ವಿ ಓನ್ಲಿ ವಿಲ್ ಸೆಂಡ್ ಎ ಮೆಮೊ ಆಸ್ ಪರ್ ಅವರ್ ಡೈರೆಕ್ಷನ್ ವಿಲ್ ಸೆಂಡ್ ದಿ ಮೆಮೊ ಡೈರೆಕ್ಷನ್ ಮೂವ್ ಮಾಡಿ. ಮಾಡಿ.
ಇಲ್ಲಿ ಕೌಂಟರ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಾ?
ಇಲ್ಲೇ ಹಾಕ್ಬೇಕಂತ. ಐಎ ಕೌಂಟರ್ ಹಾಕ್ಬೇಕು. ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಹಾಕ್ಬೇಕು. ಹೌದು.
ನಾನೇ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು.
ಹಾಕಿದೀವಿ ಅಂತ ಒಂದು ಮೆಮೊ ಹಾಕ್ಬೇಕು.
ನಿನ್ನೆನೆ ಏನು ಹೇಳಿಲ್ಲ.
ಅದೇನಾ? ಅದು ಬೆಳಗ್ಗೆನೆ ಹೇಳ್ದೆ ನಾನು. ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು. ಮೆಮೊ ನೋಡ್ಬಿಟ್ಟು ತಕ್ಷಣ ಹೇಳ್ದೆ.
ಇರಲ್ಲ ಅದೇ.
ಹರೀಶ್ ಕುಮಾರ್.